Justices Landon Moore, Mary Beth Locklear, Mark Brooks, and Chief Justice Joshua D. Malcolm.
Please take your seats. We're going to take a few minutes to just get situated. My name is Joshua Malcolm. Need to let everybody know this, to my knowledge, if you could confirm, this is being broadcast live. Is that correct, Mr. Matt?
Yes, sir.
This is being broadcast live for the purpose of our tribal council, our tribal members. Today, we are convening in the matter of David Locklear versus Ron Oxendine. The voices up front and your voices today will be projected. We're going to go through some housekeeping things first, and then we'll proceed as we deem appropriate. At this time, I'll ask each member of the court to introduce themselves and which community they're from.
Mark Brooks, reside here in Pembroke.
Mary Beth Locklear, residing in Laurinburg.
Landon Everett Moore, Prospect Community.
Okay, so there's going to be quite a bit of housekeeping that we go over before we actually get to the substance of why we're here today. There will be times that we make inquiry of the parties, and we'll ask you, if you have counsel, to respond via your counsel. If it's multiple individuals and the individual, him or herself, wants to respond, that's fine as well. There will be times today that we ask the individual to respond. I want to make clear, this is not the North Carolina courts. This is not Superior Court in Robeson County. This is not the Supreme Court in Raleigh. This is the tribal court, the sovereign court. I want to make sure we're crystal clear about that. Those that are in attendance, those that are listening, and those that are watching. This is a sovereign. The Lumbee tribe has been a sovereign as it relates to its relationship with the state of North Carolina since 1885. And we will conduct ourselves in that manner. I'm Joshua Malcolm. I'm from the Pembroke community. We're going to address some preliminary matters, but before we get to some preliminary matters as it relates to the substance, there are some things that we're going to discuss related to decorum and how the proceedings will be addressed and handled today. As available on the tribe's website, there is what I'll refer to as a judicial code, which I assume the parties have read or referenced before or made reference to or read. It basically lays out the process by which this court typically hears cases and considers matters. As all the parties know, this case is untypical, and it's untypical because this relates to the eligibility for one of the tribal chairman candidates in an election, the election that's scheduled to be held on November 9th. When the petition was filed with the court right up front with its initial order, and there's been a series of orders that have been issued by the court, made a determination that time was of the essence for this matter to be addressed and resolved. Through making such a determination, there are things in the code that refer to timing, 5 days this, 3 days that, and I'm just using notional numbers and references. Those things sort of walked out the door somewhat, and we believe the court adequately put the parties on notice. We've done our best based on the time constraints and the ordinance structure, constitutional and ordinance structure, to get this within a process by which parties and interested parties were allowed and were informed as to what was occurring. Before we get into anything related to the actual filings of the petition, we're going to go through a series of questions. There is nothing particularly in the judicial code that talks about, nor does the tribal court have the equivalent of judicial standards. Judicial standards is a term that's very familiar with the council that are in this room because that's what exists under North Carolina law. In spite of that, and as is this court's practice, since I've been on the court, we make individual inquiry of the parties. For the purpose, and solely for the purpose of this inquiry, because there is an objection as to one of the parties, the interveners and respondents, as to their standing, but for the purpose of this series of questions, we're going to treat you as a party. So at this time, I'm going to ask on behalf of the court, in order, first inquiring of the petitioner, then the respondent, and then the Board of Elections interveners and respondents. Mr. Petitioner, do you have any concerns, objections, or any other issues you want to raise as it relates to the panel of 4 justices that are sitting before you today? If you do, and during this entire proceeding, would ask that you go to the podium if you have anything you want to share. Do you have anything you want to share, Mr. Locklear?
I say no from here.
You can?
And no, no, we don't.
Okay. As it relates to the respondent, Mr. Oxendine, obviously I see you at the table. Do you have counsel that's representing you this morning?
Yes.
Is he going to be speaking on behalf of you today, sir?
Yes.
If you would introduce yourself, sir, for the record.
Thank you, Chief Judge. My name is Walt Tippett, T-I-P-P-E-T-T, and I'm Mr. Oxendine's lawyer.
Mr. Tippett, is there any preliminary matters as it relates to the seating of this 4-person, 4 of 5 justices? The Constitution says that this court should be or has authorization for 5 justices to be seated. Do you have any concerns you want to raise related to the 4 justices that have been seated?
Yes, Your Honor, I do. And by habit, I will refer to your justices as honors, but if y'all prefer something else, I want to be respectful in however you prefer.
If you would step to the podium and go ahead with your concerns.
Thank you, sir. I also want to ensure that you can hear me clearly. I'm also pleased to wear a mask, whichever is your
You can remove your mask when you're at the podium. As each person approaches the podium, if you'll look to y'all's respective right. Matt, if you'll give them a thumbs up that they can be heard, or the Matt with the black cap, that's the most important guy in the room. Matt with the black cap, go ahead and give him a thumbs up. He's the one that can confirm that he can hear you. You can go ahead, Mr. Tippett.
Thank you, sir. We have 3 initial matters, and the first, Your Honor, has already addressed that this matter has proceeded under unusual urgency. We just have a standing objection and ask for the court's indulgence regarding certain evidentiary issues.
Okay, but before you get to that, and I know this is untypical, Mr. Tippett, and bear
Yes, sir.
with us. Right now, the sole thing that we want to hear is not related to the substance of any of the claims or any of the processes that this court has followed. If you have any objections related to the 4 people that are sitting up here up front, if you can limit your expression to that right now, and we'll move past that and we'll get to the other things later if that's okay.
Thank you for clarifying that. Yes, the second issue I have is a request by Mr. Oxendine for the Chief Justice to recuse himself, or if he declines to do so, that the judicial panel disqualify him. And if I may approach the bench, I will share a written document that has been provided to the clerk.
We're not going to take any documents that are handed up. You're more than welcome to orally express your concerns on behalf of Mr. Oxendine.
Thank you, Chief Justice. Then, Your Honor, and this is made with respect to you personally, but more especially to the court. Chief Justice Malcolm is the general counsel of an entity called Lumbee Tribe Enterprises. Chief Justice Malcolm's brother, Caleb Malcolm, is the Vice President of Operations of Lumbee Tribe Enterprises. I'll refer to that as LTE. Chief Justice Malcolm is also President of Lumbee Tribe Holdings. For clarity, the Lumbee Tribe of North Carolina owns 60% of LTE and 100% of Lumbee Tribe Holdings, which I'll refer to as LTH. In discovery in that matter, a person named Frida Porter.
Mr. Tippett.
Yes, sir.
Let me be crystal clear once again. You can raise any objection you have. If you want to make reference to the state rules of professional responsibility, if you want to make reference to the North Carolina judicial standards, you're more than welcome to argue that. What you're not going to do, unless you want to open the door, sir, which I don't think you do, and I'll let you and Mr. Oxendine, if you need to consult related to that.
Yes, sir.
I don't think it's your intention, correct me if I'm wrong, that you want this 4-justice panel today to consider matters related to active litigation in Robeson County Superior Court. Is that the desire of Mr. Oxendine?
Sir, if I may conclude, there is an overlap, and I promise you this will take just a couple of minutes.
Okay.
Because I'm unable to submit my document, I'm required to read.
You're not going to make reference. If you want to raise issues related to my integrity, my ability, in your Mr. Oxendine's opinion, to be unbiased, have at it, sir. You're more welcome to do. What you're not going to do, you're not going to besmirch other people in this courtroom today.
I would never do so, sir.
You're not going to speak negatively of other people in this courtroom today. You're not going to make inferences to them. You can make inferences to me because I stepped into the arena here at the Lumbee Tribe. I would appreciate if you would keep your comments directly on point as it relates to that.
And as your initial remark, this is an issue regarding conflicts of interest, and as this panel almost certainly knows, that issue is explicitly addressed in the Lumbee Tribe Constitution, Articles 11, Section 2, 9, Section 3C, 1, Section 1C, and Article 2, Section 6. And so, sir, if I may begin again, LTE has filed a lawsuit against Mr. Oxendine. And Chief Judge, this is why it's relevant. It's a conflict, just like I can't represent both Coca-Cola and Pepsi. In that lawsuit, LTE, for whom Chief Justice Malcolm serves as general counsel, alleged that Mr. Oxendine, quote, denigrated and criticized LTE leadership and policies during his campaign for tribal chairman. That is an allegation by LTE. The court concluded in a written order that is attached to the document that is submitted with the clerk that LTE's claims against Mr. Oxendine were motivated by LTE's leadership interest in preserving their jobs. Based on the foregoing, the issues of that litigation, which is led by Chief Justice Malcolm, are directly in conflict with the issue here today. In essence, Chief Justice Malcolm and his brother's employment by LTE and or LTH are at issue in both the Superior Court matter and in this matter today. Therefore, pursuant to the Lumbee Constitution, Articles 11, Section 2, and 9, Section 3C, Chief Justice Malcolm has a disqualifying conflict of interest. That is not to denigrate his character. I mean no insult. But under the Lumbee Constitution, because of his employment by concerned entities and conclusions of the Superior Court, it is a matter of record that he cannot participate in this proceeding. We therefore ask that Chief Judge Malcolm recuse himself, and if he declines to do so, we ask that this panel disqualify him. Otherwise, his personal interest in the outcome of this proceeding will taint the outcome. I encourage you to review the matter on file with the clerk for further detail, but that is the matter that I bring before you today.
Anything else, Mr. Tippett, related to that narrow issue about the four-judge panel?
No, Your Honor.
Thank you, sir. Yes, you may exit stage. I don't know what stage that would be, Mr. Tippett, right? Ms. Graham, do you have anything you want to raise with the court, ma'am, related to just a limited issue? We're treating you as a party just for this inquiry. I know you've made an objection to being a party.
Good morning, Your Honor. No, we do not.
Okay.
If Your Honor pleases, I'd like to have an opportunity to rebut some of the things that Mr. Tippett has said.
You can address the court, Mr. Locklear.
If Your Honor and the remaining other members of the court pleases, having served as a judge for a period of my life, I appreciate the concerns of both, of course, Mr. Oxendine, Mr. Tippett, as well as your honors. I would say this, just because one of the justices was involved in a separate case involving Mr. Oxendine does not conflict that justice out of this case. It simply does not. I guess the standard, if I might just read what's in front of me to you, it says the 20th century case law states a judge should be disqualified when a reasonable man, knowing all the circumstances, would have doubts about the judge's ability to rule in an impartial manner. So the issue is, would a reasonable person have questioned the ability of any of the four of you? Obviously the focus is on Chief Justice Malcolm at this point, to be impartial. I've heard nothing here today that suggests that you cannot be. Obviously, you will have to be the person to answer that. Again, having served as a judge, we tell jurors, and that's in effect what you are too, can you disregard what you might have heard outside of this courtroom? You know, that's one of the things we ask jurors, and make your minds up on what you hear inside this courtroom. And if you can, then you are not disqualified as a juror. Thank you.
So, for those listening, this is Chief Justice Joshua Malcolm speaking. All three parties have had an opportunity to be heard. Based on my recollection, Mr. Brooks, unless I'm confused, respondent Oxendine through counsel has raised an issue as it relates to myself, and I'll respond to that right now. I want to make sure some things are clear in the record. No disrespect to Mr. Tippett, but he misstated a few things, and we're going to clear those up right now. As some of you may know, I've served on the court since 2017. I've served as the chief since, I think, approximately 2018. The best of my recollection, I took over for the Honorable Matt Scott, and have had the pleasure to serve on this panel or court since then. Back in the spring of 2018, while I was working for my previous employer in the state of North Carolina, and I was asked to become outside counsel for an entity referred to as Lumbee Tribe Enterprises. Lumbee Tribe Enterprises is a for-profit company that is ultimately owned by the tribe. And I say ultimately because Mr. Tippett is correct. Lumbee Tribe Enterprises is owned 60% by Lumbee Tribe Holdings. The other 40% of Lumbee Tribe Enterprises is owned by 3 individuals, including Mr. Ron Oxendine, who owns 20%, and 2 other individuals, last name Fink and last name Long, that own 10%. After serving as outside counsel for some time, in the early last year, after the demise of an honorable man from the Fairmont community named Mr. Terry Hunt, I was requested by the board to come work for Lumbee Tribe Enterprises. As part of their request to me, they asked that I come to work for them full-time. And no disrespect to the board at the time, they didn't want to pay me full-time money. And I said, I'll come to work. But our relationship was, I worked for Lumbee Tribe in a 3/4 time capacity and continued in my private capacity as being a lawyer for a number of matters, including representing folks before the State Board of Elections and other administrative agencies throughout North Carolina, including serving as an appointed counsel in district and in DSS court for short fashion. Early last year, I was asked by the LTH board, and understand LTE, Lumbee Tribe Enterprises, has an independent 6-member board of directors that do not serve at the pleasure of anyone in this room. They do not serve at the pleasure of anyone next door in what I'll refer to, and all of us colloquially refer to, as the turtle. The 6 members of the board of directors for Lumbee Tribe Enterprises are appointed for 15-year terms. They cannot be removed by the chairman. They cannot be removed by the tribal council. They can only be removed by vote amongst themselves. Mr. Oxendine served as a 7th member of the Lumbee Tribe Enterprises Board of Directors, but he was a non-voting member. When I was hired by Lumbee Tribe Enterprises, I only would come to work for Lumbee Tribe Enterprises if I worked directly for the Board of Directors. I never worked for the president of LTE. I served for Lumbee Tribe Enterprises as their vice president, general counsel, and eventually their corporate secretary. At some time last year, Lumbee Tribe Holdings, the 4-member board, asked me if I would serve in an interim capacity, primarily for the purpose of starting 2 additional companies on behalf of the tribe. The Tribal Council Economic Development Committee had requested LTH take appropriate steps to start additional companies on behalf of the people, our tribal members. And LTH does not have any employees. I agreed to serve. I agreed to serve as the interim president and CEO without compensation. For 14 months, I served as the interim president and CEO without compensation for Lumbee Tribe Holdings. Effective July 1st of this year, the LTH Board of Directors hired me to be their inaugural and permanent president and CEO, and I became their permanent president and CEO unlike the representation made by Mr. Tippett. Among other responsibilities that I have as the president and CEO are compliance-related matters. Full stop. In 2019, Mr. Oxendine, Joshua Malcolm, being the sworn and having the foresight to believe that someone may have concerns, and having the foresight to know that it would be incumbent upon myself to make sure that I had not made a mistake in my self-evaluation, sought and received a written opinion letter from the North Carolina State Bar. That opinion letter, which is my opinion letter, opines on my capacity to serve and wear multiple hats. Recently, the North Carolina State Bar has opined again related to my capacity as the Chief Justice, as the President and CEO of Lumbee Tribe Holdings, and in particular, they've opined on this particular matter. As part of their evaluation as to my standing or my ability to hear this matter, there's a distinction between me disqualifying myself and me actually having a conflict. The tribal chairman of the 4 seats on Lumbee Tribe Holdings Board of Directors, 2 of those seats are held on what I'll refer to as the executive side of the branch of government. The tribal chairman and the tribal administrator. The other 2 seats are held by the tribal council, the speaker and the treasurer. As it relates to Mr. Oxendine in particular, whether he recognizes it or not, I do not know, but in the event that Mr. Oxendine is elected to become the tribal chairman of the Lumbee Tribe of North Carolina, he will not be eligible to sit on the Lumbee Tribe Holdings Board of Directors. If he were to become tribal chairman, not only would he not be eligible to sit, his tribal administrator would not be eligible to sit. That's not my decision. That's a decision of the Lumbee Tribe Holdings Board of Directors. As it relates to the litigation that Mr. Tippett opened the door on, I have never sued Ron Oxendine. I, Joshua Malcolm, am not in any litigation with Ron Oxendine. I am not, despite Mr. Tippett's perhaps misstatement, I am not the counsel of record in the matter of Lumbee Tribe Enterprises versus Ron Oxendine and Spencer Locklear, nor have I ever been the counsel of record. Lumbee Tribe Enterprises is represented by 2 competent counsel, one in Raleigh and one in Virginia. Based on those facts and the feedback that I received from the North Carolina State Bar, I took additional steps. Although I'm not bound by it, but because it makes the most common sense and would be what would be expected, in my opinion, by tribal members, I reviewed Canon 3 of the North Carolina Judicial Standards. I went through each of those questions in Canon 3, and unless there's a desire by Mr. Oxendine for me to go through each one of those, which I'm referring to as subparagraph disqualification 1A, B, C, D, I, in consultation with others, with outside review, have confirmed that even if I was a North Carolina judicial official, which I'm not, I would not violate any of the Canon 3 disqualification requirements. I want to make clear, and I want to look at Mr. Oxendine in the eye and make sure I'm crystal clear. Whether you have a personal opinion of me, Mr. Oxendine, or whether I have one of you, is not of my concern, sir. I've held myself out honorably during my life, and just like you, I've on numerous occasions put my hands on the Bible and sworn to defend the Constitution. When I was sworn in for this seat, I swore to defend the Constitution. That's what I've tried to do. That's what I've attempted to do. As most recently on this panel, no disrespect to our friends, the interveners, we held a hearing about 6 or 9 months ago. And despite assertions then, this panel made some decisions that didn't please some folks, and we had some concerns related to matters. I don't think, although I might be wrong, I don't think anyone questioned my integrity or my participation in that hearing at that time, although there were concerns raised at that time too, basically the same thing related to my relationship with the LTE and LTH. And for the folks that are listening that are not familiar, the role that LTE and LTH plays related to our tribal government is they really are a for-profit arm, and they ultimately deliver money to the tribal council to be used for our tribal members at the discretion and solely at the discretion of the tribal council. So in light of my review, personal reflection, in light of the counsel that I've received on at least 2 occasions from the North Carolina State Bar, in light of my review of the North Carolina judicial standards, in particular Canon 3, I will not disqualify myself from sitting on the panel today, and it is my intention to sit as one of the 4 justices. At this time, in line with the request that Mr. Tippett has made, I'll ask whether any of the other 3 justices want to make comment or want to ask or want to weigh in on the matter that Mr. Tippett has raised, or want to ask me questions about the due diligence process that I've attempted to follow to ensure that I don't have an actual conflict.
Brief comment, Mr. Chief Justice. Like Mr. Malcolm, our Chief Justice of this court, I too am a member of the bar, state of North Carolina, and one of the things that will touch each of the members of the bar that is in this room today is that our ability and our efforts to maintain freedom from conflict of interests is extremely important. It's probably one of the first things that we often try to do when we are involved in any type of litigation or legal matter. Our ability to maintain our ethical oath to our choice either when we're representing someone or we are hearing facts is probably one of the most integral and fundamental things that we can do as members of the state bar. I have heard Chief Justice Malcolm's response. I have heard, and if I were Chief Justice Malcolm, I would have certainly done the same thing by seeking an opinion from our state bar, because oftentimes it may be the case that we cannot see things fairly and impartially through our own eyes. And the best set of eyes that I believe that can answer this question is the Ethics Board at the North Carolina State Bar. I have trust and confidence in the North Carolina State Bar's Ethics Board as it relates to this. And I do not believe that and I will not speak for my 2 other justices, Ms. Locklear and Mr. Moore, but I do not believe that I'm in a position to argue or go against the ethics opinion that has been provided as it relates to Chief Justice Malcolm's ability to hear this case.
Judge Brooks, if your reliance is on that, can the court please provide those opinions from the bar?
No, I'm not. Those are my opinions. I'm not providing them to you right now, Mr. Tippett.
I only ask because apparently Judge Brooks will be relying on your description of those, and I would like for him to have the benefit of review of them, as well as the public. The tribe deserves to see them.
Okay. Mr. Tippett, anything else?
Well, I understand that you will not recuse yourself.
You don't have to repeat me, Mr. Tippett. I've already made that statement.
Has the motion been decided?
There is no motion. Mr. Tippett.
Sir, if you're willing to review the document, it is a request to recuse, and absent that, a motion to disqualify.
We did not accept your document. Maybe let me remind you, this morning, you first approached the dais. You said, I want to hand up documents. I said, we're not accepting any documents. You're more than welcome to verbalize those. You said, okay, you proceeded. That's where we are. We've gone through let me finish. We've gone through the inquiry. Are there any more comments from any of the justices?
No comments.
Yes, my comment is this. I served with Chief Justice Malcolm since 2017. We've heard multiple cases and had multiple hearings since then. And his integrity has never been questioned. I've never had any doubts. And in this matter, I don't see why anything should change from that. I have absolutely no issue, zero issue with Chief Justice Malcolm being on the panel today. Thank you.
We've concluded the inquiry as it relates to the issues that the respondent has made. This court is moving forward at this time. The next thing that we're going to address are the preliminary matters for the petitioner and the respondent and the interveners. There are a number of preliminary matters that we want to discuss, but at this time, although it probably goes without saying, I want to remind everyone that this panel clearly understands the implications related to this hearing. As Mr. Mack, can you confirm that the court's request for the petition to be placed online consistent with our past process has been done?
Yes, sir.
Can you confirm that the orders issued by the court have been placed online as requested by the court?
Yes, sir.
So for the listeners, what that means is that is as typical, and this is not anything untypical. The petition that was filed by Mr. David Locklear and any orders, which I think number 3, I think we've issued, this panel has issued 3 orders, has been placed on the tribe's website. And before we get to that point and we start talking about substantive issues, I just want to pause for a minute to make sure that we understand and reflect on why we're here today. We're here today because about 25 years ago, a group of individuals like Miss Louise, like Vera Malcolm, like Arlinda Locklear, and other distinguished elders in our community got together and said, we're going to self-determine our pathway forward. Up until that point, as you all know, listening, the tribe, for all practical purposes, have been represented by LRDA, which is a great organization. But there was a move about 2+ decades ago. Is that right, Miss Louise? About 25 years ago, some folks said, we want the representatives to more accurately reflect us. And actually, as a result, to the best of my recollection of a series of cases, actually one in particular in Wake County, the state court weighed in and said, hey, tribal members, you can establish your own government. As part of the establishment of that government, our people created a constitution, much like this country wrote its constitution many, many years ago. Our Constitution, as we know, is not perfect, and that's part of the reason we're gathered here today. And we're just like a floundering little country around the world that's trying to get its democratic principles put in place. But with that being in mind, as we carry out our responsibilities today, we all know this is going to be a highly charged emotional matter. And at least it's the desire of the panel that we stay respectful to each other to the extent, well, we are going to stay respectful to each other. We're not going to speak over each other. But we're going to try to carry out our responsibilities in a manner befitting of our positions and in a manner that reflects positively on us as folks are listening or may review this matter. And if you would, I'd ask that you lower your head and with your own respective, whatever God you worship, give yourself a moment of self-reflection before we start today's business. Thank you. So we're going to get moving. As Mark Brooks and I are the only two lawyers on this. The Constitution's set up where there should be three lay persons. We've discussed that actually amongst ourselves. We think that's purposeful because the folks that wrote the Constitution didn't want this thing to be too eagerly legalistic. And we'll proceed today. The North Carolina rules of evidence are not applicable and will not be applied today in today's hearing. We're going to basically apply the rules of what's fair and equitable, and we're going to try our best to comply with that. We're actually very pleased that all three parties have counsel, and that will remind us strongly, as lawyers do, of their position and their opinion, and we'll do our best to show the maximum flexibility possible to ensure that your respective party is not harmed, is not allowed to be heard, and they are given an opportunity for redress. Mr. Brooks, would you mind if taking over as it relates to any preliminary matters that have been filed by the parties?
I'd just like to reiterate what Chief Justice Malcolm has said about the significance of this petition. It is not lost on myself, Justice Locklear, Justice Moore, Justice Malcolm, what implications have been brought to our government as it relates to this petition. We have spent hours conferencing, discussing this, and I can say that I am persuaded and convinced that we are each concerned about this being a fair hearing, that this being a just hearing, and that this be a hearing where the right and the power and the ability of the Lumbee people to vote in an election is not tampered with, is not restricted, and that the right and the vote of the Lumbee people will not be disenfranchised. I believe it's the opinion of this court that the sovereignty of this tribe and the ability of the Lumbee people to be a self-determining people depends on the ability of the people to have a free election. I say all that to say that I will be listening intently today, as I believe that my co-justices will. One of the first things that we did upon receiving this petition is we tried to balance the due process of the petitioner, the respondent, the interveners, the elections board, with the reality that there is an election scheduled to take place in less than a month. That is not easy. If I must be candid, I don't believe that any of us were excited or thrilled about the timing of this petition. But when we were asked to serve on this bench, to serve on this court, we did so realizing that our government, as it was established 2 decades ago, not only established a constitution, but that was a constitution that established that there would be a judiciary. And we have the task of trying to ensure that fairness, that justice, that these are things that are pursued because it is the will of the Lumbee people that they are pursued. We afforded the parties and their counsel opportunities to submit motions, to submit briefs, to submit concerns, and we have considered each of those, I believe, thoroughly. I don't believe it's the opinion of this court that in the immediate moment that we will answer those motions or respond to those motions at the current moment, but they will be standing motions that this court will reserve ruling on as we go forward. I do believe that probably the single most significant query that has been made is whether or not this court has the authority to hear this case. I would submit to you that our founding fathers and mothers of this government, that they believed that a Supreme Court would be necessary for a time such as this, to be a final decider of law and disputes between the Lumbee people. And I would submit to the parties, to the petitioner, as well as to the respondent and the interveners, to try to imagine a scenario where there would not be a Supreme Court to decide on a matter such as this. There would be no oversight. There would be no decider of conflicts. And there would be no incentive or disincentive for persons to act in accordance with the Constitution of this tribe. The Constitution states clearly that the Supreme Court of the Lumbee tribe, and by the will of the Lumbee people, that this court has both original and appellate jurisdiction to hear all matters, cases, and controversies of the Lumbee court. As it relates to our Tribal Elections Board, which is a vital and an irreplaceable organ of our government, the service that they perform for this government in ensuring that there are free and that there are respectful in elections with full integrity is extremely important to this tribe and to our nation. It is an independent organ of this government. The Constitution declares it to be so. The Constitution also says that their actions, which although they may be final, that those actions are reviewable by this court. So at this time, I believe that this court is properly impaneled. I believe that we not only have the authority to hear this case, but I believe that it is our responsibility to hear this matter.
So as it relates to that, the court received a number of motions that were submitted by petitioner and what I'm still referring to as the interveners. To the best of my recollection in reviewing the file, there was a motion submitted by the petitioner, basically in short summary, saying that the election board intervener respondents should not be allowed to participate due to a lack of standing. Is that correct, Mr. Locklear?
Absolutely correct.
Okay.
If Your Honor, please, as a point of personal privilege, would you give me 1 minute to step to the men's room? I apologize.
Absolutely, if you need to. We'll pause for 1 minute. We'll actually probably pause for about 3 minutes for everyone. So if everybody needs to step up and stretch, please do so at this time. We'll stay seated up here, but we're going to pause for a couple minutes.
Why wouldn't you want to? Oh, but I can ask around. I can ask.
Yeah, I'll get you guys a bottle. There's a bottle in here, actually.
Where's it being streamed at, Josh? Where's it being streamed at? Go to the tribe's website. On the left-hand corner, it says live
A lot of people needed that break day.
Thank you, Gary. You did good, son.
Woo. I knew we was about to get into something that was gonna take some time. If I didn't go then, I'd have to stop in the middle of that, so I shouldn't have drunk. I had a big cup of coffee. I need to hush. I had a big cup of coffee and I shouldn't have had that. Had to go, wouldn't it? Josh.
Judge? Sir, how are you, sir? Trying to figure out if I need to.
Like we're never receiving.
Well, I tell you what, it's not encouraging so far. Judge? Walt Tippett, good to see you, sir. I think we have met in some context somewhere. I don't know what it is.
How you doing?
I live in Raleigh. I grew up in Fayetteville. And I'm down in Fayetteville a lot just for work. You're a lawyer by day, aren't you?
Do you remember Ray Brable?
You're in court today.
What's his mom? What's her?
I understand.
Yeah, that's you know that now.
I appreciate your commitment to service and your commitment to being fair. Yes, sir.
And watermelon.
Hey, how are you doing?
But I don't know.
And I didn't have anything planned here
Other
at
two, one of them,
noon or anything. It's 10 o'clock.
one of them's related.
Oh, I had my eyes on her back in the day. Never could make it happen. I think I might.
Well, that went about as smoothly as it could have went.
This one's. There's two of those girls.
What you want? It depends on. And you feeling Are you feeling country? You feeling Are you feeling trap music? You feeling gangsta?
Yeah.
Dallas last, weekend before last, and it was all
You're in the basement.
What?
Miss, these are some of the still getting them this morning. Purcell's is not in here.
This word there, motion.
Okay, we're going to get started at about a 1-minute warning.
You know, they shot each other in the grocery store there in town. Hendricks grocery store.
They just brought that to you.
Killed each other.
All the parties ready to proceed? Mr. Tippett, you ready to proceed, sir?
Yes, Your Honor.
Commissioner's ready.
Locklear? Mr. Locklear, you ready to proceed?
Yes, sir. Yes, sir.
Ms. Graham?
Yes.
Mr.
And thank you for the break.
Brooks, I'll defer to you, Mr. Brooks.
Chief Justice Malcolm just raised the particular point of contention that Mr. Locklear, you being the petitioner through your counsel, one of the motions that you filed was to, and correct me if I'm misrepresenting this, but to have the Elections Board, which we have treated as interveners in this matter, to have them removed as a party in this matter. Is that correct?
That's absolutely correct.
We've considered that. Certainly, we had considered that prior to treating the Elections Board as a party in this matter. And part of our responsibility, our duty to this tribe and to this court is that we consult the Constitution, and as I previously stated, our authority, which I would characterize as both constitutional and inherent, just the nature of the highest court of a government, that they have a reviewing authority. We have elected at this time, and as I stated previously also, I do believe that we would treat your motion as a standing motion. But as it relates to the article, I believe it's Article 10, with the Elections Board, that it states that they, being an independent actor of this government, that their decisions and that their certification, or certifications rather, are final decisions or final authority of the court. And the word "except" is not there, but I believe that any reader of that provision in the Constitution would conclude that that does not stop with them, that even though their decisions are final authority and that they are independent from every other branch of government, that those decisions, like the decisions of the tribal chair, like the decisions of the tribal council, are reviewable by the Supreme Court. For as simply as it can be stated, this matter is a petition on whether or not the respondent, Mr. Ron Oxendine, is properly certified to run in the November election as chairperson. That is a decision that the Board of Elections has, at least constructively, has decided that he has been certified to run in that tribal election. And we believe that at question in this hearing is whether or not that certification has been or has not been made constitutionally.
Opportunity to respond?
And while he's walking up, Mr. Tippett, during this process is when I think we're going to get to your you said you had a couple of things at the beginning. If they're preliminary matters, we'll get to you at the third step in this process after we hear from the intervener respondents.
Thank you, sir.
Having heard your comments, Justice Brooks, I'm not quite sure whether they're in or out, but I do know this. Their rules say that any matter that has been certified by them shall be deemed final and shall be reviewable by this court, and we're in agreement there. Regarding their intervention, they will tell you they don't want to be in this case. So that's the motion I got from them. They don't want to be. They didn't ask to be. They were forced into it, if you believe their documents. If they want out, my goodness alive, let's simplify this whole proceeding. Get them out. Take their table down when they leave. You know, if they're out, they're out. They can't have it both ways. They can't say, let us out, and then, oh, by the way, we want to be heard on a special matter. It doesn't work. You don't get two bites. What's the term from the Westerns? You know, when one person was accused of speaking with a forked tongue. You don't get that benefit here in the court. So, I mean, to that extent, they want out, and I've got any number of reasons why they ought not be in, and I'll be glad to share them with you if you want to hear them now or hear them after they make their motion, whichever.
I think we'll hear them after, if that's okay. We'll hear them after, Judge.
Thank you.
Judge Locklear. Ms. Graham, could we hear from you all now, please, ma'am? As it relates to this preliminary matter, I know you know that, but just for the listeners.
Well, Your Honor, the court just changed the entire petition. The issue with us not being an intervener is the petition itself never made any allegations against the Board of Elections. It never appealed the certification of Ron Jones.
Say that again, Ms.
The
Crispin.
petition that's filed before the court never appealed the certification of Ron Jones.
Okay.
It never alleged that the Board of Elections failed to follow any laws or breached any rules or made the wrong decision, which would be a standard of review. Our problem is not with the court. Our problem is with the petition. If the court today changes the petition, the court changes our response, because we can only respond to the petition that we had. If you read the petition word for word, it never mentions appellate review. It never mentions we appeal the decision of the Board of Elections. It never mentions on September 5th, 2019, Ron Jones was certified by the Board of Elections. It never mentions that the Board of Elections got it wrong because of residency. If that was the case, we would have filed a motion to intervene. We would have told the court, wait a minute, court, we're a party to that. That's not what the petition says. If the court's changing the petition, the court's changing the rules, the court's changing the law, the court's changing our response. We were asked to respond to his petition. We're not here to argue with the court about what the court can and can't do. We're here to tell you his petition can't stand as written in this court. That's what we're here to say. We need an opportunity to say that because what you do affects our policies and our procedures. Now, if you're going to change his petition today, we want to intervene. We need to be heard because that's not what you asked us to do. We got a CC email that said, if you have any interest in this case, respond. We responded to a petition that asked the court, pursuant to original jurisdiction, to decide the issue of Ron Oxendine's residency, not appeal the decision of the Board of Elections for the purpose of certification of Ron Oxendine on September 5th, 2021. That is a different case altogether, and that is not why we're here today.
Sure. If I could, Ms. Graham, and for everybody for the record, so can you respond to the letter that you wrote on behalf of your client, which you addressed to the court, 5th line down? I'm quoting a letter under your signature that says, quote, "The ordinance authorizes the policies that were applied in the case law and define residency. This is the standard for which the Supreme Court must." You didn't say shall, you didn't say may, you didn't say can, you didn't say if you want to. The Board of Elections told the Supreme Court, quote, "This is the standard for which the Supreme Court must uphold as the law. The Supreme Court lacks any authority over the Independent Board of Elections, as it is not a party to any action, as you've recently said, to any action to prohibit any action authorized by statute to stop the issuance of ballots." So when you said a few minutes ago the Board of Elections didn't tell the Supreme Court what to do, in fact, you did. You told the court that there was, quote, case law, which we want you to point out to us, which was not attached to the approximate 12 pages that we received. And then 2, if the Board of Elections wouldn't mind telling us the basis by which the Board of Elections tells the court what it must do. If you would start with the case law.
The case law that should have been attached was Beck versus McNeil.
So make sure we're clear, case law comes from a court. So are there any court decisions, this court, not an administrative decision by an independent Board of Elections, which is not a court of law?
Well, Your Honor, we would argue that it is a quasi-judicial body that until any matters are appealed or any of their laws are set aside, that the Constitution gives them the right to promulgate, pursuant to Article 10, 1A, necessary and appropriate regulations, which are rules and laws, that this court must uphold unless those rules are set aside or those rules are vacated by this court. So
Yes.
that is case law that until the court either appeals or hears or sets aside or the tribal council decides is not valid law and comes back and redacts or voids, it is good law.
Okay.
Because the Constitution authorizes them to promulgate the regulations, which are rules, which are the laws.
Okay, so we'll go ahead. So the court discussed that in conference. Just to be clear for the record, the court has decided that is not in fact law. Those are administrative determinations that were made by the Board of Elections, and that's how we viewed it. Can you move on to, and maybe that answers it, can you move on to the part where you said the court must uphold the law? I assume you're really saying we must follow the prior administrative determinations made by the Board of Elections? Is that your?
If the Constitution authorizes the ordinance to be enacted by the tribal council Tribal Council enacted ordinance to allow the Board of Election to promulgate rules and regulations and policies. Those rules and policies have not been set aside, stricken, they've not been vacated, they've not before the judges to be heard, to be struck down. They are valid tribal law.
So is it your contention that this court today does not have the statutory basis to opine on the policies that have been prepared by your client?
They very well could if those policies are before this court to be reviewed, because this court has a appellate review of any and all decisions that come before it. It also has original jurisdiction to hear any and all ordinance and case law, but guess what? It has to come before the court. The court can't wake up one morning and decide I have inherent authority to strike down laws. If it doesn't come in the petition, it can't come before the court. The court doesn't have inherent authority to just make case law from the bench when it isn't in the petition for the courts to decide. There is nothing in that petition that challenges any rule, any law, any procedures, any case law from the Board of Elections. The court's not being asked to do that.
Sure. Do you agree, without referring to it specifically, that petitioner has pled that there's an issue about the principal primary place of residence, yes or no?
By way of the definition of the Constitution, he has, for original jurisdiction.
Do you agree that the principal place of residence, that phrase, is found in the Constitution?
We do.
Do you agree that the Supreme Court has original jurisdiction over matters that are found in the Constitution?
It depends. If you go to the judiciary section, there is a limit.
Okay, I'm looking at so which article of you're referring to the Constitution, ma'am?
I am.
Okay.
Inferior courts, Article 9, Section 1. Inferior courts, only appellate jurisdiction. We are an administrative court. We are quasi-jurisdiction. Once we took action and certified Ron Oxendine, the only action that can be taken by this court is that of appellate jurisdiction. If you read petitioner's brief, you will find that he stipulates that this is appellate review. The word only prohibits this court from having original jurisdiction the moment the Board of Elections certified Ron Oxendine. From the time he posted his first sign, to the time he filed his application, to the day before the Board of Elections certified Ron Oxendine, the petitioner could have filed this petition with this court and asked for this relief.
Sure.
The moment the Board of Elections certified him, it became only possible for this court in the process of appellate review based upon Article 9, Section 1.
Okay, I just want to make sure maybe I misheard you. Are you saying Article 9, Section 1, line 6, which starts with the beginning of a sentence that says in the event the tribal council establishes inferior courts, the Supreme Court of the Lumbee Constitution shall have appellate jurisdiction only over those cases and controversies arising under tribal ordinance. I want to make sure, I think I heard what you said. Did you say that you believe the Board of Elections is an inferior court?
I do. They're quasi-judicial. They're having hearings. They're issuing orders. They're making decisions. Those decisions are appealable to this court. If you go over a page to the Board of Elections.
Which article, ma'am?
Article 10, any matter decided, a decisions we have hearings, we issue orders, shall be deemed final tribal action and reviewable by the Supreme Court of the Lumbee Constitution. We are probably the only administrative court issuing orders and hearings that are appealable to the Supreme Court.
Well, that's what was my next question. So if you wouldn't mind just answering that on the record. Are there other inferior courts? We know we exist. We know there's a tribal administrative court, which we agree that exists, correct? There's a tribal administrative court.
Your Honor, we would state that any administrative court created by ordinance, created to hear matters, that enter orders, enter decisions, that once those parties act, the only matters that can be heard by the Supreme Court are only those that are appealable.
Sure. What other administrative courts are you saying exist within the Lumbee tribal government?
Your Honor, you just indicated there's the tribal administrative.
Yeah, we're familiar with one tribal administrative court. You've told us today that the Board of Elections is one. Are there any others?
I would leave it at the pleasure of the court. I have no idea. All I'm concerned about is the Board of Election. It is a quasi-judicial court having hearings, issuing orders.
Well, we've considered that, so just to close the door on that, this court has considered that. The Tribal Elections Board, this will be in whatever version of the order that comes out of this panel or this decision today, is not an administrative court. It is not an it's not a judicial court. It is not an inferior court. It's an administrative arm of the tribal government. It does not issue case law. It issues administrative determinations. That's the way we've discussed it in conference, and that's the way we're going to treat it today. I think in our earlier discussion, so to be clear for the record, it's the Tribal Elections Board's position that the Supreme Court must follow the decisions that have been made by the Tribal Elections Board, and those decisions in those administrative matters cannot be reviewed today, cannot be subject to court order, and are not within our realm. When you use the word must follow, that's what you were trying to relay to us. Is that correct?
Yeah, let me go back to just the one for appellate. Under Article 10, again, under Section 3, any matter decided or certified, again, Ron Oxendine was certified by the tribal election, shall be deemed final action and shall be reviewable by the Supreme Court. Again, that leads its term to be that this court sits in review of the actions that took place. So that would again lead me to believe that this is appellate jurisdiction over the action of the Board of Elections. If the court, again, amends the petition of the petitioner to consider it a review of the certification of Ron Oxendine. Now, as to the case law, here's our argument with that. Because the petitioner does not have or has not made any allegations regarding any rules, any laws to be applied, or any failure of the board to follow rules, regulations, or indicates that their rules, procedures, or have violated the Constitution in any way, or any ordinances, or ask the court to review any case law and find that it does. The court can only review what's in front of it. And the only thing that the petitioner has asked is for the court to decide the issue of residence. And based upon that, we would say again that the case law established by the administrative court, even though the court's already established it, they disagree. We believe the Constitution allows the tribal council to establish ordinances to create the Board of Elections, and that ordinance allowed the Board of Election to promulgate law, rules, and policies.
So I want to make sure I'm clear. It's the Board of Elections' opinion that the tribal council has given the Board of Elections the authority to create tribal law. That's what you just stated. Is that correct?
That is not what I'm saying. They're giving them authority to create policies and procedures. And those policies and procedures have not been challenged. They've not been set aside. They're not being challenged today. As such, we have case law. Again, it may only be administrative case law, but that administrative case law has not been challenged. It has not been set aside. And here's the issue with it, with the Board of Elections. If we have administrative case law that we follow, and you are not reviewing, because this again is not an appeal, because there's nothing in the petition that tells us we're being appealed, and the court's considering, oh, well, we're going to look and see what you did anyway, then we're not put on notice. We're not put on any type of notice that we're here today defending any of our actions, because the petitioner didn't give us any notice until the court said right there, we're reviewing the certification of Ron Oxendine. Board of Elections had no idea that this was an appeal, or the court was going to treat it like an appeal.
If I can make a few remarks,
Go to the order.
Justice Malcolm. Ms. Graham, as you refer to Article 9 of the Constitution as it relates to the judiciary, when it says that the judicial power, under number 1, the judicial power of the Lumbee tribe of North Carolina shall reside in the Supreme Court of the Lumbee Constitution and such inferior courts as the tribal council may establish. Is it your position that the elections board and whatever, as you describe it, administrative court that exists within the elections board, is it your position that that is established by the tribal council?
Yes, it is established with the elections ordinance to allow them to promulgate their own policies and procedures, and one of those policies and procedures is hearings, and from those hearings they promulgate case law.
Where would you say that what ordinance exists that establishes an inferior court with the elections board? Because I will say that from my perspective, in my opinion, as an interpreter of this Constitution, that the elections board is an entity that is established by the Constitution.
It is.
And I believe that it would be a slight to the elections board to suggest that they are established by tribal council.
And, Your Honor, we're not suggesting that the elections board is created by the tribal council. We're not. We're simply rereading what's in Article 10.
But you would agree that according to Article 9, Section 1, that inferior courts must be established by the tribal council.
And again, the tribal council has the election ordinance, and the election ordinance allows the Board of Election to promulgate its own rules and regulations, as well as the Constitution. The Constitution allows it, as well as the elections ordinance allows it. So again, that is some dual power that's working there. But again, you have to respect the authority that they are having hearings, whether you consider them administrative, and the court's already ruled. The court's made the decision and announced it that we do not consider you an inferior court. Fine. Consider us an administrative court where we still issue case law that can be reviewed based on the Constitution. But at this junction, none of our case law is being reviewed.
Is it your position also that that sixth line in Article 9, Section 1 that says, in the event of the tribal council establishes inferior courts, which we've decided that the tribal elections board is not an inferior court established by the tribal council, the Supreme Court of the Lumbee Constitution shall have appellate jurisdiction only over those cases? Is it your position that that clause in that section of the Constitution restricts which cases the Supreme Court can have original jurisdiction over?
Well, Your Honor, the court's already told me it's ruled. It's already told me it ruled that we are not an inferior court, that you've already took it under consideration, you read my argument in my brief, and you disagreed with me. Now I'm asking you to reconsider. If you disagree we're an inferior court, I'm asking you to reconsider that we're an administrative court. Based on your disagreement, you've ruled that we're an administrative court with case law and with rules, with procedures that establish the case law. That case law is well established in history, that is currently standing and available to the courts. That the court can take judicial recognition of that case law. That this petition before the court today does not challenge any case law of the Board of Elections or any rules, regulations, or procedures of the Board of Elections. Based on its face, Now, if this court does that on its own inherent authority, we're without due process notice. Because again, the court can only hear what's in front of it to be heard. The only thing the petitioner asked the court to do was decide residency pursuant to the Constitution. And again, the petitioner's own brief acknowledges that this is an action of review, of appellate review. So at some point, this court has to decide, or the petitioner has to pick one and decide, because we can't answer, because that's not what the petition said. And now that's not what the court's saying. So we can't form our argument to tell you if we're in or out until the petitioner picks a side, and whether it's original jurisdiction or appellate, and whether the court picks a side, or whether it's hearing the petitioner's petition or the amended petition that the court just announced that it was going to hear.
I believe the court respects your argument, Ms. Graham, but I would say that with all due respect to your argument, that even if this court were to conclude that the elections board, as one of the responsibilities of the elections board is to act as an administrative court, that this court does not have the authority under the Constitution to treat the actions of that lower court as case law. The Constitution says that we have original jurisdiction and appellate jurisdiction over all cases and controversies that arise under the Constitution.
And our defense would be that based upon the brief of the petitioner and the statements of the court, that this is not, in fact, an issue arising out of the Constitution as alleged in the petition. That the reality of this is, and again, it's not the court's fault, it's the petitioner's fault for not correcting his petition or filing it appropriately, that it is, in fact, on Article 10, Section 3. Any matter decided or certified by the Tribal Elections Board shall be deemed final tribal action and shall be reviewable by the Supreme Court of the Lumbee Constitution. The Chief Judge got it right. The real action here to be heard today is the certification by the Board of Elections of Mr. Ron Oxendine. That's the real issue. It's not really about residency or not residency, but that's not what the petition said. And if that's what the court's here to do today, the Board of Elections doesn't have due process notice. And that's what our motion to dismiss is about. That's what our argument about motion to intervene is about. That's what our argument about personal jurisdiction is. We got notice as a CC copy that there was something going on as a courtesy. In reality, what this board does here today affects the Board of Elections rules, regulations, procedures, and case law. But they're not even a party to the action. Furthermore, the remedy that the petitioner seeks is not really the remedy he asked for in his petition at all. He asked for a remedy that says, Judge, I want you to find that he's not a resident. That doesn't solve the problem. This court would have to order the Board of Elections to buy new ballots, to strike his name from those ballots. And again, we're not a party to the lawsuit.
We're in the preliminary discussion.
But again, Judge, that's the preliminary discussion. The real remedy, Mr. Ron Oxendine couldn't give the plaintiff. Mr. Ron Oxendine couldn't decertify himself. And that's the real remedy that Mr. Locklear really is asking for, is against the Board of Elections. And his petition just didn't say what it needed to say. And that's what our motion to dismiss. That's why we're not a proper party. We didn't get served correctly. That's our motion for intervention. It all comes back to the same thing, to petition. It's not the court's fault.
So just so we're clear on a couple of things and for everybody to make sure we're level set. So at the beginning, we got a petition from Locklear against Oxendine. This court conferenced and made a decision, a clear decision, as is set forth in all of our orders in one way or another, or set forth by the direction that this court gave to Matt Roller. Matt Roller is the equivalent, hold up your arm, Matt is the closest we have to a court support person This court does not have somebody working for us. There's nobody sitting over there waiting for us, ask him or her what to do. It's us. So we directed Matt to notify what we phrased as all interested parties. And so for everyone to understand that, there was an initial notice that went out by the court that asked a series of 3 questions. And that notice that went out to the court, to the named parties, Locklear and Oxendine, and to the interested parties, asked all of them to respond to a number of questions about basically how should the court proceed on a number of things. It was at that moment and during that process that the tribal election board was part, and we determined was an interested party because this dealt with an election matter. In addition, and so everyone else understands, the other interested parties were anyone's name who was on the ballot. So anyone's name who was on the ballot got a notification from this court, the initial order, saying, we are requesting your feedback as it relates to a number of matters. So I want to just make sure that everyone understands, and for the parties to understand, because you're not understanding the machinations behind a curtain. We sent that out and made a determination in conference that all the direct parties and interested parties, it was as a result of that, Ms. Graham, when we got this very long response from the Board of Elections, which of course, and no disrespect to anyone, caught the tribal court's attention when the Tribal Elections Board told the court what it must do and that what it could not have any authority to do, which basically, the way it was interpreted by the court is that we had no choice other than to follow the decisions that had been made. We don't have to dispute it anymore. Decisions that have been made through the administrative processes of the Board of Elections. And I think what Mr. Brooks is saying, and I'll ask Mr. Moore, one of the administrative determinations that the Board of Elections made, whether it was through process, it was through process, through whatever process, was that Ron Oxendine's name was placed on the ballot. Would you agree with that?
Yes, he was certified to run and placed
And he was certified by the Board of Elections. We admit, we're on the receiving, we're not trying to say, hey, go file this petition. We got the petition just like everyone else did. The fact that he was placed on the ballot, just to be clear to your client, is the reason that when the response came from the Board of Election, we basically said, okay, you're exactly right. We're going to hear you. We're going to give you a place at the table because we believe that you do have an interest in what takes place today, a very important interest, which is why this court ordered, and I want to ask now, which is why this court ordered that the Board of Elections stop sending out absentee ballots on Friday and that the chairperson of the board prepare a log as it relates to any and all actions she took from the time that order was delivered to you, her counsel. So can you confirm for the court that that process did stop and that the log was prepared and that you guys dropped it over with Mr. Matt this morning?
Yes, he has it. He had it this morning.
So I think that's very important, and we really appreciate that.
And again, I don't know exactly what time we received the courtesy copy of the petition, but prior to that, we received the email from the courts when, again, we didn't know there was a petition that asked for the explanation about the absentee ballots. So we were not party to a lawsuit, but we were getting orders from a court, and we didn't know there was a petition filed.
Sure.
And again, that went to jurisdiction because, again, we hadn't been served, we weren't duly noticed,
Sure.
but we had an order from a judge to produce, and we did produce out of respect to the court. Certainly we're going to comply with the court, and we did again today.
Just so we can put that to bed, did your client then, or do you want to express an objection now to the court directing that the Board of Elections inform the court as to what was happening in the election process? Was there a problem with us directing that we needed to receive something so we can understand what was happening with the issuance of these ballots?
Your Honor, the only problem we have is a due process objection. And it comes from the theory of inherent jurisdiction. And that goes back to the Constitution with the idea of separation of powers. Because again, you are the Supreme Court and you do have that inherent authority. But the separation of powers does limit that authority. And again, our argument would be, before the court can order parties, members, tribal agencies, tribal organizations, that there should be some type of due process. You have to be noticed. You have to be made a party to an action. That the court can't just wake up inherently one morning and order the Board of Elections to do something.
Sure.
Because if you do, you violate the separation.
So just for
Of
clear,
powers.
I don't disagree with that, I don't disagree with that, Ms. Graham, but I want to be clear because you've made reference to that a couple of times. And I want to ask you and your client clearly. It's not the assertion by the Board of Elections that the tribal court just woke up last week and decided that it was going to pen an order to the Board of Elections, is it?
No, Your Honor, and we knew when we got this order that something was going on.
Sure.
We just didn't get any due process notice that what it was. But
Sure.
certainly, out of respect for the court, we did exactly what the court ordered.
Okay, thank you. Mr. Moore, Ms. Locklear, do you have any questions? Mr. Brooks, I'll ask you to wrap that up and we'll move on to Mr. Tippett.
I believe that's all, Ms. Graham, unless you have something else that you want to add to the court. I believe we have ruled on that issue. Mr. Tippett,
I'm sorry, sir, I couldn't hear you.
you can go to the podium.
If you had some preliminary matters, we're
preliminary.
still in the preliminary phase, Mr. Tippett. I know this is different than what you're used to, but we're still not in the substantive case yet.
Sure, and if I-
Petitioner filed a motion. They wanted to be heard. They basically let us know. And I know this morning, you walked in and you said you had three things, and what we said, or I said on behalf of the court, and we decided in conference we were not going to set. So did you have a preliminary objection, dismissal motion, or anything like that before we get into the substance that you want to express on behalf of Mr. Oxendine?
Thank you, sir. And I do not mean to take anything out of order, but here are the issues, and I'll just lay them out, and you can tell me now, later, whatever. First, to the extent you're soliciting my thoughts on their motion, I agree. I think it centers on due process. I cannot do a better argument than counsel has provided, but I think there's a due process issue. That's related to the two things that I have of the three. The first was the motion to recuse/disqualify. The second is, in general, the expediency with which this has proceeded has had two impacts. First, I don't think it's either procedural due process. I just don't think we are able to act as quickly as the court has required. That's a real problem. We just have an objection to how this is rolled. I've literally been unable to do things that I would like to do to help my client, or that Mr. Oxendine would like to do to help himself. The second issue is evidentiary issues. When you get to the substance of it, I have read very carefully the 7 pages of the Code of Judicial Procedure here, and there are just necessarily gaps, just because it's short. I understand. And I would like to, at some point, address issues related to those so that I can best know how to proceed within the hearing when it proceeds. And if now is the time, I'm pleased to discuss those now. If that is a later moment for this court, I will defer to a later time.
I think we'll talk about those matters later, Mr. Tippett, if this court gets to that point where we move from these preliminary matters over. And just to be clear, it's right now where we stand is we have standing and as Mr. Brooks phrased it, continuous motions that we've decided from petitioner and what we'll still refer to as the intervener respondents, that those are standing motions to dismiss or for us to take different action, but we're going to proceed at this time. As to the evidentiary things, I think it may be best that you raise those when we get to those points. And we acknowledge up front to all the parties, and to be clear, I mean, we're on the receiving end of this thing. There is nothing, and we'll talk about, I'll say this in general. This is not the court deciding anything. The court has taken, as y'all saw in our order last night, the court has taken a tremendous amount of time in reviewing, constantly reviewing the Constitution, the ordinance, or ordinances, plural, to my knowledge. There's only one. Maybe y'all are going to tell us there's 4 that we just haven't looked at. And that's it, full stop. There's one election ordinance that's been issued. And so in light of that, as you know, is what is pushing this thing along. The court did, and I want to make it clear to all the parties concerned, it's been a finding, conclusion, whatever you want to refer to it. The court has determined that time is the essence. The court has determined that unless something miraculous happens, we do not intend to direct the Board of Elections to impair this election happening on November 9th. It would be very easy for this court, with some inherent authority, which I imagine, I know what Ms. Graham and her client would say, that we order that the election is going to take place instead on the 9th of November, it's going to take place on the 15th of December when all the kids get out for Christmas. We are not going to do that. Unless something comes out in this hearing today, we have no intention of affecting the timing of the election because there's so many processes that Ms. Luis, the chair of that board, Dr. Clark, who I know personally well, and the other members of that staff have put together. It's not our intention to try to break anything. Now, by doing that, does that mean that the parties are going to have to work on weekends and receive emails from Matt on a Saturday night saying submit something by 10 p.m. on Monday? Absolutely. And that's what we did, and that's where we are. So if there's nothing else, I think what we'll do now is we're going to move into the next phase unless there's something else you have, Mr. Tippett, in particular related to that, sir.
Sir, I think you've been responsive, but let me repeat back. I have a procedural due process issue and then evidentiary issues, which you're going to address later. And I guess...
Well, the procedural, go ahead. What's your procedural? So the evidentiary things you said it was missing from I think you referred to it, the 7-page of the judicial codes. What are your I thought what you said, and correct me if I'm wrong, please, that you agreed with Ms. Graham's argument and you couldn't add anything to that to make it better, correct?
The things that she said, I agree with, but also that's sort of narrowly addressed to the Board of Elections. Differently, in regard to Mr. Oxendine, this court has proceeded in a way that even if it has jurisdiction, see her remarks, I'm not sure that it does. Even if it does have jurisdiction, it cannot proceed in the manner that it has without impairing procedural due process as I understand, y'all rely on federal common law.
Okay. We'll hear those now. Go ahead.
Sure. The manners in which you have usurped, that may be the wrong tone, but the way you have denied my client the benefit of the process that he followed under what seems to be the clear election requirements without a method by which to challenge them, i.e. the appeal, impairs Mr. Oxendine's ability to rely on his Lumbee constitutional rights. To be clear, and I respect very much that you people are extraordinarily more experienced in Lumbee constitutional law, but in terms of law in general, it's a parallel tract. Some of our arguments are the same, others build on that. But because he played within that structure of the Lumbee election process, he is entitled to rely on that benefit. And this feels like a second bite at the apple by an interested citizen, the petitioner, Mr. Locklear, when he should have intervened far earlier under the rules. He intervened into the election process. And I happen to think the Supreme Court cannot proceed in this way in regard to Mr. Oxendine.
Can you be more particular? Can you tell us where in the election ordinance or where in the Constitution in particular that it says the election board is violating some, what you refer to, and I'm paraphrasing, some constitutional rights that Mr. Oxendine has as it relates to us expediting this process?
Yes, sir. And it's over there, but this is close enough to her argument that this may be sufficient, otherwise I'll walk over. Because the Constitution expressly contemplates that the Board of Elections shall have the right to issue ordinances.
Show that to me.
Sir, I'm in Article 10 of the Constitution titled Election Board. Paragraph 1 reads, "There shall be an independent tribal elections board of the Lumbee tribe of North Carolina, which shall have the following authority. Parens A, to promulgate necessary and appropriate regulations under authority of this Constitution and tribal ordinances governing voter registration and the conduct of all regular and special tribal elections." Ms. Graham has cited this authority in regard to her client, and I'm saying that Mr. Oxendine, as a member of the tribe, similarly has the right to rely on this authority.
Sure. Before you step to the table, unless you want me to get it played back, you said the Tribal Elections Board has the authority to create ordinances. Did you misspeak, or is that still your position?
And if you're referring to how I said regulations,
No, sir, I'm referring to the comments that you made before you stepped to the table. You said the Tribal Elections Board has the authority to create ordinances. Is that your position?
my position is Article 10(1) sub A. It has the authority to promulgate necessary and appropriate regulations to conduct regular and special tribal elections. So if my paraphrasing was inconsistent with this paragraph, it was unintentional, and I certainly didn't mean to mislead the court.
So I want to be clear. You do agree that the authority of the Tribal Elections Board is limited to creating regulations, yes or no?
I believe it is what is in Article 10 of the Constitution. Whatever
that
all
yes?
says. No, that's not a yes. It's this. I'm not going to allow you to.
Let me ask you, does the election board have the authority to issue and create ordinances?
No, sir. I guess. No.
Yeah, so the reason that, I assume the reason that's germane to us is because what this court is required to do in accordance to and in accordance with, and I'll just refer to, if I could, the order, if I have them in order, the order that was signed by Miss Mary Beth Locklear on behalf of the court just last evening, where the court cites in particular, and with clarity, we thought, excuse me, in the order that was issued last night, and the order, as y'all noticed from our process, that has footmark 10/13/2021 at 18:15, the court under its orders under number 5, I'll read that unless you have it. Do you have that, Mr. Tippett?
It is among my materials, but I'm sure you'll read it correctly.
The court has taken judicial notice, paragraph 5, I was reading from 6. The court has considered in conference thoroughly the phrase in Article 9 to, quote, shall be the will of the Lumbee people as expressed in the Constitution, duly adopt tribal ordinances and Lumbee custom. In the absence of a governing rule of law from these sources, the governing rule shall be federal common law. So is it your position, I want to be clear, because you said you agreed with the Board of Elections, if I heard your initial comments correctly. Do you believe that the Board of Elections, at Mr. Oxendine's position, that the rules, processes, policies, whatever you want to refer to it, I think they call it policies, that's founded in, that's in the Constitution or in duly adopted tribal ordinances?
I believe that Article 10 creates power that this court is required to respect or correct through an appellate procedure.
Through a what, I'm sorry, the last part? Through what?
Through an appellate procedure.
Okay.
That 10, if they got it wrong in 10, this panel can fix it through an appeal.
If I can just make a few remarks, Mr. Tippett.
Yes, sir.
It is my opinion that really what this boils down to is you mentioned Article 10, and I think it was at Section 1.
Section 1, subsection A.
Really what this comes down to is the definition of promulgation. What does it mean for the Elections Board to promulgate? I believe it's the opinion of you and on behalf of Mr. Oxendine, and I think it would probably be the opinion of the Elections Board, that word promulgate really means to legislate or to create law. For the court to come to that conclusion, the court would have to believe that the Constitution or by tribal ordinance, that the Elections Board has been entrusted with the authority to make law, to create law. And I would submit, and it is my opinion, that the word promulgate does not mean to legislate or to make law, because Article 7 specifically says that the legislative authority of the Lumbee tribe is with the tribal council. And if you refer to the elections ordinance, which to my knowledge is the only elections ordinance that we have, 2005-002, specifically, and it may be the fourth whereas, but it says that all legislative authority rests with the tribal council. Now I say all that to say that this court has a responsibility to interpret Article 10, Section 1, subsection A, the word promulgate, in light of the fact that both the Constitution and Tribal Ordinance 2005-002 establishes that legislation authority or lawmaking authority rests with the tribal council. So it's my opinion that as we look at that word promulgate, it means something other than what you were saying that it means or suggesting that it means. I believe it's the opinion of this court in our discussions that it is the responsibility of the Elections Board to put into effect, to carry out the laws and the regulations and the rules that are established by the tribal council as it relates to elections. The Tribal Ordinance 2005-002, can you show me in that tribal ordinance where an authority is vested with the Elections Board by the tribal council, an authority to make laws or to make rules or to make regulations?
No, sir. My contention is that Article 10 of the Constitution controls, and that if the election board makes a mistake, it gets fixed through an appeal. That's my argument.
And I assume you're saying this is not an appeal.
Correct. I don't know where it fits. It's
Sure.
kind of like her point. It's neither. I don't know what this is. It's not an appeal.
Okay. You've read our Constitution.
Most of it.
Do you need a few minutes?
No.
Okay. You read the part about the original jurisdiction.
Absolutely.
Okay. Do you believe that this court has original jurisdiction over the matter that has been brought by petitioner Locklear?
I think it can have it, yes.
So if we can have it, then what part, if any, do you object to this being impaneled today other than the timing of it? Or do you have any objection to this being duly before the court?
Sure. If you say timing also involves this procedural issue.
Yeah, I was using
procedural
time.
evidence. Yeah. It is this tension, this conflict between Article 10 and the original jurisdiction piece. And you know, all due respect, this document is only X pages long. It's not 5X pages long. Every document I've ever read, there's a room for ambiguity. This is one of them, you know. And so there's the tension. I think that it forfeited original jurisdiction through Article 10, but absolutely the words, Your Honor, original jurisdiction are in there, not disputing. That's what the text says.
That if I could use your word, the tension, and the tension between the timing and the tension between the timing that you brought up earlier, where you, your assertion to the court is that your client is being, you didn't use this word, I'll use it, that he's been impaired, his rights are being, he's not fully allowed to exercise those rights that have been given to him as an individual under our Constitution. In light of the timing of all this, you're saying the court should do what to cure that potential harm to your client related to the timing? Your words were procedural, but you're really talking about the rush, the pace by which this is moving. What would be the cure, in your opinion?
Sure. I think this court has two options. My client believes this court has two options. Option one is to deny the petition as untimely and irregular and improper in form. There's a lot of ways, but that's remedy one, and I could list off several reasons it's improper, but you can imagine them. Also, I think factually without merit, it's not just legal defenses. And option two is exactly what's going on today, like literally today throughout North Carolina, where due to various redistricting issues, many communities in Raleigh, including Fayetteville, have postponed their elections for some period of time. I don't know the right period of time. Maybe it's December 15th. Maybe it's some other period of time. But that would at least take away the prejudice. You use the word impair. In some circles, we use the word prejudice, that we have been unable to prepare in a way that we think we should because of the lateness of this petition. That's not your fault. You didn't file this petition late. You received it late. But that doesn't mean that you must consider it. You could deny it because of the delay. Lots of magic legal words like latches and things. It's just too late. Or you could create more time by saying, okay, instead of November 9th, we're going to do it some other time. Those are the two fixes.
So sharpen the pencil, and what the court wants to hear clearly. Is Oxendine requesting that this court order the Board of Elections and mandate that the election currently scheduled for November 9th be delayed to a new date? And if you would tell me what that date is, that would allow your client proper time, in his opinion, to prepare for the petition that has been filed against him.
No, sir. And you note that I said I think if you look back at that, at the transcript that you may be getting a live feed on, I said those are the two things I see. I do not have authority standing at this podium to suggest, until I consult with my client, whether he wants it postponed, and certainly whether he wants it to X date or Y date. I don't have that authority. I'm just saying those are the two ways that I think things get fixed in this context.
So what we're going to do, it's 11 a.m., the court's going to stand in recess. We're going to give all parties an opportunity to consult. We're going to stand in recess for 10 minutes. Please be seated. It's 11:21. This is the Supreme Court of the Lumbee tribe reconvening.
Mr. Tippett, if you may return to the podium. I believe prior to the break, you were asked what would due process look like for Mr. Oxendine, or in the best way I can paraphrase. And you indicated that there were at least two, and I think you did qualify that at the end by saying that you were speaking for at least for yourself, and I think part of the break was to allow you to consult with Mr. Oxendine. After doing that, particularly with the second request, you had mentioned that this court act in possible similar fashion as other courts throughout the state, that we delay this election. And of course, that is a serious proposal that the court is prepared to take into consideration. But we would, after giving you an opportunity to consider that with Mr. Oxendine, what is your response at this time?
Thank you, Judge Brooks. Mr. Oxendine does not seek postponement of the election. He believes that this petition was weeks, if not months, late based on the certification of his candidacy. That and other merits-based defenses mean that this important election needs to move forward on November 9th, and of course he needs to remain a candidate.
In light of that, does Mr. Oxendine, or can you present to this court anywhere in the tribal constitution or in any tribal ordinance that would give us direction as to what rule of law to apply as it relates to the timing of this petition?
Yes, sir. Standing here today, I cannot give you specific dates, but it is my understanding that Mr. Oxendine's certification was
No, let me re-ask that question.
Okay.
The question is you indicated that you believe that this petition was filed improperly because it did not satisfy with the requisite timing requirements. This court has considered that question numerous times in our conferences together. And what I'm asking from you is that if you can show the court, offer to the court, some direction that is either in the tribal constitution or is in a tribal ordinance, what we ought to follow as it relates to the timing of the petition filed by the petitioner.
Yes, sir. And I heard you cite two authorities, and I'm going to ask you to consider a third because I think it's necessary.
Okay.
First, in the Constitution, I rely on Article 10, Section 1, parens A, which, as Your Honor has pointed out, entitles the Board of Election to promulgate regulations regarding regular and special elections. That is how I fit within one of the cited authorities. And to finish that thought, those regulations allowed for certification of candidates within a period of time. I'm sure Your Honor has already considered, well, what if the petition was filed on November 8th, or even worse, November 10th? You'll need to defer to something, and I'll come back to that.
Let me stop you right there. Let me ask you a question. What if this petition had been filed November the 8th? Mm-hmm. What would you, on behalf of Mr. Oxendine, say that the court, in that scenario, what would the court do?
Sure. I would continue to rely on that Article 10, but if Your Honors dismiss that, which seems to be your inclination as of a little while ago, then I would go to my third set of authority. The second one is ordinances. And candidly, I don't think the ordinances, to my knowledge, I'm not prepared because of urgency. I'm not deep dive into your ordinances. So I'm going to move my third set of authority, which is the federal common law, which is my understanding.
Before you move to that, forgive me for interrupting, and I don't mean that to try to distract you or cause an interruption in your thought, but I do think that it's important to flesh out some of these things. Sure. Because certainly there are persons who are present, who are hearing this matter, that they may not be fully aware of the reason why we're even asking these questions. So I don't want us to skip over the work. I want us to show the work so that the people that are hearing can understand the importance of these issues. Would you agree that if there is not a tribal ordinance, or if there is not a place in the tribal constitution that gives direction as it relates to the timing requirements of filing a petition, that it would be helpful for this tribe that there would be such an ordinance to give that specification?
Excuse me, my client has asked me to. Just for clarity, my client wanted me to emphasize that there is a published certification date. That is the triggering date. And so I want to emphasize that. That's what he stands on as a critical date. Would it be helpful? Sure, it would be helpful. I mean, but that's not the world that we lived in at the time that his candidacy was certified. I admire that the tribe does what it can to have these proceedings under the rules that it has, but there's just inexactness, okay? And so that's why your fallback, as I understand it, is federal common law, and in that is several principles relating to statutes of limitation and latches, meaning latches, L-A-C-H-E-S, for those who are not familiar with the term, basically stands for you waited too long. It's just not fair to bring it up. And I believe that November 8th is too late, November 10th is too late, and I believe October 6th, which I think whenever this was filed last week, is just too late because it's created all of these issues which may impose unfair procedural burdens on everyone. He just waited too late. And even if Your Honor does not believe that the court is bound by the certification date, like you aren't beholden to that as a statute and because of this irregularity of this not appeal, it is certainly evidence that the petitioner knew or should have known he should have filed a way back. And if I recall correctly, the petition even says he waited for other candidates to challenge it. They didn't. They have standing. And he did it. And let's face it, a community as wonderfully large as this, it is possible that there will always be someone to file a petition. There might be 10 filed tomorrow against all the other candidates. That would be unfortunate. You know, I'm not suggesting that should happen, but this court must not enable petitions to be filed but so late. Is that responsive to your question, sir?
It is.
Thank you.
So, with that being said, do you agree? I really don't want to ask you a speculative question, but because of how you've, and I'm using the phrase, open the door to it, I'm going to, especially with your reference to latches. You do agree that even after the election, it is not unheard of throughout this country and the state of North Carolina and other tribes around this country where protests are filed and the basis for those protests have to do with eligibility. Are you able to say, yes, you know that, or no, you don't?
I mean, I really don't know. I'm not going to claim ignorance of some of the stuff in last year's presidential election, if that's what you're alluding to.
No, I'm not alluding.
I
It's-
really don't know.
Sure. So since you don't know, then it's not your inference to this court that we should artificially put some deadline in there, correct?
I think the common law, the federal common law is you look at what is unfairly prejudicial to candidates or latches in general is unfair delay. And I think all of this is unfair delay to something that Mr. Locklear, the petitioner, was aware or should have been aware. It was certified weeks ago.
Sure. And I guess the only thing I'll say more for myself, to remind myself and the parties, the only ordinance that we are aware of that's applicable to this, in that ordinance, in section 6, where it talks about election results, it has a subparagraph called subparagraph 4. And it clearly says a candidate may contest the results of an election for a tribal chairperson or council, while a voter may contest their results. Subparagraph A, any contest must be based on a violation of tribal law. Tribal law, in our case, I assume you agree, includes the Constitution.
Yes, sir.
Or applicability of common law. And the reason I bring that up is because I believe, me, Joshua Malcolm, is that there is nothing in the Constitution and there's nothing in the ordinance that I've seen that establishes a deadline by which a challenge has to be brought. And in fact, subsection 4 that I just referred to actually opens the door that a protest can be filed after the election based on tribal law, which the parties have all agreed, to the extent that I asked all the parties this morning, everyone's taking judicial notice that in the Constitution, it clearly says, it uses the word residence, principal place of residence. I don't have any more questions on that, Mr. Brooks.
Thank you, Mr. Tippett. I would like to hear from Mr. Locklear in his response to that.
Thank you kindly for the opportunity. Oh, I don't know where to start. I'm just a simple man here, and I pride myself on that. Do recall at the...
Take your mask down if you would, Judge. So we're having a hard time hearing.
I'm sorry. Start over. I'm just a simple man. Pride myself in being that. It's not a bad thing. You know, what I think is being presented, with all due respect, is a lot of smoke and mirrors. I mean, the issue is whether or not Mr. Oxendine whether or not he has met the constitutional requirements to run. The Board of Elections is playing hide the ball. They wouldn't tell us, they wouldn't give us any information on his application. I've forgotten it. Let me get it. This will give you some insight as to why we didn't file before the Board of Elections. We asked for any information and then boiled it down to just tell me when he claims, Mr. Oxendine, when he claims he became a resident with respect to his filing period. There's what they gave me. 4 sheets of nothing except his name on the top. It would have been a colossal waste of time for David Locklear to have gone through the door at the Board of
Mr.
Elections.
Locklear, what is it that you say that the Elections Board gave you? I see the pages there, but
This is an application for tribal chairman that Mr. Oxendine filled out. I asked him for some information, in particular the answer to the question. I can read the question to you here. Length of time at this residence. I said, just give me that. And this is what they gave me. Everything is redacted except the name Ronnie Oxendine, which means they gave me nothing. Again, why would we even attempt to go through their door and ask them for anything else when they wouldn't even tell us that. Lumbee people are entitled to know what he claims. And well, they didn't give it to us then. We haven't heard it yet. That's why we're here. This thing about latches.
So, just, Mr. Locklear,
Yes,
what's the date on that application? Does it
it's
have a
not
date?
on there.
Doesn't have a date on it?
It's blacked out.
Okay, what date did Mr. Locklear receive what the election board sent to him?
I asked for this, and they sent this to me Monday morning about 8 o'clock. I asked for it at least a week before. I asked for it, I think, before I ever filed the petition on his behalf.
So you-
Why did you ask for it?
Because I wanted to know what Mr. Oxendine claimed. That'd at least give us a start date in trying to make our case. I mean, I know full well he's not going to claim I moved in last week, but does he claim he's been there 2 years or 3 years or how many months? You know, we know the term is supposed to be 12 months before, 1 year before the term begins. And so let's just suggest that January 1 would be the start date. Well, I was interested to see what date he claimed. Also, in terms of establishing residence, you know, when did he move to this place, and what evidence does he show that he has now claimed that? That's another argument, of course, and we're not there yet.
Mr. Locklear, let me interrupt you just for a minute.
Sure.
Mr. Tippett, I don't believe, or he was unable to provide the court with any type of tribal ordinance or any place in the Constitution that specifies with specificity the time for which is allowed to protest a candidate's eligibility to run for chairperson. Can you present to the court any or cite any ordinance or any place in the Constitution where that is cited?
It's not there. It's not there. Now, granted, I would have never taken the case if he'd came in with a sack full of money if he said if it was on the day before the election. No lawyer worth their salt would have ever done that. Yeah, there are times when protests are filed after the election. I mean, if evidence came to light and it was provable, good evidence, even after the election, the tribal chair, the elected tribal chair, could be challenged. He can move he can move to Southern Pines, you know, where he's got property. That's not the case. David Locklear came to me to hire me when he felt that he had enough evidence to go forward. And hiring a lawyer to do this kind of thing is not a simple thing. You don't just walk in somebody's door and they take your case. There's all kind of issues. Let me get back to that.
Let me ask you one more question.
Yes.
Mr. Locklear. Can you offer to the court or cite any ordinance or any place in the Constitution where the Tribal Elections Board is under a duty or responsibility to provide you with the information that you requested?
No, I can't. But let me tell you, I mean, aren't the Lumbee people entitled to know when their possible elected leader, aren't they entitled to know what he puts down on a piece of paper when he files? Just plain old common decency, common sense ought to be the rule of the day. You know, they claim all these privacy issues, and they quoted statutes and ordinances, and I don't have access to all that stuff. I don't. But I mean, what world are we living in when we're not entitled to know where our prospective tribal chair lived at, how long he's lived, any of the answers that are required to be filed in an application? We ought to be, you know, we don't want to know his social security number, obviously. Don't need to know his cell number. You can get that off the internet easily. I've seen it many times. But we didn't ask for that. We didn't get what we asked for.
Let me just respond, Mr. Locklear.
Okay.
I understand that all of us are dealing with some difficulties. there are problems that exist here. One, because there is silence in tribal ordinance that would give us more clarity and direction on how to address some of the technical aspects of this case. But specifically, I would like to hear your response to Mr. Tippett's assertion, because you somewhat raised that it's a matter of fairness, it's a matter of common sense, it's a matter of the right thing that you should be able to request this information from the elections board and receive it. Mr. Tippett's raising the issue that it's a matter of, I may be putting some words in his mouth, but I believe it's paraphrasing the spirit of his argument, that it's a matter of common sense, it's a matter of fairness, that this is a protest that should have happened a long time ago. And that's why he brings up this issue of latches. How would you respond to that?
Okay, thank you for the question. Closing date on the filing was September 3rd. The Board of Elections policies and procedures say they have 5 days to certify. They certified it in 2 days. They say they certified it on September 5th. That's on a Sunday, 2 days later. They also say in their filings, David Locklear should have appealed this matter between the closing and the certification. He had 2 days, a window of 2 days. That's totally unfair. That's not answering your question. The two things, we have time to resolve this dispute today, or tonight, God forbid. I understand Mr. Oxendine's position, but the bottom line is this. He's got all the answers to the questions that you need to hear today. Preparation, all he's got to do is be sworn and tell the truth. And this matter it'll go away one way or another. You'll fine for the petitioner or you'll fine for the respondent after you hear that evidence. Lumbee people are entitled to know. Now, he didn't wait until the 11th hour. This might be the 9th hour when the petition was filed. He filed the petition when he got the information. Now, again, I say that Mr. Oxendine has not been prejudiced. I understand Mr. Tippett's point of view, and he needs more time to feel comfortable. Now, I don't know if that would ever occur, Mr. Tippett, given the loose ends in these procedures and in our Constitution, for that matter. While I'm here, let me mention this. Go back to the 5 days to certify. They certified in 2. If you read on down to, it's just in section 7, it says if somebody makes a claim against a candidate, it doesn't say you got 5 days to make that claim. It says the board will investigate that claim. The board will proceed to investigate allegations that have been raised within 5 days. That's certainly not any kind of time frame that the petitioner is bound by. And of course, the reason we're here, if we'd gone to the Board of Elections, we'd still been the Board of Elections. They'd have done whatever they did. Obviously, they protest too much. I mean, what is it? Why is it? Why is their decision so important that they put up this big a fight over it? Why not say, here's how we made our decision? You know, this thing could have been resolved in a letter or in mailings, but no, they gave me no information. We filed this matter. We are entitled to be heard, and we hope you will agree. Latches does not apply because it was filed at least a month before the election, and we do not, David Locklear goes on record, we do not want this election postponed regardless of what happens here today. That was never our intent. Our intent is for this election, for the cloud to be removed that's hanging over Mr. Oxendine's candidacy. Board of Elections won't help us. Lumbee people are entitled to know if they elect this man that we don't question his abilities, his competence. None of that is at question. He's a smart man. I'll give him that. We question whether or not he meets the constitutional requirements for residency, and only you can make that determination. these folks, I suggest to you that they either couldn't with an open mind because they already had ruled that he was qualified. And then we go back and ask them again to reconsider, that'd have been a futile effort. And and then we'd have been at the 11th hour attempting to appear before you a week before the election. That wouldn't have worked, and that's why we're here. I'll be glad to try to answer any questions you might have, if any more.
Is there any more preliminary matters that you wish to address, Mr. Locklear?
I'm sorry, say again.
Any other preliminary issues that you would like to respond to or address?
Well, we do have a motion to, for you to reconsider intervening, having the Board of Elections be a part of these proceedings. We also have a motion to ask you to apply the burden that North Carolina applies and that's commonly applied in most, if not all, jurisdictions, and that is when a candidate is challenged, it's up to the candidate to prove his residency, not to the challenger. Again, Mr. Oxendine's he's got all the answers. Of any person in this room, he is the only person who has the answers. I mean, you'd think Mr. Oxendine would want you to hear these answers, and that takes the cloud away. And if he doesn't, then obviously there's an issue, and that's why I guess we're here.
So in light of you bringing up that last point about the question of burden of proof, as a practicing attorney, you would agree that in overwhelmingly the majority of legal cases, the burden rests with a petitioner. Would you say that is?
I agree. I agree. Certainly, not in this instance.
And the incident that you're citing where the burden shifts to the candidate or the respondent, you're citing a North Carolina statute or North Carolina law. Is that accurate?
That's correct. But I suggest to you that's the law in other jurisdictions.
Would you suggest that is the law or the approach for under federal common law?
I can't answer.
And the reason why I ask that, Mr. Locklear, is that you understand that this court is instructed in the Constitution to base its rule of law on an exhaustive list of things, which include the Constitution, tribal ordinances that are passed by the tribal council, tribal custom, and federal common law. So you would agree that it would be problematic to some extent for this court to rely on a state law established by the state of North Carolina in making our decision. And so I ask that question, not because I believe that it is insincere or impractical, but I ask that question so that this court can have a guidance to go by in making a determination which way the burden should be in this case.
And again, I appreciate the question, and I understand full well that we're at a disadvantage in arguing North Carolina law, but I mean, what does it require? A change in the Constitution to say, consider North Carolina law? Hopefully not. Hopefully the court can, on its own, consider what the majority law would be. And just because the Board of Elections decided that was going to be the burden, that's not final. Again, this court determines what is final. It's time to change the standard, whether or not you choose to do it today or the next case. I mean, our case is not going to stand or fall, not as long as we can call him as a witness. 6 of one, half a dozen of another.
Say that last part again, your case.
I don't think our case is going to stand or fall on whether or not you shift the burden to Mr. Oxendine, so long as we're allowed to call Mr. Oxendine as a witness and ask him a litany of questions. He's got the answers.
Would you agree, Mr. Locklear, that regardless of who the burden of proof rests with, that the standard of proof would be by preponderance of the evidence?
Absolutely.
Which for maybe persons who don't understand what preponderance means would simply mean which side is more believable.
51% of the evidence versus 49% of the evidence is one way that we use, it has been described. I'll accept your definition, certainly I will.
By the greater weight of the evidence, that's what it means.
Say again?
Greater weight.
Greater weight of the evidence, and if you can imagine scales, then that tip just a little bit, then the side that proves has the greater weight obviously prevails.
Thank you, Mr. Locklear.
Thank you.
Miss Graham, can I ask you, get you to step up and answer one question, just one question only?
Your Honor, may I have the ability to respond?
Sure. Can you answer this one
Yes.
question first? Sure. Does the Board of Elections request that this election be delayed until this matter is, so, I mean, you too, much like Mr. Tippett, have mentioned not, your client has been, I use the word impaired. You reference due process, not able to adequately respond to the interpleader, things like that. In light of that, and we need to get the Board of Elections on the record. Is it the Board of Elections' desire that this matter, that this election be delayed so the board has more adequate time to prepare to participate in this matter?
No, Your Honor. The board has convened and spoke with its members, and based upon its budget and the time constraints, it has the report that it submitted this morning, 131 outstanding absentee ballots, and we're holding 217 absentee ballots. We want this resolved as soon as possible.
Okay, thank you. I think if it's okay with other justices, we'll ask you to respond to the comments from the petitioner, if you wouldn't mind.
The first thing we would like to
Ms. Graham,
respond to,
Excuse me, if you feel comfortable, will you remove your mask? Just
Yes.
so I don't want to miss out on any information.
Yeah, we're having a hard time hearing.
Thank you.
first thing we would like to respond to as the Board of Election is to the disclosure of information. Lumbee Tribe of North Carolina has a disclosure ordinance. In that disclosure ordinance, the Board of Elections is specifically removed by name from the disclosure ordinance.
And you cite that ordinance, Ms. Green?
CLLO 2010-0318-01.
So when you said remove, what do you mean by that, Ms. Graham? When you,
Specifically in Section 3, this ordinance does not apply to the Board of Elections as a constitutionally established independent board. And what the disclosure ordinance did is it gave all the agencies and all the organizations that fall under Lumbee Tribe rules to follow on what to disclose, what not to disclose, so that everybody's following the same set of rules. And we also have case law. The Tribal Supreme Court in Purcell versus Sheila Beck decided a case, and in that court order, it issued that no addresses, no anything would ever be revealed on voter rolls except voter names. You get an application, it has to be redacted. It's case law, it's present, it's recorded.
I think, yeah, I don't, the court has discussed that in conference. I think that we have accepted that, and you don't need to make any more arguments related to that. To be clear to all the parties, the court has taken notice that an ordinance exists that prohibits the Tribal Election Board from sharing certain private, I'll call it private in general, I'm using a general term, private information related to individuals that go and file for election. We accept that as basically fact.
And specifically, we take offense that it indicated some way that we were hiding information or not being cooperative with the petitioner. We had great discussion about it, and we decided the best thing to do was to follow the law. If the court wanted to issue an order that we provided to the courts, the court had the authority to do so.
Sure. Anything else related to Mr. Locklear's?
Yes, Your Honor. In regards to latches, in my motion to dismiss, I specifically have a claim for violation of statute of limitations, as well as in the alternate of latches. And
What statute of limitations?
that's where I'm going to go with this. In our claim, we claim that the policies and procedures of the Board of Elections establish a time limit. Now, If you go to our policies and procedures, which we did submit, pursuant to the claim under Section 7, once the candidate is certified, and he was certified again on September 5th, that within 10 days, and this is in Section 4, within 5 days, the board will proceed to investigate the allegation that has been raised within 5 days of the receipt.
I'm sorry, Miss Graham. So we're looking at a document for the record. It looks like, make sure we're clear. The
This would
Lumbee
be-
Tribe of North Carolina Elections Board Policies and Procedure in the top right-hand corner has 3 dates. And the last date says amended September 19th, 2021.
That's correct.
And which section do you want us to turn to, ma'am?
It would be Section 7. And the first section you could read is, again, the candidate's eligibility pursuant to the Lumbee Constitution, whereas the election of the board's authority shall be to canvass the candidate's application after the closing date of the filing and within 5 days certify those who are eligible to run. That's exactly what happened. Within 5 days of the closing date, Mr. Ron Oxendine was certified to run. Under Section 3, all of the board members shall sign the certificate, the candidate certification document, and provide copies to Tribal Council Speaker, Office of Tribal Chairman, the Supreme Court candidates. That was done.
Ms. Graham, can I interrupt you for just a minute? I believe the court has stated an opinion thus far in this hearing that at the present moment we are not convinced that the Elections Board has the authority under the Constitution or by tribal ordinance to pass laws as it relates to elections. In light of that, assuming that this court were to accept that the Elections Board does have the ability to pass policies as it relates to this, as it relates to elections, and in light of the fact that we are looking at a copy that was adopted on November 17th, 2016, and was amended on September 19th of 2021, the provision that you just spoke, can you state on behalf of the Elections Board whether or not that was in the original policy that was adopted on November 17th, 2016?
Yes, Your Honor, that was in the original copy.
Can you explain for the court what the purpose of the amendment was? Why this policy was amended?
The Board of Elections needed an explanation for the word of residency under Section 2.
So, is it accurate that the Board of Elections modified a policy related to residency of candidates, including Ron Oxendine, after he had filed for election, after he had been certified by the Board of Elections? Are those statements true?
Your Honor, the board informs me they had already been using the said policy. They simply had not put it in writing, that it had been before the board in their meetings at least 6 months prior to.
Okay, that sounds great, but is it true that the board formally adopted changes to its policy after Ron Oxendine had filed, not only Ron Oxendine, Dewey McNeil, Kendra Locklear, Wendy Moore, and every other person that had filed for election? Is it true that the Board of Elections changed its policy after this election had begun?
Yes. After the 5 days for certification was up.
Can you explain to the court why that happened? You're more than welcome. If we'll be more than happy to hear directly from your client, Ms. Graham.
Board's indicating they wanted to codify into their policy what they'd already been using as their practices and policies, but had not codified it.
How would the tribal members know of the non-codified provisions that they had adopted as practice based on your words 6 months prior?
They would have access to their meetings as well as minutes.
Okay. Would it be fair for me to ask whether you think the court should have concerns about the fact that your client earlier in your written words to us on or about the 8th instructed this court as to what things we must follow, and for us to solicit, I'm not going to call it testimony, but for us to solicit from your client through counsel that they changed their election policies after the election had begun? Is it fair for the court to have concerns about that, and more importantly, the tribal members in general?
Could you repeat the question?
Is it fair for the tribal members and this court to have concerns about the fact that your client made changes to its regulatory policies after this election had begun?
No, because at that point in time, all candidates had been certified, the time to appeal within the 5 days had ran, and there had been no appeals made, there had been no challenges made, and the time at that point had expired.
So, Mr. Locklear, and, Mr. Tippett, Mr. Oxendine has argued, and you have argued, laches. And you and Mr. Oxendine have basically argued that this matter should have been brought forward by Locklear. How is Locklear supposed to bring a matter forward if the rules of the elections board are being changed after the election began? And would it be fair, with that having occurred, wouldn't that mean, in fact, that your board could meet tomorrow and adopt an additional change to the policy?
They're allowed to do so by the authorization of the Constitution as well as the ordinance to do so, but at that point in time, no. He had not filed within the 5 days, he had not made the challenge, and there was no pending allegations.
What is the limit, if there is one, that your client has as to the changes it can make?
The limits are set forth in the ordinance pursuant to Section 3, but it's also given authority under the Constitution if it so wishes under any other matters.
And which ordinance are you speaking of?
Under the elections ordinance.
Section 3 you want us to look at?
The election ordinance, Section 3, is the ordinance that sets out the ability to promulgate rules and regulations. The first one that is the issue is Section 2, the certifying of candidates.
Section, make sure we're clear, we're referring to CLLO 2005-002, last modified on March 21, 2019?
That's correct.
I'm looking at Section 3, ma'am. So
And
just for the record and for because I'm not, can you point out exactly where it says the board can make the changes it made?
the elections board authority to promulgate rules and regulations shall include but not be limited to, and it sets out.
Okay, and that's that list, 1 through 22?
That is correct.
Isn't it
But I also would say that there is inherent authority pursuant to the Constitution as well.
And it's your client's position that that authority includes, after the election has begun, that it can change its policy and establish who has the burden of proof related to a candidate challenge. Is that true?
Just give me one moment, Your Honor. According to the Board of Elections, there was no change as to the burden of proof.
By chance, we've received from you the amended policy dated September 19th, 2021. By chance, would you be able to tender to the court a copy of the policy as it was on November 17th, a copy of the policy as it was on September 12th, so we could see what changes the board made to the policy, so we would better understand in practicality the authority that they think that they have?
He's asking, can he get copies of the pre-edited versions? Yeah, we can't have them. We don't have them with us. Let me see. They will work on getting that to the courts, but it may be someone have to go to the Board of Elections.
But the bottom line is, it's your client's position that their authority is not limited.
Their ability to promulgate rules and regulations as set forth in the ordinance is set forth in Rules 1 through 22. However, they do also have some inherent authority that's given and set forth through the Constitution. But at this point in time, their rules and regulations and policies and procedures that we provided copies are specifically do deal with items 1 through 22.
And based on your earlier comments, this court should consider them the equivalent of an ordinance.
We would not say the court should consider them the equivalent of an ordinance. We would say that because the Constitution gives the authority to the tribal council to grant that authority that it did grant to the Board of Elections to promulgate rules, that this court should in fact respect those rules and consider them to be valid case law, valid court orders, valid rules of the court, even if it is administrative in nature, that it could uphold as the practice or the custom of the Board of Elections. Because what you are doing today, essentially, even as the review court, affects the policies and procedures going forward of the Board of Elections. And the duality in nature, if a person could have come before the Board of Elections to challenge the residency of Mr. Oxendine, and at the same time, Mr. David Locklear could have come to this court to challenge the residency. There we go.
Ms. Graham, you would agree that part of the scope of this court's authority is to make decisions that have an effect on actors of this government.
And we would agree, and that is exactly what we say would be appropriate in the review process.
So,
that this would be an appellate decision to review the actions of the board had the petitioner filed his petition correctly.
So
and we wouldn't disagree with that.
when you say that what the court does here today will affect the elections board and their policies and procedures, isn't that precisely what the Supreme Court does? We make determinations whether or not an actor of this government has acted constitutionally or unconstitutionally. And going forward, there should be a modification of behavior that would be constitutional.
And we would agree that that would be correct if this was the correct setting, if this was the review process, if this was an appeal. But it's not. It's circumventing the appeal process. It's circumventing the review process. It's not a do-over. It's not a fix the Board of Election. He's not complaining about what we did. It is a brand new action. It is a redo. It's a avoid the Board of Elections because I don't like the way they work.
What does the Board of Elections say to promulgate rules and regulations means? What does the Board of Elections contend that the word promulgate means?
To make rules and regulations. Rules and regulations.
So it is your contention that the word promulgate means to create,
Create
or to
rules
establish,
and regulations.
or to make.
Establish, to make.
You would also agree that this election ordinance that you're citing, 2005-002, that in the second whereas it says, whereas Article 7, Section 1 of the Constitution of the Lumbee Tribe of North Carolina delegates all legislative authority to the tribal council. And at the fourth whereas, it says Article 10 authorizes the tribal council to adopt ordinances, which shall govern voter registration and the conduct of all regular and special tribal elections and any other matters specified herein. Now, I say that because it is difficult for me to conclude that the Elections Board has the authority, inherently or constitutionally or by tribal ordinance, as you state, has the authority to make, to create, to establish regulations in light of the fact that this very ordinance says that it is the tribal council's authority to make ordinance, to make regulation.
And if you go to Article 10 of the Constitution under the Elections Board, Section 1A, to promulgate necessary and appropriate regulations under authority of this Constitution and tribal ordinance.
That is assuming, you would agree that that is assuming that your conclusion that the word promulgate means to create.
There shall be an independent tribal elections board of the Lumbee Tribe of North Carolina, which shall have the following authority: to promulgate necessary and appropriate regulations, make policies.
If that word promulgate means to create or to make or to establish, why would the tribal council pass an ordinance telling the elections board what its duties are if the elections board has the own authority to establish what its own duties are?
Because the Article 10 also gives that authority to the tribal council to do so by way of tribal ordinance. It's included in Section A, under authority of this Constitution and tribal ordinances governing voter registration. Again, I read it. Maybe it isn't written well, but what it says is the board is given authority. It's given authority to do what? Promulgate. What does promulgate mean? If I look it up in the dictionary, it simply explains what the word means. There are some places you can read it and it'll say create. There's some places where you'll read it, it'll say make. At this point, the more important word is regulations. What are regulations? They're rules, they're policies, they're procedures. We're not going to call them ordinances. We're not going to say that they're created by the tribal council. No, we have our own policies, our own procedures, and they are reviewable by this court, and we respect that. We simply say that what the petitioner's done here today is not following Article 10, it's not following our policies and procedures that we were given authority to do by the ordinance, that we're asking the court to respect our policies and procedures that have not been set aside, that have not been challenged here today by this petition. That's it. We're not saying they're 100% right. We're not saying that you can't change them. We're saying the petition before you today does not challenge that. As such, it's still our policies and procedures.
You would agree that the provision in the election board's policy, which limits a petitioner or a protester's ability to bring a petition before this court or to the elections board, you would agree that limiting that to 5 days places a restriction on the Lumbee voter, would you not?
Well, if you do that, then you also have to agree that the Lumbee ordinance that limits a challenge of a protest to 5 days is also a limit of a right.
Where does it say that in the ordinance that they're limited to 5 days?
Under Section 7.
Okay.
And you would agree that this ordinance is adopted by the tribal council, not the elections board?
That's correct.
So
that's where we promulgated our rules to follow the ordinance.
But that's not what my question was. I didn't ask you whether or not the tribal council has the ability to restrict the actions of the Lumbee people. My question was your policy, or the election board's policy, that limits a challenger's challenge to 5 days from the date of certification, that would be an act by the elections board to restrict the right of the Lumbee voter.
And the question was, do we think that that's fair?
No, my question is that is a limit on the right of the Lumbee voter.
Yes, we limited it to 5 days because from September 5th to the actual date of elections, we need to limit the time so that we can do our jobs to move forward with the election process.
Is it the position of the elections board that the elections board can limit the rights of the Lumbee voter without that being brought to the tribal council to be made law? Apart from the lawmaking process, that the rights of the Lumbee voter can be restricted?
At this point, it's not law, it's policy and procedure. There's nothing to say that Mr. Locklear couldn't have appealed the decision of the certification without following the 5-day rule to challenge it. There's nothing in that procedure that said he had to make allegations to challenge it and then appeal that challenge.
Where is it? Hold on, Judge. Please respect the court. Where is it in section 7 of the ordinance that you keep referring to where it says the petitioner only had 5 days?
Okay, numbers 5 on page 10.
Section 7 starts on page 9 according to the one that I have. Make sure I'm looking at.
And if you, I have section 7,
You want me to look at the top of page
5.
10? Okay, okay, I'm in section 7.
Item number 5.
Item number 5, I see that.
Certification of a candidate or measure in question will be made by the board following determination of the challenge or recount as the case may be. Upon certification of an election, a candidate or voter may within 5 business days appeal to any lower court with jurisdiction. If a decision of any lower court is not satisfactory or no lower court exists, the candidate or voter may appeal to the Supreme Court. Under that certification of a candidate, if there is a protest, which is what was alluded to earlier with Mr. Locklear, and the question was asked, the ordinance established by the tribal council has limited that date and time to 5 days to appeal it.
You would agree that that is in reference to the certification of an election?
Yes, and we've compared our certification to the candidate to that of the certification of an election. So the certification of election puts a 5-day limit on the protest, as it does the 5-day limit to challenge the candidacy through the procedure of the Board of Elections. But again, that does not stop, again, section number 5 under procedures, where any decided or certified matter by the tribal elections deemed to be final, tribal action shall be reviewable by the Supreme Court. So nobody's saying he only had 5 days to appeal the certification. The 5-day rules is to say if you challenge the certification and you're asking for the board to review it. Now, he didn't ask the board to review it. 5 days go by. Now, 30 days go by. He still, within 30 days, didn't ask for an appeal of the Board of Elections decision. And that's where it gets to latches.
So let me just stop you for a moment, because this will have a great effect on how I feel about this particular issue. Is it your position that it is the policy of the Lumbee Elections Board that states that an election to a candidate's qualifications must be done within 5 days of the certification of that candidate? Or is it your position that Section 7 in this elections ordinance, particularly Section 5, subsection A and B, is it your position that that is the law of which this court ought to rely on?
No, Your Honor, that was the question that was referenced to Mr. Locklear in regards to a protest, that it could happen any time, that this action here could happen even any time, even after an election. And the question arose, well, what would be the time limit after that? Well, here under the Lumbee Tribal Council, it's only 5 days.
But
that was my answer to that
5
question.
days after the election.
After the certification of the candidate in that election. So that was my answer to his question.
And you would agree that this provision, this section in this tribal ordinance was adopted by the tribal council, not the tribal elections board?
That's correct. We do not argue that. What we say is, that was the answer to the question presented as by way of latches, what is a reasonable time? When would it end?
I understand that, and I respect that argument, but is it then your further contention that the policy of the Elections Board, which I believe is probably inspired by Section 5, subsection A of
And that
this
is
ordinance,
correct, Your Honor. It is exactly
is it your
inspired.
contention on behalf of the Elections Board that this policy should be given the same weight and treated the same way as this section in a duly adopted tribal ordinance by the tribal council?
Of course, Your Honor, we would not disrespect the court and say that a policy and procedure should be given the same weight as an ordinance enacted by the tribal council. No.
But practically speaking, Ms. Graham, isn't that, what other way is to do it? It's not there's not room for a gray area. It either has to be respected or it's not respected.
No, what we're asking the court to do is to look at our policies and procedures and for the court to respect them, that they are there, that they've not been set aside, and that they are good rules and the valid rules and procedures of the board, an administrative board, not the law of the land as an ordinance may be, but the rules of the administrative board. Whether you want to call them the administrative court or not, they are still the rules that have not been set aside, that the tribal council at any time could promulgate its own laws and say, hey, we're going to go back into the election ordinance and we're going to change it because we don't like the policies and procedures that the elections board put together. But they haven't. And these are the rules and policies we have, and we're asking the court to respect them because they're not before the court being challenged.
Even if he didn't plead them, you said that even if he didn't plead it, you're not saying this court cannot, on its own inherent authority, decide today or tonight, whenever we're going to wrap this thing up, that the policies adopted by the Board of Elections are not consistent with the ordinance and the authority that they've been given, and they've exceeded the authority granted by our legislative branch, which is more closely related and connected to the people. Are you saying, is it your belief or your argument that the court could not strike it all down today, saying that it's unconstitutional what's been adopted?
No.
And what's been put in place?
No, Your Honor, what I do believe is that the court should hear what's in front of it, what the pleadings bring to the table. And the pleadings today are defective. Now, that's not at the issue with the court. That is the petitioner's pleadings. He brought them to the court. There's nothing in the pleadings to suggest that anything the Board of Election did was wrong or needs to be changed or needs to be addressed. As such, again, the Board of Elections has no due process notice that we need to be here defending any of our policies or procedures, but we are under notice that what you do matters because you do have the inherent authority to address our rules and regulations. And simply by the order you've already issued with the definition of residence has in effect affected our policies and procedures.
Absolutely.
So we're well aware of the court's authority. What we want the court to do is understand that we have policies and procedures, we have case law that has not been challenged, either by the courts or by the tribal council, who with the swift of a pen could do so. And they know the rules. And these rules have come before them. And even by the transcripts that we received last night at 8 o'clock, they're in discussion. So, that being said, our issue with latches is, even though Mr. Locklear didn't meet his 5-day deadline for the allegations for a challenge, he still waited 30 days later, 31 days later, as a matter of fact, before he filed his petition to come to this court. 31 days that the Board of Elections was able to rely on his inaction. They relied on his inaction. They got their absentee ballots. They've got them printed. They've sent them out. And now we've been told to stop because of his inaction. The problem with the process we have here is there is an administrative process. He had a remedy. He's not here today telling you that the administrative remedy set forth by the Board of Elections didn't work. There's nothing in his petition that says, Judge, they can't do their job, or they didn't do their job. It's not in the petition. To allege that the administrative remedy is not available or is not sufficient You have to plead it in your pleadings so that we know how to defend ourselves yet again. It's not there. You have a duty to use your administrative remedies that he had through the Board of Elections. First, he had a right to make a challenge. Within 5 days, he didn't do it. Then he had a right to appeal the certification of Mr. Ron Oxendine.
And if I may, Ms. Graham, you're basing that on the election board's policy. When you
Policies
keep
and
saying 5 days, you're not saying according to the Constitution, according to any tribal ordinance adopted by the tribal council. You're specifically referring to the tribal elections board policy that you presented to this court as amended as recently as September 16th of this year, September 19th of this year.
But the policies that were in place, Your Honor, in regards to the 5 days, the policies that were in place in regards to the administrative hearing, they've been in place since the policies and procedures were enacted. This isn't anything new. Mr. Locklear had rights and remedies since November 17th of 2016. These aren't something that he just learned about September 12th or September 19th, and we will get you copies so that you're clearly aware. The 5 days raised within the date of receipt in his administrative remedy have always been available with the Board of Elections. There are numerous cases with the tribal court, Supreme Court, that have come out of the Board of Elections through appeals and through appeals.
Does the elections board contend that they had the authority to put a provision in this policy that there would be no opportunity to contest a candidate's candidacy after certification? And if they say they don't have that authority, why wouldn't they have that authority?
Can you repeat the question?
Does the elections board, do they believe that they have the authority that in a policy, in the same policy that you keep referring to, would they have the authority in that policy to make a regulation that would say that a candidate's qualifications for office cannot be protested after the date of certification?
No, because it simply says in item number 5, it repeats what the Constitution said. Any matter decided or certified by tribal election shall be deemed final tribal action and shall be reviewable by the Supreme Court of the Lumbee Constitution. So it would always be reviewable.
And so, what if you're saying that the elections board does not have the authority to not grant any time after the certification for a protest?
Well, no, I didn't say that. I said that it would be reviewable by, any action would be reviewable by the Supreme Court.
Including this action.
Including this action had he filed his petition to say, I'm appealing the certification of Ron Oxendine.
And I want to make sure, that's where I'm getting stuck, Ms. Graham. Section 7 of the ordinance refers to election certification. You're telling us that it's the view of your client that Section 7 election certification in subparagraph 5A, where it talks about 5 days, your board equates election certification with candidate certification.
No, that my board used that as a way to mirror the candidate certification with the 5 days as an inspiration.
Okay, so, all right, so where at, and I apologize, I'm looking at your client's policy, last updated on September 19th. Where specifically does it say for candidate certification, it's 5 days?
Well, first you would need to read paragraph 3 that tells you that they signed the
Tell me which
candidate.
section to look at first. I apologize. Which section?
It's section 7
Section 7. Hold on one second.
of the policy.
Section 7. I'm at section 7. Yes, ma'am.
In line number 3,
Subparagraph 3, all the board's members shall sign.
and once it's delivered, yes.
I don't, make sure. I'm looking at section 7 on the bottom of page 6. Which subparagraph do you want me to go to now? 1, 2, 3, 4, or 5?
So once you read paragraph 3, then all the board members shall sign the candidate certification document and provide copies
Yes,
to
ma'am.
those listed individuals.
Yes, ma'am.
If an allegation is made by any tribal board member against the candidate, that individual member shall be required to provide the burden of proof in written form to the election board. This is the 5 days. The board will proceed to investigate the allegation that has been raised within 5 days of the receipt.
And the insertion, the reliance that your client used to put section 7, subparagraphs 3 and 4 comes from the election ordinance, section 7, election certification.
No, I'm not talking about the protest. I'm talking about the challenge of the candidate.
Just for everybody in the crowd, we probably anticipate breaking around 1, Mr. Tippett and Mr. Locklear.
Thank you, Your Honor.
Yes, sir. 'Cause I know you guys are busy with other things. That's our goal.
So the answer from the Board of Election would be that they simply looked at it to give them some type of direction.
Some type of guidance.
That's right.
And these are my words. I don't mean to put words in your client's mouth. They said they saw 5 days referenced in section 7 related to election certification, and they thought, well, maybe we need to have a certification process for the candidate certification, which is how they came up with section 7, subparagraphs 3 and 4. Basically, and I'm not putting words in their mouth. That's not testimony, but that's in generic terms.
Yes, Your Honor. And again, the appeal, there is no time limit for appeal, and there is no process that said you had to challenge and then appeal. That is not the case. But what we're simply saying here is that you waited 31 days afterwards to file your petition, which is still not in the form of appeal. And because of that, we say that you've sat on your rights that you've had since the day he put out his first sign to say he was running for tribal candidate, that you could have come to the Supreme Court. And again, we acknowledge that up until the day that the Board of Elections certified Mr. Ron Oxendine, that he wouldn't have had an administrative remedy, that this would have been his only remedy. But once he was certified, Mr. Locklear had an administrative remedy he didn't take advantage of. For whatever reason, he sat on his rights. Because he didn't make allegations, they weren't investigated. Because he didn't appeal the decision to certify, the Board of Elections has moved forward with its process, and it's because he sat on his rights, and that's our argument for laches. He's failed to do what a person should do to protect his interests. He's failed to use his administrative remedies that were available to him through the process, and we believe his petition should be dismissed. We also believe it should be dismissed based upon the fact that those who sleep on their rights are not protected.
Just in case, just so it's clear, Ms. Graham, I hope it's evident that one of the things that's important for this court is to assure that there are these separation of powers. And you made that argument, I recall when you were very open in argument to the court, is that the elections boards, one of their concerns is that their authority is not being encroached upon by any other agency in this government. And I respect that. And I do believe that the elections board is independent. And I do believe that the authority that's been granted to them either by the Constitution or by tribal ordinance, ought to be respected and ought to be scrutinized if it's violated. But likewise, I believe it's also important for this court to ensure that the authority of other branches of this government, particularly the legislative branch, the tribal council, that their authority is not being encroached upon by the elections board in any attempt that may look like the making or the creation or the establishing of any type of law. And so that gets me to this question. Can you show the court in Section 3 of the Elections Ordinance 2005-002, out of those 22 duties that are specified there, can you point the court to any one of those duties that would include the making of rules or regulations that affect the Lumbee voter?
That affect the Lumbee.
Voter or member. I use those two interchangeably.
So you're asking if the ordinance allows any promulgation of rules and regulations that affect the Lumbee member?
No, that's not what I'm asking. I'm asking, does any of those 22 duties established that are authorized to the elections board, does any of those include the power or the right to make policies, rules, or regulations that would affect a Lumbee voter or member? Or are those rules simply procedural rules to carry out laws that are in fact passed by the tribal council?
Then the answer to that would have to be yes, because if you look through items 1 through 22, there are no laws created. There are no ordinance created on how to store ballots. And all of that affects the members because it affects their vote. It affects the security.
You would agree that there is a significant difference between counting a ballot and making a rule to determine who can be or cannot be on that ballot.
And I agree to that, but
you would
all
agree
of the
that one is
security
procedural.
of the Board of Elections, whether it's procedural or not, because if it comes down to theft of even just storing a ballot, that involves the voters' rights, because it involves the integrity of the election. So every rule that they promulgate, every policy that is made, however you want to say it, affects the Lumbee member if they're a voter, because it affects the outcome of the election and the integrity of the election, which is very important.
Do you think that the tribal council would have a legitimate concern that the elections board is attempting to make policies that they have not themselves made?
And if they do, they can fix it. That's the key to it all.
I do have a question of clarification, and I'm coming from a lay perspective, just to get a clearer understanding, and because I think there's a lot of confusion of the delineation between what the council reps do and the Board of Elections when it comes to this. On October the 5th, the Constitution Ordinance Committee meeting met, and it was recorded, and there were some comments made about what the Board of Elections can do, cannot do, versus what the council representatives can do and cannot do. And do we have that we can listen to just to get
Matt,
a point of clarification?
Mr. Roller, do you have that?
Yes, sir, I do.
So just last night, just so we're clear, everybody listening to this, last night, everybody, all the parties that are here in this room received a transcript of this recording. At this time, this recording is going to start. If you need to stretch your legs, probably now's the time to stand up and stay silent. This recording goes about 18 minutes. It's going to run. We're going to let it run in its entirety. And to the best of my recollection, the portion of this recording, this is a portion of the Tribal Council Elections, Constitution, and Ordinance Committee. These comments start on or about 1 hour, 10 minutes, and 45 seconds into the meeting that they had on October 5th. If you would play that loudly, Matt, so everybody can hear it.
Your Honor, permission to see it while we do this?
I'm sorry?
Permission to see it while they play?
Sure, absolutely. Yes, ma'am.
Next on the agenda is Tribal Elections Board residency definition. I got a copy of, evidently there was a complaint on residency, and the Elections Board developed a policy regarding residency. As far as my opinion goes with this, I think that the board was within its right to develop a policy on residency. I think that they're going to get a lot of response from this particular definition. I'm going to read an excerpt from a letter that states by Mr. Dr. Christopher Clark, Vice Chairman of the Lumbee Tribe of North Carolina Elections Board. It says, since the Lumbee Tribe of North Carolina's Constitution and Elections Board ordinances are both silent in defining principal place of residence, this board has adopted the following as a working definition for candidate certification purposes. That place shall be considered the residence of a person in which that person's habitation is fixed, and to which, whenever that person is absent, that person has the intention of returning. And it refers to some section that says it was an elections board policy, section 7, number 2, amended September 19th, 2021. And like I said, the board is within its rights to develop policy, and my position is to leave it as is, move forward, and allow the Lumbee people to deal with the policy, the new policy, amended policy regarding the elections board. I am very, very hesitant when you use something with intent, because intent's subjective. If it wasn't many years ago, there was a tribal council member who had an intention of resigning, and who even wrote a letter to state that fact, but for some reason it never happened. So the intentions may be honorable, but intent is a big, big, big area and very subjective. But I just wanted to bring that to the council, the Constitution and Ordinance Committee, and the tribal membership in attendance. I wanted to bring that to your attention, and I'm sure based on some Facebook warriors, we're going to see more regarding this particular policy. Is there anyone that has anything regarding this?
If I may, I think we're the lawmakers. I think we ought to make a law that defines what we intend and what we don't leave any ambiguity there. We have, I can speak from my own personal situation, what I was involved in. When I ran for the seat or was asked to run, I had my house, was going to sell it. My intentions was to stay in this district and to live there for 40 years. When I got my house under contract, I brought it to the council and the ethics committee. When I sold the house, I moved in with my daughter with the intentions of still moving. I purchased the land. I'm living on the land. I think the intentions, what is my uncles went to Baltimore or Maryland and Pennsylvania and lived, and they intended to come back home when they retired. So that was 30 years later. We keep that's a big window. You see what I'm saying? I think we need to close that window and make it within a certain time frame. If you're remodeling your house, naturally you're going to move back in that house when you get through remodeling. If you're building a house in another city and you just lived in another city in another state, and what's your intentions? You're going to build a house and let it sit there empty in another city out of our district. So I think we need to define it better to keep the ambiguity out of it. And I think that's what this committee and our laws should reflect. And we shouldn't change it after filing. You know, the rules that happen prior to filing, and I don't think they changed the rules, but they're trying to define it after filing. It should be defined before filing. So I just think we just need to be clear.
Thank you, Mr. Goolsby. Mr. Malachi?
Sorry, taking a look at the Constitution, Ms. Wendy, and that's the governing document that the election board follows. The Constitution does not define what residency is. It just simply says primary place of residency. But then if you look at the election board section, it only gives the election board the authority to, I am scrolling here, regulate under the authority of the Constitution. It doesn't give them the authority to define what the Constitution or the wording of the Constitution. So in my opinion, just based off what Mr. Goolsby said, it would be best of the interest of this committee to help redefine this or define or amend the Constitution to reflect a true definition or provide guidance to the election board. Because again, your opinion was that they're in their well, right? But in my opinion, just looking at the document of the Constitution, they only have the right to govern voter registration and to conduct all regular special tribal elections. They don't have the authority to define what primary residency is, what the Constitution defines it as. That's just my opinion.
I actually reached out to Dr. Arlinda Locklear, and I reached out to her regarding the constitutionality of whether they were creating law versus creating policy. That's a big gamut. Dr. Locklear, if you give me just a second. Trying to see where I've got her email out. But Dr. Locklear stated that she felt they were within their right to determine policy. She did not feel that it was amending the Constitution for them to end election practices, even though I agree that the mention of intention is too broad an area. I agree with that. I just want to get feedback from the committee to see how they feel we need to proceed. And I do greatly appreciate your interpretation, Mr. Malachi. Thank you.
Miss to define Constitution. One is in these chambers of law, another is in the court system. So I think that's what we find.
Based on the Constitution, the only way to amend that document is through referendum. You have to go to the Lumbee people to amend the Constitution. We, as tribal council, don't have the authority to do it. The Supreme Court doesn't have the authority to do it, nor does the tribal chairman or any other board have the authority to do that. That power lies in the people themselves. Mr. Corbin?
Yes, ma'am. Um, in reading Dr. Clark's letter, the first thing that caught me, of course, besides the definition, was the initial wording where it said, since the tribe's constitution and our election board ordinance didn't, or were both silent. I think that's the key thing. I agree with Mr. Goolsby. Having served for 5 years now, I have seen just multiple situations. A lot of times we get caught up in black and white, reading it moving forward. But when you start talking about buying and selling a home, renovating a home, totally moving out of your district, I've mentioned a number of times that we don't have anything that says once you represent or are elected in to represent a district that you continue to reside there. I think we really need to take some time. We got this information today, but I think we need to start now talking to people, doing our own research, really thinking through what a council member is going to go through in 3 years' time, and what's best for the people to make sure they get adequate representation. But I think it is on this committee and this council's shoulders to tell the election board what our definition is, as we've heard from our people. Thank you.
Am I? Okay, I apologize. When we wrote the Constitution, we were under the impression that when you write something, people's gonna follow it. But we didn't do the devil's advocate thing. We didn't take into consideration that sometimes there are things as much as a natural disaster that could happen that could cause a person to have to leave their primary place of residence or their principal residence. That's happened to many of our tribal membership in 2016 and 2018. So I think we've got a lot to consider with regard to the residency issue. I think we just need to look at the elections board ordinance as a whole, because from my understanding, per Miss Louise's request, she requested that we look at the elections board versus a court hearing, and the court opinion seems to be in direct conflict with the elections ordinance. So if we could have a motion to reconsider the elections ordinance and look into these issues, I would greatly appreciate a motion regarding looking at the elections board ordinance.
Miss Moore, Madam Chair.
Yes, Mr. Oxendine.
So could we consider accepting their statement as of now till we can further review it thoroughly? Can we do that, or you're saying that's in conflict with what our opinion of how that should be?
No, I was more than willing to let the Lumbee people decide how to deal with the elections board with regard to their definition. But looking at the elections ordinance, we can look at that, because they're saying they're not amending the Constitution, they're actually defining it for the purposes of their policy.
And their policy aligns with our committee's thought on that? I mean,
I have not seen their policy, sir.
There was a statement that Dr. Clark shared with us in there. Do we accept that? Does that seem reasonable? Or are we going to try to define it better for them?
I think we're obligated to do better.
Okay.
We are looking at a statement that is Katie bar the door kind of statement, and it's the ambiguity will be something that we're going to deal with if we allow it to go forward. It will be something that the Lumbee people will deal with for some time to come. What's the wishes of the committee? Mr. Richard?
Yes, ma'am. My question was, did I hear Mr. Gooseby say they made the policy after the filing? Is that what you said, Mr. Gooseby?
They come with a definition after the filing. Is that correct? Ain't that what it did? Yeah, they come with a definition after, because there was, I think there was a complaint or something filed, and then they defined it after the filing.
Okay, thank
you. It does not look well to do a definition after the election process begins, because people already have their opinion of what principal residence is, and I'm sure any candidate that filed had their idea of what principal residence was. For it to be something that's done in the midst of an ongoing election like that, it causes me pause, to say the least. Does anyone else have any recommendations of how to proceed?
I know I'm speaking a lot, but Madam Chair, I agree with you on it. It gives me pause. It makes it look like the election board is showing, or we the ones that get the blame for it, showing favoritism and bending the rules for a particular candidate, whoever that candidate is. And I think it needs to go back. They got to have proof of residency the year before they file, and leave it at that for this election cycle, and do a deeper definition for the ones here forward. Because that's the Constitution. And I didn't intend, I don't want anybody to think I was saying change the Constitution earlier. I was saying we write the laws to support the Constitution, and the court system is the other part. So I think it needs to stay the same.
Miss Jennifer? Miss Jennifer?
Sorry, that was good stuff y'all missed. I was on mute. So they're not trying to retroactive this definition, correct?
It's now.
Can you hear me?
I can't tell you what they were trying to do. I can't speak for Dr. Clark, but it looks, based on the definition coming in the midst of an election, it looks like they were trying to do something that should have been done prior to the onset of any election. It shouldn't be in the middle of the cycle or almost at the end of it, at the filing.
Okay.
And it also came, I think, after a complaint or something. I think that's why they had an issue.
Well, I mean, I can appreciate them attempting to put something in place going forward, but it's irrelevant to the current election, or it should be. And that definition, at best, council should shoot it down. That to say that my primary residence is determined by the fact that it's a fixed place that I intend to return to when I leave the house, that's anytime I'm down home, I'm going right on back to where it is that whoever I'm staying with family. So that's more problematic than what they currently do or don't have. That's just my opinion.
Thank you, Miss Jennifer.
Miss Wendy.
Yes, Mr. Corbin.
I would suggest that moving forward, we do put the ethics ordinance on the next committee meeting agenda and that we begin the process. Don't expect us to do it in one meeting, but we begin the process of defining residency and residency requirements so that there won't be a question or a need for a policy development by the election board going forward.
So, did you say ethics or election?
I'm sorry.
I
I've
know
got
you
ethics.
got
Yes,
ethics
I've
on
got
you.
it on I'm sorry. The election ordinance. Thank you, ma'am.
Okay. Do you move forward with that? Is that a
Yes,
motion?
ma'am, that we put that on the agenda for the next meeting. Yes, ma'am.
Restate it for the secretary, please.
I would make a motion that we put the elections ordinance on the agenda for our next CNO committee meeting as we begin to, for one, look at residency definitions.
I have a motion by Mr. Eddings to put the elections board ordinance on the table for the next Constitution and Ordinance Committee meeting. And I have a second by Speaker Burnett. Any discussion?
I have some discussion on that.
Yes,
Ms. Moore.
Okay, Mr. Oxendine and then Ms. Barfield.
I would just maybe consider adding to that motion the language where we are accepting the recommendation from the elections board until we're able to review at the next meeting. Because that's what we're doing, seems like, if we're not making a decision tonight.
I don't know about about anybody else's interpretation, but we are not moving to accept this policy at any. I'm not. Now I can't speak for anybody else on this committee, but I'm not moving to do that.
Miss Wendy.
Yes, sir.
Yes, ma'am. If we begin accepting or rejecting policies, I think we've stepped outside of the line. I don't know that we've accepted any administrative policies, any election board policies in the past. I think this was something they did in their capacity as the election board, which we did appoint. But I agree. I don't feel this is something that we would accept or reject. That if we want to correct it, we correct it through writing or amending law.
Ms. Leclerc. Miss Carbeckis, I apologize, Miss Rebecca. Miss Carbeckis had her hand up too. I'm sorry. Miss Carbeckis.
My question to, I hope you can hear me well. Bad reception because of the weather. But what my concern is and what I need clarified, what do we do with this at the present time with this particular election? That's my question.
Based on Mr. Eddings' we have no authority to accept or reject their policy. We've never done anybody's policies, but we do have the right to review the ordinance. As far as whether or not, what impact it has on this election, if someone brought charges against the elections board for unethical behavior of adopting a policy in the middle of an ongoing election, that could be something that might be viable. I really don't know, Ms. Carbeckis, because we're dealing with policy. Ms. Rebecca?
I'm good, Wendy. I don't have a question now.
Mr. Malachi?
Just as a question, it sounds like the motion that Corbin made was to review the election ordinance. insight into how the election process should take place. So it sounds like the ordinance would be amended if that's the case, but still, though, the Constitution says primary principal residency. So that's where I'm questioning whether or not are we providing a definition of that, or are you amending the Constitution? Because if you're amending the Constitution, then, as you said, Ms. Wendy, it requires the vote of the people. So the ordinance does not mention anything about residency. It just gives the governance of the election board and how our election process should work. The Constitution defines residency, and according to definitions of tax purposes, primary residency is the place that the person mainly lives at. So again, that's where my question is. If you're amending or defining what that definition is, then it's required to go through the Constitution process, not an ordinance, because that ordinance does not reference residency. Just giving clarity or asking the question as well.
To my knowledge, Mr. Malachi, there is no reference of residency, period. There's principal, there's a primary principal place, but as far as the definition, we're not going to amend the Constitution by no stretch of the imagination. We're just looking at the Elections Board ordinance and moving forward to see how we can proceed without impacting the dynamic of the existing Constitution as it stands. Anyone else?
I think I agree with what he said about the Constitution. I think right now we're looking at defining the Constitution. Right now, the current election, I don't think anybody's got a leg to stand on unless they go to Supreme Court as it relates to a challenge of this particular statement or anybody's right to run. It would be the Supreme Court that would have to decide that. We can make laws, but right now, I don't think we can do anything about the current situation other than ever who wants to file a complaint to the court and let the court decide.
And that was my position from the very beginning, was to let it be as it is. And if anybody feels that they want to challenge it, they're welcome to. But we will be looking at the Elections Board ordinance in November. We have a motion on the floor that's been duly seconded. Madam Secretary, roll call.
Mr. Ted Waddell,
Yes. Yes.
Ms. Carvectis Barfield,
Yes.
Mr. Joel Goolsby,
Yes.
Mr. Harold Smith,
Yes.
Ms. Pam Hunt, Mr. Terry Hunt,
Yes.
Mr. Carrington Locklear,
Yes.
Mr. Larry Chavis,
Yes.
Mr. Richard Jones,
Yes.
Mr. Reginald Oxendine,
Yes.
Miss Yvonne Dial,
Yes.
Mr. Alvin Mercer,
Yes.
Mr. Corbin Eddings,
Yes.
Mr. Joey McNeil,
Yes.
Ms. Marshall Locklear,
Yes.
Ms. Chuckawanna Oxendine,
Yes.
Mr. Shelley Strickland, Miss Annie Taylor,
Yes.
Mr. Ricky Burnett,
Yes.
Miss Wendy Moore.
Yes.
Passed.
Okay, so the Constitution and Ordinance Committee will be reviewing the Elections Board ordinance in November. The next order.
Okay, so this court, from your own words, is that is part of our record. That is an official recording, transcribed and oral. The parties have the transcribed version, and that's not a fancy reviewed version because that costs money. So that's why you got the fast draft, and that's why I played it. So if you wanted to follow along, but the court that will be part, and that is part, if we move to this next phase after lunch, that will be part of the information that this court considers. And for the record, unless I'm corrected in my next few comments by someone from the tribal administration, it's my understanding that a gentleman that spoke by the name of Mr. Malachi and the woman that spoke by the name of Miss Jennifer, both of those individuals are not members of the tribal council. Is that correct, Mr. Roller?
Yes, sir, that's correct.
So those were community members. The way the tribal council has recently started carrying out its meetings in the virtual world is they allow tribal citizens, to my understanding, and I actually don't know that that's a threshold matter, they allow folks to speak. So the court has not considered any of the comments related to Malachi and Jennifer, because in our opinion, those are not germane to us better understanding, as I made reference to Ms. Graham earlier, what the people that are more closely associated with our tribal members, the elected members of our tribal government, and how they view the actions of the election board, but more importantly, how they view their authority and where the power resides to make changes, and in Mr. Brooks's so eloquent words earlier, although they didn't talk about it, to limit our tribal members' ability to participate in our form of government. Mr. Tippett, Mr. Locklear, and Ms. Graham, unless the court has something else, we're going to go on break, and it's our intention to reconvene, folks, at 2:10 p.m. Does anyone have anything they need to get off their chest before we take a break? Locklear, Tippett, or Graham?
No.
All right, we're on break until Please be seated. It's 2:13 on August 14th. It's 2:14 on August 14th, reconvening of the Lumbee tribe of North Carolina. Are we ready to move forward? Mr. Locklear?
Yes, sir.
Mr. Tippett?
Mr. Oxendine is in the building. He's right there. Yes, sir, we are.
Ms. Graham?
Yes, sir.
Okay.
Just prior to our lunch recess, is what I believe the candidates had made some final remarks concerning the preliminary matters before we move forward. Are there any brief remarks by any of the parties as it relates to the preliminary issues that we've discussed? Hearing none, the court has decided that it has proper jurisdiction to hear this case. The court has decided that this is a sufficiently pled controversy for the court, that the court does have original jurisdiction to hear all controversies as it relates to the Constitution. The petitioner has alleged that Mr. Ronald Oxendine, the respondent who has filed to run as chairperson for the Lumbee tribe, an action that has been certified by the Lumbee Tribe Elections Board, is unconstitutional based on a residency requirement that is named in the Constitution. At this time, we will move into the substantive hearing of this matter, and we will direct the court, or direct the proceedings to the petitioner. Mr. Locklear, you may present.
Before we do that, Your Honor, did the court rule on where the burden lies?
Court has considered that thoroughly today, yesterday, just about every day this week. We tend to agree with counsel that...
Which counsel?
You, at least as it relates in the, in your, I don't believe it, we don't necessarily agree with your conclusion, but we agree with the statement that you made earlier that the standard of proof in this matter is much more consequential than the burden of proof, meaning that what is the greater weight of the evidence holds much more than the burden of proof in this matter. We have not made a decision as to burden of proof in this matter. We do not believe that we need at this time to make a determination on who the burden of proof is on. We believe that the court can hear the evidence, can make a determination as to what the greater weight of the evidence is in this matter, and make it a conclusion of whether or not Mr. Ronald Oxendine meets, forgive me if I've misspoken your name, Mr. Oxendine, Mr. Ron Oxendine has met the residency requirement.
Okay, well, petitioners ready to go forward. We call our first witness, and that'd be Ron Oxendine.
So as we move forward, any documents that you're...
Give it back to me.
Just hold on one second. While Mr. Brooks, Justice Brooks is talking about that. So on a go-forward basis, the way we're going to handle this, Matt, is when the folks are testifying, if they present any evidence, Mr. Tippett, I don't think Ms. Graham, this is going to really be an issue for you, but Mr. Tippett, Mr. Locklear, Judge Locklear, we're going to do like we do in a traditional court. If you'll hand stuff over, gonna mark it so it can be part of the record and things like that. The guy in the pink tie is the one we want to hand stuff to, if that's okay.
Your Honor, this is one of those procedural moments. I'd like to just raise this issue.
Yes, sir, absolutely, go ahead.
Since we've moved past what I'll call some of those earlier issues, I understand that Mr. Locklear needs to ask questions of my witness. It may be more efficient if I were to ask him questions.
Well, Justice Brooks is getting ready to be instructive as to
sorry.
the petitioner on some things.
Counselor Locklear, after conferencing with the rest of the justices, it is our position that before we permit you to call Mr. Oxendine as a witness, we would ask you to present other evidence prior to that.
Well, it's certainly, you make the rules here. I don't quite understand or appreciate that, but you make the rules. So we'll call the petitioner, David Locklear. In terms of going forward, can I sit here rather than go up there? Or
Yeah, he can go, he's going to go up. So the people that are testifying are the ones going up. If there's not a Bible up there, Mr. Locklear, let me know and we'll get you one handed up. And to be clear, while he's walking up, Mr. Locklear, it's the court's opinion that you need to proffer evidence. The amount of evidence, that's up to you, you're the lawyer, but you've got to present some evidence to this court so we can see and understand and have a better understanding of what your assertions are. Does that make sense?
Well, again, I hear you. I think we've made a proper showing in the petition, certainly a basic showing, and I think that should get us past any motion. And well, no, it wouldn't, not until we call Mr. Oxendine. I strongly disagree with the procedure that says the petitioner's got to go first. I mean, that's the court telling us which witnesses we can call.
Well, I think as Justice Brooks has informed, we're going to hear from the parties, but you're going to have to present your information first. Obviously, you know better than I do, certainly. You present your person, there'll be redirect and all that good stuff, and you'll have an opportunity to ask additional questions, but that's what the court's decided.
All right. Mr. Locklear sworn.
You put your hand on is there a Bible up there, Mr. Locklear?
Oh.
You want to swear or affirm, Mr. Locklear?
Term, either one, either.
You place your left hand on the Bible, raise your right hand. Do you swear or affirm the testimony that you're about to give this court, the tribal court of the Lumbee tribe of North Carolina, shall be true and correct to the best of your ability?
I do.
All right, thank you, Your Honors. Say your name loudly. Say your name loudly.
I can't understand it.
Say your name, please.
David Locklear.
Where do you live, Mr. Locklear?
I live at 2822 Saddle Tree Road, Lumberton, North Carolina, 28360.
Member of the Lumbee tribe?
I am a member of the Lumbee tribe.
Do you know your enrollment number?
I am enrolled.
Do you know it?
No, I don't know it right off, but I got it in my pocket here.
That's good. You don't have to show it till somebody challenges you, I guess. Mr. Locklear, you are the petitioner in this matter.
Yes.
What caused you concern or consternation or whatever the word might be? In other words, why are you here? Why'd you hire me?
Well, Your Honor, ever since this tribal chairman election got started, there's been a cloud hanging over the tribal election. The cloud is about Mr. Ron Oxendine. I know he was away from here for several years. All at once, he showed back up, filed to run for tribal chairman. Okay? Nobody could really tell us where he lived, how long he had been there, or any of that. I know over the past several years, I've been hearing about Ron Oxendine through the tribe, about forming businesses with the tribe and his different standings with the tribe. All at once, I heard that he had been relieved of his duties with some of the tribe holdings. Okay, now he's come back and want to run for tribal chairman. Why is this? You know, why is it? From what I gather, talking to some of the tribal members, he's getting a percentage of the business. He's getting what he asked for to start with. Is he coming back to get a lot more? That's the cloud that's hanging over people.
Mr. Locklear,
Yes.
Judge Locklear,
Yes, sir.
I'm going to ask that you make an inquiry as to your witness, that he testify as to matters related to what we're here today about, which my understanding is,
Yes.
court's understanding is, we're here today to hear matters related to a constitutional residency or / domicile challenge to Mr. Ron Oxendine.
Best information you have, Mr. Locklear, what state did Mr. Oxendine move from to North Carolina, to the territory?
Well, I went to a political rally 2 weeks ago. I met Mr. Oxendine, and I heard him talk at that rally. And he told us he moved from Virginia down here to take care, him and his wife moved down here to take care of his mother-in-law.
I do have some documents, if Your Honor's.
And from my understanding, they moved to Hezekiah Road. But they never did give us a date when he moved there.
All righty. Thank you, Mr. Locklear. I do have some documents, Your Honor. I should go
Sure.
have them stamped, I guess.
You can just mark it, Matt. And what is it you're marking, Mr. Locklear, Judge Locklear? So for the record, I understand Judge Locklear, attorney for petitioner, is getting marked a voter registration document. Okay, I'll wait for you to hand that up and then you can proceed.
1300 Crystal Drive, Arlington, Virginia.
How are you marking the first, how did you mark the first item, Matt?
Petitioner Exhibit A, second one will be Petitioner Exhibit B.
And what are you referring to Exhibit B as, Matt?
The Google search.
Okay, and I assume, Judge Locklear, you have a copy of that to give to Mr. Tippett? Okay, at the earliest opportunity, if you would allow Mr. Tippett to review those before you speak with your witness about those. Mr. Tippett, is that sufficient?
I certainly don't stipulate that these are authentic or useful legal evidence, and I certainly have a problem with the fact that these are the only copies in the building.
Sure, that's why I want to give you a minute, Mr. Tippett.
Well, I object. These documents have not been authenticated to prove anything in particular.
Okay, sir.
Thank you for showing them to me.
Way of saying he doesn't want them in. That's all.
Doesn't know what?
That is. I mean, you said yourself.
Speaking in the microphone, Judge.
You said yourself, Chief, the rules in Lumberton and in Raleigh and the
So go
Supreme
ahead.
Court don't apply.
You can sit down, Mr. Tippett. If you'd go ahead and establish the basis for which you're presenting the information to us,
All
Judge.
right, need to show them to my client, of course.
We would.
Mr. Tippett, the court does take note of your objection. I do want to remind the parties that early on in this proceeding, that this court, unlike other courts, as Mr. Gary Locklear has pointed out, we are under no obligation to apply the rules of evidence under the state of North Carolina. As far as this hearing is concerned, the court is reserving the right to give proportionate weight to each article of evidence, and this court will make an independent ruling as it relates to each piece of evidence that is presented, whether or not the court finds it credible.
Thank you, Judge. And just to make sure that everyone knows the point of my remark, I'm like Judge Locklear, and each of you could really cite some pretty objections, but my point is really, is this reliable? And Judge Brooks, your remarks seem to focus on that, is the court should only weigh reliable evidence. And a photocopy off of Google doesn't count for much anywhere, but that's my point.
Well, I mean, that's easy. Put him on the stand, he's got the information.
Hold on,
Tell
Judge.
us.
Hold on. I just want to make sure. So the documents I'm looking at, Exhibit A, appears to be a printout from a website which is controlled based on its appearance. Appears to be a printout from the North Carolina State Board of Elections. The second document is Exhibit B and does appear to be a printout from Google, I agree with that 100%. Here we go. Thank you. Mr. Locklear.
All right, Mr. Locklear, can you hear me?
Yes, I can.
All righty, the document that's marked plaintiffs or other petitioners A, I believe. They're both on one page, but it's kind of pre-printed stuff. There's no picture on it. You see that? See that document?
Yes,
What's the name on it? Up at the top.
up at the top. Ronnie Oxendine,
The address?
1837 Hezekiah Road, Maxton, North Carolina, 28364.
What does that document appear to be?
It appears to be a registration document
What kind of registration?
for automobile, for voter. Wait just a minute now. An active member.
We could
It's a-
speed up this process if the court
Right.
would allow me to lead my client. I mean, it just is what it is.
You can ask him to refer to the document.
Say again?
You can ask him to tell you what the document is, Judge.
I did. What is it, Mr. Locklear?
It's registered in the county of Robeson County, and a voter registration number's on it.
Okay.
North Carolina ID, which has a number for it at the party.
Anything on there about driver's license at all?
American Indian or Alaskan Native.
What's the date on it? That's
The
the
date.
crucial thing. What is the date on that?
1/21/2021.
So that's January 21st.
January 21 of 21, year 21.
All righty, thank you. And the next document, take a look at that.
Yes.
What does that appear to be?
It says Crystal Gateway Condominium on the top of it, and it's got an address on it of 1300 Crystal Drive, Arlington, Virginia, 223202.
Do you recognize that address as being Mr. Oxendine's former address?
I don't know what his former address was.
Okay, fair enough. All righty, I have some other documents, if Your Honors please. They're marked.
What are you attempting to proffer at this time, Mr. Locklear?
Well, we got some information about land he has purchased. We've got information about offices he holds out of state and the address and the date that was updated. Resumes of Mr. Oxendine listing Arlington address.
It may be simpler, Mr. Locklear, if we take these item by item.
Okay, please.
If you'll share that with Mr. Tippett.
All right.
Then share that with the court.
Thank you, sir. Good.
For the record, it is a challenge for a panel of justices to make a decision independent of one another about the admissibility of these documents. Mr. Locklear, Mr. Tippett, I apologize. So my intention is, or the court's intention is that once the petitioner has completed an attempt to present his documents, the court will take a brief recess to consider the admissibility of these documents based on what we find to be credible, presentable, and then we'll make a ruling about what is admitted. Fair enough?
Yes, Your Honor. Just 2 quick points. I think you've got 2 issues to look at. Is first, is it reliably anything? Like, because this has not been authenticated. It may or may not be what it appears to be. And second, it is not yet known to the court or to me what he suggests this actually proves. And that's going to be probably the bigger focus is what does this prove?
I believe the court can afford at this time some discretion to Mr. Locklear to give him an opportunity, once he's presented these, to explain to the court the purpose in providing them.
Yes, Your Honor. Thank you.
Mr. Locklear handed you, I think that's C, I'm not certain. What does it say on the front? Petitioner's exhibit. Is there a number up there, a letter rather?
I'm having a little problem hearing you because of the fan over here, Gary. I'm sorry.
All righty, you have a document in your hand.
Right.
What does it appear to be on the face?
Search of a real estate, and it's a deed. It's showing a deed for Moore County, Register of Deeds, Judy Martin registered, and
You tell whose name it's in?
it's in Moore County.
No, and the individual's name. Can you tell what individual? You may have to flip a page, I don't know.
Okay, let me look. Mr. Ron Oxendine.
Is there a date on there?
5/11/2021.
May 11th of 20.
May the 11th of 2021.
Will you flip over a page or two and see if there's like another title to the next series of pages?
Yeah, there's a deed of trust here.
Whose name?
Just a minute.
Flip a page if necessary to get to a name if you can find one.
Yeah. Ron Oxendine.
All righty, deed of trust, do you know what amount that deed of trust is in? How much money?
I'm sorry, Mr. Tippett, speak up.
Said objection, irrelevant.
You can proceed, Mr. Locklear. I believe it's relevant.
I'm sorry, I don't see the amount of money, Gary.
Well, there are several pages there. As quickly as you can, if you'd flip through them.
Mr. Locklear, the court wishes to be fair to Mr. David Locklear. But just for clarity, because of the time that is expiring, can you rephrase the question to Mr. Locklear so both we will know exactly what the question is again and that he also will know?
The question is, do you find an amount of money listed in the deed?
I might be overlooking it, Gary,
All right,
but I don't see none.
Fair enough. Well, if I might be heard, Your Honors, momentarily.
Heard?
Yeah, heard. They will listen to me. When we walk through the door, I understand you make the rules here, but it was our intention to solicit. We don't have to have paperwork. We got tons of questions we can ask where we don't have to have a copy of anything, because Mr. Oxendine's got the answer in his mind. He can speak it. We don't have to show him any paperwork. He knows the answer that's on that document right there, for that matter. In the interest of time, I'll concede. I didn't go over every one of these pieces of paper with my client, and that's why he's having trouble locating the answer. But what's more important here? The fact that he can't find the amount on the deed of trust, or that the Lumbee people know that they feel secure in who's running for tribal chair, who's going to be their leader. Now, if you're going to let rules keep us from presenting our case, then I'm sorry,
Well, Judge,
then I've let the Lumbee people down.
sure, I understand what you're saying. I'll speak briefly, then I'll turn it over to Justice Brooks. This court is going to afford Mr. Oxendine the rights, and I'll loosely word it as the privileges that he has as a tribal member. And if he has been questioned as to his residency, the petitioner, as we've set forth a few minutes ago by the sequence for which we've called, you're going to have to present some showing to us. You're going to have to present some showing. As I said earlier, the amount of showing is up to you. You're going to have to present some showing to this court that there's a valid basis for Mr. Locklear to question Mr. Oxendine's residency. That's the most fair thing, in my opinion, speaking in individual justice, for Mr. Oxendine. It would be unfair for this court to just say, based on recollection or based on what I heard, or because Mr. Oxendine said at a meeting 2 nights ago that he used to live in Virginia, that creates some doubt in Mr. Locklear's mind. He's got to answer some questions now that he's under oath about some things. I mean, you and Mr. Tippett know what this is about. This is about, the Constitution says basically, generically, that Mr. Oxendine, it uses the word, and I'm shortening it, that his residence was here 1 year prior to what I agree with you earlier, because it's not set forth, but the date is 1 January, that within a 12-month period, you've got to, your client, has got to present something to this court where he has a good faith basis for questioning Ron Oxendine's residency. This is your chance to do that. How many documents you give to your client to testify to and to state dates for this court is up to you, but there's got to be some showing to the court. Mr. Brooks, if you'd clarify that.
And as it stands, and I'll give, Counselor Locklear, I'll give you an opportunity, the court will afford you an opportunity to argue to the court what these items that you're intending to introduce, what their purpose are, and what purpose you're using them for. But as it stands right now, the court has heard testimony from Mr. Locklear that he overheard Mr. Oxendine say at a recent gathering that he had recently moved to the area from out of the area. There's also been a document that has been submitted to the court that has been testified about concerning a voter registration document dated January the 21st of 2021. And there has been a Google map that has been presented to the court that shows an address in Arlington, Virginia, but without any statement or any knowledge as to the owner of that property. And most currently, we have been presented with a deed of trust that Mr. Locklear has testified is in the name of a Ronnie Oxendine. And I believe that your most recent question was concerning the amount, dated in May. I do believe, for the benefit of all parties and for the benefit of this court, that the court should take a 10-minute recess to convene with one another to discuss how we're going to handle these to the presentation of evidence going forward and objections to that evidence. So we're going to stand down for 10 minutes. Time 3:05. We will reconvene at 3:05.
You may be seated, please. It's 3:04 p.m. on Thursday, October 14th. This is continuation of a hearing. David Locklear v. Ron Oxendine and the Lumbee Tribe Board of Elections. I'll turn it over to Justice Brooks.
So going forward, we're going to act accordingly with what I had mentioned previously. The parties will present evidence. The parties will, if they have documentation that they want to offer to the court, they will allow the opposing counsel to review that. Counsel will then make that available to the justices to take a look at. Counsel will then question their witness, argue to the court the purpose that it's intended to be used for. The court will keep a log of the evidence that is attempting to be presented to the court, and at which time, after opposing counsel has an opportunity to question that evidence, the court will conference together once more and make a determination on which items presented the court will allow to be admitted as evidence. Mr. Locklear, we'll turn the floor back over to you.
For the record, you are David Locklear, and you're still under oath, correct?
Right.
All right, Mr. Locklear, did you have an opportunity to review those items that you previously looked at?
I have.
As to item A, do you now know what it is?
Yeah, it's a voter registration.
And I understand we're repeating ourselves, but what's the date?
The date is January 21, 2021.
Is there anything on there to suggest that Mr. Oxendine received his license on that same day?
Yes.
What is that?
From the DMV, a DMV customer.
And how do you know? What does it say? Next to DMV, what does it say?
It shows registration date.
Date?
Date.
Okay.
It's 1/21/2021.
All right. And moving to the next document, I think that was a multi-page, no, that was a two-page document, a Google search of 1300 Crystal Avenue, I believe.
1300 Crystal Drive, Arlington, Virginia.
What is your understanding of the significance of that address?
It indicates that it's Mr. Ron Oxendine's address.
All righty.
His home address in Arlington, Virginia.
All right, move to the next document. It's a multi-page document, I believe, correct? The next one.
Okay.
Got it?
Got it.
All righty. The question when you were earlier looking at it is, you said that was a deed of trust. Do you now know in what amount and in whose name? I think you got the name in already, but repeat it.
It's Ron Oxendine.
And the deed of trust amount?
May 10th of 21.
That's the date, of course.
Right.
And what amount is the deed of trust for?
Oh, just a minute. I saw it back here just a minute. We've got it highlighted. Okay, it's $816,500.
All right. Thank you. Members of the court, I've shown, I think,
Yes, sir. Mr. Locklear, what do you want me to do? You want these back? Okay, thank you. Mr. Locklear, just to clarify any confusion, your last exhibit that you presented was Exhibit C.
Yes,
You have handed up Exhibits D and G.
correct.
Is there a reason for a gap?
I skipped one. I'm
E and
not
F?
going to present one.
Okay, all right, just making sure.
Thank you.
Counselor. Please, thank you. Back on the record, Your Honors. Mr. Locklear, what's the last item you have by way of letter number?
C and D.
Okay. Then I hand you what's been marked. And what does that document appear to be? What kind of paper writing is that?
It's showing that RMB Holdings and registration of some fees and stuff, and the status date on them is 10/2/2021.
October 2nd, 21. Do you see the name of Ron Oxendine on there?
Yeah, Ron Oxendine's on it, yes.
Right.
And, yeah.
Which exhibit is this?
But
What's the letter number on the front of it?
Exhibit E, D.
D as in Delta?
D.
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 Yeah.
You have G with you in front of you. Look and see if you have G or not.
Yeah, D. That's D.
G.
C. I'm sorry.
As in Gary.
Gary. G. No, I don't have G. I don't think I have G at all. No.
Are you? I'll skip it.
Okay. R&B Holdings, Ron Oxendine, Business Development Program.
It's got a date on it? Or a date that he was involved with that company for?
10/21.
Does it say for how long?
Okay.
10/21, October 21?
It says his experience as president and CEO of RB Holdings from October 20 to the present is 1 year and 1 month. Arlington, Virginia, Arlington, Virginia, United States.
All right, thank you. And your petitioner's age? You recognize that document?
Yeah.
What is it?
It's showing Ron Oxendine's former address, which is 1300 Crystal Drive, Arlington, Virginia.
What kind of document is that, or what does it appear to show?
It's to the Lumbee Tribe Enterprises, LLC, Vice President of Operations.
Has he got a is there a list of jobs that he has held, for example, on that?
Yeah, it's a list of jobs, and there's also President, CEO, Vice Program Manager from July 1 of 20. I'm sorry, July 2000 to October 1 of 2012.
Okay, those dates are way back yonder, of course.
Yeah.
What address again is on that document under his name?
Say that again.
What address is under his name?
On the residence is given at 1300 Crystal Drive,
Thank you.
305, Virginia.
Last document I won't show you. That is I. What does that appear to be?
That's a copy of a license plate, and the license plate says Arlington, Virginia, and it's 10703K.
Now, can you make out that that is a Virginia license plate or not?
looks like 1021.
But can you discern, can you figure out that it's a Virginia license plate?
Yes, I can read the
or a
license
license plate holder?
Yeah, I can read the license plate holder.
Okay. Do you know the source of, you know where that picture's supposed to come from? Where it came from, period?
I have no idea, but it looks like it's on a General Motors product, Cadillac.
Okay. You don't know what Mr. Locklear or any of his family drive in, do you?
No, I don't.
All right. Those are my questions, Your Honors, of David.
Mr. Locklear, you have presented exhibits A, B, C, D, G, F, H, and I. I understood you to say that one was missing. Would that be in exhibit E?
I think that's right.
Okay. Would you present to the court purpose for which you intend to offer these exhibits? Would you argue them to the court?
On all of them. Okay. Okay.
Let's start at the top. We've offered Exhibit A to show that Mr. Oxendine he didn't renew. He got a North Carolina driver's license on the 21st of January. And while he registered for a license, he automatically was registered to vote in North Carolina. Not with the tribe or anything like that, but obviously in state municipal elections, things like that. But anyway, the date of January 21 is obviously important because that's inside the year, the term of the year that he must meet. I understand he didn't have to go get a license the day he moved down here. We don't know what day he moved down here. Elections Board wouldn't tell us what day he claims. But he was here from the time he's got on his application that we don't know what it is until January 21st before he ever got a license.
Just go through the evidence, if you wouldn't mind.
Thank you. Item B is a Google map and photo of the address listed on numerous documents, well, not necessarily documents, but web searches for Mr. Oxendine's residence in Virginia, 1300 Crystal Drive, Arlington, Virginia. That's what that shows, is a picture of it, is where it's located.
Is it your contention, Mr. Locklear, that that's being offered to show proof of that address exists, or?
Yes.
Proof that the address exists.
Well, it's listed in a lot of different documents. If it doesn't exist.
No, that's just make sure. You're offering that to the court to show that 1300 Crystal Drive, Virginia exists.
That's first, that it exists, correct. And secondly, that that's either is now or was his residence. We'll get to that.
Okay, proceed.
C, petitioner C is a record of the recording of a deed in Moore County, done May 11th, 2021. That's certainly inside the year. Just a few months back, $816,000, well, actually in $5 more, deed of trust for a house in Moore County.
Of whom? Deed of trust of whom?
As my client testified to, Ronnie Oxendine, and he might not have said wife, but Tina Oxendine, but I know he testified that Ronnie Oxendine's deed of trust. I think D is the next exhibit, and that's a search of the Virginia Secretary of State's website that shows R&B Holdings and who the principals are and such as that. List the chief executive officer is Ron Oxendine. It lists 1300 Crystal Drive Apartment, 305. and it says last updated of October 7th.
October 7th,
I'm sorry,
2021?
21, my mistake, I apologize.
And what exhibit was that?
That was D, and that tends to show his business interests are in Virginia. And I know there's a counter argument to that. No, we'll see. The burden right now, well, I don't get to argue yet. A, B, C, D. F, petitioner's F, we skipped to E, of course. That is a resume of Ron Oxendine. Again, stating his experience, and as my client testified to, it says he's president and CEO of R&B Holdings from October 2020 until present, and then he has 1 year and 1 month. So that would take us to current. List an Arlington address. It doesn't have the specific address that we talked about, the Crystal Avenue, 1300, whatever, but it does have an Arlington address. Tends to show, of course, what it shows. G, another resume. It was posted November 5th of 2020. That's outside the 1 year, but it is some evidence that when he posted this resume, he was looking for a job somewhere and was willing to at least discuss it with somebody because he put it out there for discussion.
And is that, are you asserting that that shows that he's living in Maxton or what? Well,
That doesn't show, it's got his name, I'm sorry. It's got his name as Ron Oxendine with an Arlington, Virginia address.
Arlington, Virginia?
Arlington, Virginia address. It was posted on November 5th. This is 2020 now, as opposed to the current year. And finally, petitioner's H is no, it's not the last one, I'm sorry. It's a resume of Ron Oxendine listing 1300 Crystal Drive, and admittedly, there's no date, but it's online and can be found. It hasn't been taken down. The date hasn't been changed. The address hasn't been changed. Still lists the Arlington, Virginia address. And lastly is a photograph of a car that appears to be registered in Virginia. You said that I could argue. I would argue that this is a vehicle of Ron Oxendine or a family member. And it's still got appears to have a Virginia license on it. And that would be some evidence. Of course, at the appropriate time, I would certainly want to be heard as to what all this means.
You would agree, at least as it relates to Exhibit I, that there was no evidence presented before the court that car, in fact, belonged to either Mr. Oxendine or a family member.
I'll agree.
I do believe that Mr. Tippett has a right to cross-examine Mr. Locklear. Before doing so, Mr. Tippett, I know that you initially made an objection that the court is aware of. The court is treating that as a running objection to each of these matters. The court, at the appropriate time, will take these matters under advisement and make a decision as to the creditworthiness, trustworthiness, admissibility of these matters. But at this time, we would like to extend to you an opportunity to cross-examine Mr. Locklear.
Thank you, sir. Who's holding the documents at this time? Who has possession of the exhibits?
I do.
May I please hold? Mr. Locklear, my name is Walt Tippett. I'm Mr. Oxendine's lawyer. Just want to run through a few questions.
Yeah.
Will you move that microphone a little closer, Mr. Tippett?
Yes, sir. Sorry.
Please.
Do you have any personal knowledge where Ronnie Oxendine maintained his principal place of residence in October 2020?
No, I don't.
Do you have any personal knowledge?
Hold on just a second. Hold on just a second.
Your Honor, I've got an issue with counsel consulting with his witness on the stand.
Mr. Locklear, return to the podium. Proceed, Mr. Tippett.
Thank you, sir. Mr. Locklear, I believe I was asking, do you have any personal knowledge of where Mr. Oxendine maintained his principal place of business in October 2020?
No, I don't know what I read on those papers.
And we'll come to the papers in a few minutes, but just sitting here in your mind, do you have any personal knowledge of where Mr. Oxendine maintained his principal place of business, residence in November 2020?
No, I don't know what I read on that paper.
Mr. Locklear, do you have any personal knowledge of where Mr. Oxendine has maintained his principal place of business, principal place of residence in December 2020?
No, I don't.
And since that time, sir, as we sit here on October 14th, 2021, do you have any personal knowledge of where he has maintained his principal place of residence?
No, but we all would know if they'd have listed it when he registered to run for tribal chairman, Board of Elections, which should be public knowledge to all of us.
And I understand that you're frustrated with the Board of Elections. Did you happen to reach out to Mr. Oxendine to ask him where he lived during any of these periods?
What Mr. Oxendine told us 2 weeks ago at a rally in Renard, we didn't have to ask him. He gave us a location of where he stayed presently.
Yes, sir, and maybe my question wasn't clear. Have you ever asked Mr. Oxendine where he has lived since October of 2020?
No, I haven't.
So, aside from whatever might be in these documents, are you able to provide any evidence to the court regarding Mr. Oxendine's residence since October 2020.
I haven't asked him nothing, but he hasn't asked me where my residence is either.
I understand. Mr. Locklear, this is the stack of documents that your lawyer just reviewed with you both during your testimony and during a break. Exhibit A looks like a voter search that references that my client was registered to vote and got a driver's license on January 21st, 2021. You remember that one, sir?
I read that, yeah.
Okay. This doesn't say where he lived in October, November, December, or January of 2021, does it?
No.
Similarly, Exhibit B is some sort of Google search of a condominium complex that I don't know how you did it, but you somehow linked it to Mr. Oxendine. It's not obvious to me. I don't see the word Oxendine anywhere on this document. Do you see it anywhere on there?
Well, on the other documents, it's got his address on there. It's the same address that's shown there.
Okay. Well, does Exhibit B tell you where my client lived in October, November, or December of 2020?
Some of them documents has got dates on them.
Oh, sir, but just narrowly, Exhibit B, does this tell you where he lived during that period?
I don't recall that one.
So, and I'm sorry, sir, I don't mean to bully you. I learned a long time ago being mean to witnesses is a bad strategy. So, do you think this provides evidence of where Mr. Oxendine lived since October 2020?
Well, if the sheriff was looking for me and he could pull that up and link it to me, he'd find out where I stay at. So that's what we're doing with him.
Mr. Tippett, could you restate your question? And Mr. Locklear, try to speak clearly your response.
Yes, sir. My question, sir, is can you provide sworn testimony that the document marked as Exhibit B proves where my client lived between October 2020 and now?
No. The answer is no.
Thank you, sir. Exhibit C is a package of Moore County documents.
Right.
That include deeds and a deed of trust. Do these documents show where my client maintained his principal place of residence in October 2020?
Not October 20, but 5/21 of 21 shows where he bought that land there and bought the house.
They certainly indicate he owned property.
He owns property in Moore County according to that.
Sure. Do you know if he actually slept there?
I have no idea where he sleeps at. He sleeps in the yard, as far as I'm concerned.
In fact, there's no house on this property, is there?
Sir?
State that question, Mr. Tippett.
Is there a house on this property?
Thank you.
Is there a home on this property referenced in Exhibit C?
I don't think so.
Okay, so unless he was camping, he wasn't sleeping on the property referenced in Exhibit C, was he?
Okay.
Well, make sure I'm clear. Exhibit C is referring to which property, Mr. Tippett?
Which property are you referring to?
Yes, sir.
The different properties show.
Exhibit C references property in Moore County. There's a deed and there's a deed of trust. But what it doesn't have is anything related to proof that there are improvements on this property. Isn't that correct, sir?
Right.
Are you able to provide sworn testimony that there's a house?
No, I can't swear to that.
Okay. Sir, I'm looking, oh, here's Exhibit D. This is evidence of a company called RNB Holdings.
Right.
Is that correct?
Right.
Does it tell you where my client maintained his principal place of residence at any time?
If I recall correctly, there is an address on that. Might be on the second page there.
Sure. Does this tell you where he lives?
No, it's telling you where his holdings was at,
Where this company is? All right.
and that was Virginia.
Yes, sir, it is. That's where the company was in Virginia.
Right.
Is that right? Mr. Locklear, there was no Exhibit E, so I'm going to go to Exhibit F. And this is a LinkedIn profile, you know, website profile. And do you know what LinkedIn is, sir? Doesn't matter.
Was that where he was giving the resumes out and stuff?
Yes, sir,
Right.
it's related to that. And does this tell you where my client was living since October 2020 to the present time?
I'd have to look at the document again to see if there's even an address on it.
You're welcome to do that, or if you're familiar with your prior views. Does it tell you where he maintained his principal place of residence?
Got an address, Arlington, Virginia.
Yes, sir. And is that his home address?
That's a R&B holding address.
So that's a business address, isn't it?
Sir?
Is that a business address?
Yes, business address.
Thank you. Sir, the next one, that was Exhibit F. Exhibit G is a resume that G is a resume posted November 5th, 2020, and I believe your lawyer argued, I'll call it, that that is outside, beyond the period of concern for this inquiry. Isn't that right? So whatever might be on Exhibit G is not important to what we're doing here today, is it? Yes, sir, absolutely.
Yeah, I remember him talking about this, and it's got a date of November 2020.
Yes, sir, and that's prior to January of 2021. Yeah. Thank you, sir. And then Exhibit H doesn't have any date on it, does it?
Right there in bold letters, Ron Oxendine, 1300 Crystal Drive, Arlington, Virginia.
Yes, sir, it says that. Is there
And it's got a asterisk there with 305, so I'm assuming that was his address.
Yes, sir. Is there a date on that document?
Sir?
Is there a date on that resume?
Yes, there's a date here.
What's the date?
January 25th, 2020.
Okay. Do you know whether that indicates where he lived in October of 2020?
No, because October 2020 would have been 9 or 10 months later.
Right. And so do you contend that that document proves where my client maintained his principal place of residence from October 2020 to the present time?
I can't say that it does.
It does or does not?
It does not show me that.
Okay, it does not show you that. Thank you, sir. And the last one is this picture of this pretty car that doesn't have a date, and I don't know that you know who it owns. You don't contend that that proves where my guy lived October 2020 through the current time, do you?
No, I don't know what he drives.
Okay, thank you. And hopefully my very last question to you would be, and I'll take that back, just don't get misshuffled. The petition alleges in paragraph 6 that the petitioner, and that's you, alleges and says that to the best of his knowledge, information, and belief, formed after reasonable inquiry, the respondent failed to meet the residency requirement of the Lumbee Constitution. That's what this document says, and I'm trying, and this is my question. Have you shared with us everything you know regarding whether or not my guy meets the residency requirements of the Constitution?
Well, from what our search come up with, we can't find established residence that he had prior, for a year prior to filing for tribal chairman.
Yes, sir.
Not local within the tribal bounds. It was all listed back in Virginia.
Are you able to testify here today under oath that he did not live within the tribal boundary from October 2020 to the present day?
I can't testify to that I don't know.
Thank you, sir. No further questions. I appreciate your time today.
Unless the court asks.
Just a minute. Just a minute, Mr. Locklear.
Stay up there, sir.
Ms. Graham, do you have any questions for this witness on behalf of the Elections Board?
On behalf of the election board, Your Honor, we have no interest in residency issue.
Exhibit B. Can you hand him back Exhibit B, Mr. Tippett?
Yes, sir.
I'll give you a minute to look at that, Mr. Locklear. Is it accurate that that shows an address of 1300 Crystal Drive? Is that what you testified to earlier, Crystal Drive, Virginia?
Yes, it does.
And what kind of building is that?
Sir?
What kind of facility or structure is
Looks like a condominium complex.
Is that what your testimony
That's what it says, Crystal Gateway Condominium.
Say that again.
It says on the brochure here, it's Crystal Gateway Condominiums.
And I'm not looking at it, Mr. Locklear. You're saying that it says Crystal Gateway Condominiums. That's a photo, and those words are there.
That's in the photo, right below where the cars is sitting.
So that's on the picture.
Right down here at the bottom, right above where the address is at.
Okay, all right.
I have maybe at least a couple questions for you, Mr. Locklear. Why does this address of 1300 Crystal, whatever it is in Arlington, Virginia, why does this Arlington, Virginia address concern you? Why has that caused you to file this petition?
From what I gather, the complex itself is named Crystal Gateway Condominiums, but now then it lists the address of those condominiums down below.
No, I ask that because you've testified that you don't have any personal knowledge of where Mr. Oxendine lives.
No.
So in light of the fact that you are saying that you don't have any personal knowledge where Mr. Oxendine lives, why does it concern you that you have this address?
Some of the other literature we have has this address listed on the documents. This 1300 Crystal Drive, Arlington, Virginia, is listed on some of the other documents.
Does that suggest something to you?
Yeah, it suggested to me that's where it stayed at. It's more than it's showing in Robeson County or the tribal territories.
Mr. Locklear, is it your impression that this is strictly a resident, just condominiums and no business offices or complex inside? It's just strictly apartments or condominiums?
It's condominiums, looks like to me, and that'd be where it look like to me. That's where his dwelling would be at.
You previously testified as to was it a conversation that you had with Mr. Oxendine at a function in Renner several weeks ago?
I met Mr. Oxendine 2 weeks ago at a campaign rally, and I introduced myself to him and introduced my wife. He introduced himself to me, and he gave me one of his campaign cards, and that's as far as it went. But later on, when we give the candidates time to get up and speak, it come his turn. He got up there, told where he was from, what is involved with, and why he's staying in the location he's in now.
And the reason that you gave previously was that he was here to help take care of a family member?
He said previously he stayed in Virginia. That's what he stated.
And was it your testimony that he indicated that the reason why he was here now was to help take care of a family member?
He was here to take care of his mother-in-law. And from what I understand, I think she deceased some time back, and his wife was staying there right on. Him and his wife was staying there right on.
Mr. Locklear, does that draw any more questions from you, your client?
I'm good, thank you.
I have a question.
You may be seated, Mr.
Sorry.
Oh, I'm sorry, miss.
Exhibit A, the voter registration form, you mentioned that was when he got his North Carolina driver's license.
Ma'am, I'm sorry, I don't understand the thing you were saying.
The North Carolina voters registration document, Exhibit A.
Yes.
You mentioned that at that time, that's when he got his North Carolina driver's license. Was that did he apply for a new driver's license, or was that a North Carolina renewal license? Can you clarify that?
Looked like to me he applied for a North Carolina driver's license. And he's also, he was qualified and went ahead and registered him to vote, and I think he voted under the Democrat Party or whatever. That's what it indicated to me on that.
That's your impression?
That's what I read off from the thing here for you.
So
the document that I had.
Prior to January 2021, he did not have a North Carolina driver's license.
He didn't have them on the vehicle that he was applying for. Now, that don't mean that he ain't got 3 or 4 vehicles, you know.
But you're not testifying as to the registration of a vehicle, are you?
No, I'm not testifying to a registration of a vehicle.
You're talking about a document that you obtained, correct me if I'm wrong. Will you give him Exhibit A, Mr. Tippett?
I will.
If you have that, sir.
Let me look at it again.
Make sure the court is clear, Mr. Locklear, because I wrote down that it was your testimony that Exhibit A was a document from the North Carolina State Board of Elections. That may not have been your words. That showed that Mr. Oxendine...
This document here is from the North Carolina DMV. That's what it lists as here. But it's also a registration form to vote.
Okay, so if you let me finish, please. So the document that you're looking at shows that he registered to vote. That's your understanding?
Yes.
And that your testimony is you've proffered that, which means you've offered that to us.
Yeah.
as saying he registered to vote on January 21st of this year?
January 21st of this year.
And in addition,
Give a registration number.
okay, in addition, you're saying that that's related to a driver's license how?
No, I'm wrong on that. I'm wrong on it. Something else I was looking at earlier. This is the voter registration.
Could I look at the document, please? Could I see this document? I apologize. Where is the other three? Where's the other 2 pages? This document says that it's page 1 of 3. Where are the other 2 pages?
They're not attached. I felt like there was nothing on them that made a point one way or another. I certainly am not hiding anything. Everybody in this room can, of course, Google that in 30 seconds and see the same document if there's some question about its validity.
Justice Brooks, I know you're running this session. I don't have any more questions.
You can return to your seat, Mr. Locklear.
Your Honor, may I ask one follow-up question based on what you asked? Did you obtain these documents yourself?
No, I did not.
Okay.
Could we ensure that all the exhibits, can we give all those to Gary Locklear? Mr. Locklear, if you would look through those right now, and can you confirm that you have all of the exhibits that have been proffered in your hand? Alpha Bravo Charlie, my understanding, Alpha Bravo Charlie.
Minus E.
Yes. Alpha through India minus Echo, is that right? E?
They're all here.
Okay.
Mr. Tippett, Mr. Locklear, Counselor Gary Locklear has argued to the court the purpose for which he intends to use these exhibits and the reason why he is asking that they be admitted to this court and be considered as matters of evidence. As mentioned earlier, you made an initial objection to the introduction of these documents. The court considered that a running motion or running objection to these documents. At this time, you are afforded the opportunity to argue why these documents should not be considered by the court.
Thank you. Thank you, sir. I think perhaps the first point I should make is the witness's final remark, that he did not obtain those documents. He cannot speak to whether they are reliable. And there has been no stipulation as to anything about whether it's reliable. Judge Brooks, I have not misremembered that you may deviate from typical rules of evidence, but it speaks a lot that this witness both did not obtain the documents and had a great deal of difficulty ascertaining what they were. The second thing I would point out is I appreciate the court's patience in my walking through all of them, and I believe he testified that they are all irrelevant to this court's inquiry because they either didn't speak to a substantive issue or they couldn't be linked in time to the relevant period. So none of them check boxes that make them significant to this court's analysis. So while they are, in varying instances, pictures of property that my client may own or descriptions of companies where he may work or have worked, none of them tie together to actually speak to the issue, which was my guy using the territory as his principal place of residence as of January 4th, or maybe 3rd, depending on how you count it, 2020. So I just don't think they're helpful to your analysis. We moved that you exclude them on those bases.
Thank you, Mr. Tippett.
Yes, sir.
Ms. Graham, would you like to be heard on behalf of the Elections Board as it relates to this?
No, Your Honor, we do not wish to be heard in regards to any evidence as to residence.
I certainly do.
Sorry,
I certainly want to be heard after Mr. Tippett's motion.
certainly, go ahead.
Well, I mean, what are we engaging in, a shell game here? I mean, you know, who hide to pee or something? If
Please move the microphone closer, Judge, at this old.
Are we engaging in a shell game where somebody is moving things around and we got to pick the lucky shell in order to win the contest? Absolutely not. That's not what this case ought to be about.
And the purpose at this present moment, Councilor Locklear, is in a moment, this court is going to take a recess. Court will be at ease. We are going to consider whether or not these documents ought to be considered by the court, which ones, if any, if all. The case, as it appears at the present moment, will continue after that. But as it particularly relates to Mr. Tippett's objection that these matters be considered evidence, the court will hear your argument as it relates to that.
As to these exhibits.
As to these exhibits.
Only.
And then the court will come back and we'll go forward? Is that?
Well, we'll figure out.
We will make that determination based on our review of this evidence.
Well, let me first say, I disagree with what Mr. Tippett said. David Locklear never said that all those documents didn't prove anything about his residency here. At the very minimum, the first document, that's petitioner's A, says he registered to get a driver's license on the 21st of January. That's within the year. And at the same time, you get automatic voter registration if you ask for it when you go get your license. That's what that's about. If he had had a previous license, if he'd been previously registered to vote here, they wouldn't put yes in the box. So, I mean, that's proof that he was here January 21st. And that's he registered, he listed Robinson County as his address. I don't know where he got the license. That does not matter. There's no one piece of evidence except what will come out of his mouth that will prove what we have to prove. You can have 10, 20 different pieces of evidence, and none of them alone. For example, none of these other documents proves exactly what Mr. Tippett says. He's right. They don't prove that he was living here within that period of time. How is a person, I'm asking this rhetorically, of course, how's David Locklear going to prove anything when he can't get any information from the Board of Elections? Is he going to go out and hire a private detective to tell this man? Absolutely not. We do the best we can do. He has done the best he can do. He's came to me. We've gathered up some evidence. It seems, obviously it seems at least enough to get past any motion at this point. We get past the motion, then we hear the evidence.
Counselor, I need you to, the phase we're in right now is your opportunity to tell us, in response to Mr. Tippett's request to this court, to exclude these exhibits. If you want to share related to these exhibits, we're not taking arguments on weight and burden and all that other stuff. This is solely about Alpha through India, excluding Echo. That's it. Full stop.
Well, A comes in because it clearly shows what he has done. Driver's license and voting to register within the period of time. And that's proof, that's some proof that he wasn't living here before. I understand, you can question that all you want, or they can, but that's some proof. We don't know if he lives in these condos or not. He's got other addresses in Virginia, but that's the address he lives. If that's an office address, then so be it. He knows, we don't. Again, we don't hire a private detective in Virginia. We do know this. In May, he closed on an $800 and some thousand deed of trust for a house in Southern Pines, and he is filing now to run for tribal chair, or filed back in whenever it was, ended in September, and since then, he's bought entered into a deed of trust for $800 and some thousand. That's some suggestion that he never intended to live here. I mean, y'all are not bound by this time frame of 1 year. I mean, I can go to the beach and stay 18 months. That doesn't mean I moved
Councilor Locklear,
to the beach.
at this point,
I'm sorry.
it appears to the court that you're arguing the merits of the evidence. And at this point, we're only asking about whether or not the evidence should be considered.
A should come in, okay? I will try not to argue those that, other than they tend to suggest what his intent is and his intent was. Anything with a 2021 date, I think is relative. Petitioner's D there's a status date of October 2nd. We didn't put that date in there. The document was printed on May 10th. And that's R&B Holdings, where he is the chief officer. The last update was 10/7. He lists that address in Virginia. Again, we don't know if that he lives there, that's an office. But that's some evidence that his heart's in Virginia. And who's to say, you know, we think his residence was there too. Petitioner's F, we think that comes in because it says he's president of a company in Virginia. That's some suggest. How many people around here are president of a company out of state? I understand. This is the unique case, but it's some evidence that his business interest is in Virginia. It is a lot of evidence of that, and that if his business interest is there, then that's his residence. That's an argument we'd make. I know it. If you want to poke holes in it, so be it. G was posted in November. He's looking for a job, and again, he lists his Arlington address. Does a person go from looking for a position in November to filing for tribal chair in August, I believe? Maybe. There's been a big change of plans if that's the case. H doesn't have a date on it, and I can't comment about where I came from.
Mr. Locklear, will you make those available for the court at this time?
Of course, they are the courts. And they're mixed up right now. Not in alphabetical
order. At this time, the court will be at ease. The justices will recess and examine this evidence.
All rise.
Please be seated. It's 5:21 on Thursday, October 14th. This is reconvening at the Lumbee Tribe Court. Mr. Moore.
The court has discussed the exhibits offered by the petitioner. The court does admit the following exhibits: Exhibit A, Exhibit B, Exhibit C, Exhibit D, Exhibit Exhibit F, not E, Exhibit G, and Exhibit H. The court excludes Exhibit I from consideration. We haven't decided any weight to these exhibits.
Counselor Locklear, at this time, do you have any further evidence that you'd like to present to the court?
We do. We'd like to call the respondent, Ron Oxendine.
Mr. Oxendine, if you approach the place and put your hand on the Bible, sir, and we'll swear you in. You want to affirm, Mr. Oxendine?
That's fine.
Okay. Sir, do you affirm that you would tell the truth, the whole truth, and nothing but the truth to the best of your ability?
I do.
Thank you, sir.
Good afternoon. Good afternoon, Mr. Oxendine.
If you move that closer to your...
Sorry.
Mr. Oxendine, if you feel comfortable, will you remove your mask?
Sure.
I don't want to miss any information.
Mr. Oxendine, you understand, my name is Gary Locklear. I represent David Locklear. You're aware of that.
Yes.
Mr. Oxendine, do you appreciate the fact that we don't question your competency? You're a smart man, and I give you every bit of credit that you're entitled to.
Yes.
Okay. Do you then equally understand that my client is of the opinion that you don't meet the residency requirements, and as a member of the Lumbee tribe, he's entitled to ask that question, and it's ended up being in this forum?
Yes.
Okay, thank you. All right, I got a series of questions, and I want to go through with you. You did live outside the territory for some time. What was your last address before you moved inside to the territory?
1300 Crystal Drive, apartment 305, Arlington, Virginia, 22202.
Is that was that like a condominium or something?
Yes.
Is that maybe what was shown in one of the exhibits? Is that your previous residence?
The outside, yes.
Right, right. Well, thank you. When do you claim, Mr. Oxendine, that you established residence in the territory?
I moved permanently to Robeson County the 26th of September, 2020.
When you say the 26th, you mean that very day?
Yes.
And that's, you signed a lease with your mother-in-law that same day, is that correct?
My wife signed the lease. She's responsible for it, but I was a resident on that lease.
And your name is on it, right?
Yes. I'm a resident living there, but the lease was between my wife and her mother, or my mother-in-law.
Does the lease say that, or does it just? Can you figure that out from just looking at the lease, that it's a lease by your wife and not by you?
Well, I think it has her name at the bottom. It says she's responsible.
Okay. Well, I'll find it. Maybe go back to it. Thank you. Mr. Oxendine, was it it was just a few days before September 26th that there was some action by the LTE board. Is that a fair statement involving your participation on that board?
Yes.
Councilor Locklear, what does that have to do with residency?
If you want to know what I think,
Well, I want to know why you're querying Mr. Oxendine.
because we think there's some connection between what happened then and him establishing a residence in Robinson County, in the territory.
I would just comment, Councilor Locklear, I don't see the relevance of motive behind establishing a residence. Either he establishes a residence that will be considered primary place of residence or not.
Okay. Fair enough. Did you move to help with your mother-in-law, Mr. Oxendine?
Yes.
During her illness?
Yes.
And of course, she eventually passed away.
Yes.
We're aware of that. Just as a comment, I knew your mother-in-law, she's a good woman. So in order for the court to understand this, you moved in on the 26th to help your mother-in-law, you and your wife, her mother, and then your mother-in-law was leasing the house to you while you were there helping her. Is that?
Yes.
Is that the way that works? What moving company did you use to move from Virginia?
I use my own transportation.
What kind of truck or whatever? What kind of transportation?
SUV, my car.
Okay, so you moved what you could in a vehicle of that size. Wouldn't that tend to suggest you left a lot of property up in Virginia?
Yes.
So that we keep, I don't mean to dance with you. I'm just trying to get to the bottom. Do you still own that residence up in Virginia?
Yes.
Your furniture that you left there, to your knowledge, is still there?
I lived there from 2003, January 3rd, 2003, to 25 September 2020.
And so whatever you left on September 25th or 26th, to your knowledge, is still there?
Yes.
Is it vacant otherwise, or anyone renting, leasing, and doing anything like that?
No.
So it's vacant, it's empty?
It's empty.
Gotcha. Since you did register to, you got your North Carolina driver's license on January 21st, didn't you, Mr. Oxendine?
That's correct.
And at the same time, you automatically registered to vote. That's kind of, if they,
Yes,
they ask you and...
The process works together.
Yeah, right. Where are your vehicles registered now? Are in Virginia, North Carolina?
All vehicles are registered at 1837 Hezekiah Road, Maxton, North Carolina.
Okay. Did you saw the picture of the Cadillac that we showed earlier? You recognize that vehicle?
Yes.
Whose vehicle is that?
It's my wife's vehicle.
And what kind of tag, was that a North Carolina tag or?
It is a temporary tag, but 2 days ago I actually received the North Carolina tag where it's registered in the state of North Carolina, and I still need to put it on the vehicle.
But up until that time, it was registered where?
It was registered temporary tag in Virginia because I went to Virginia in August to clear my wife's classroom where she was teaching. And after we completed moving her class and getting all the materials out, we decided to drive over to the Cadillac dealer where we bought a car.
Thank you. Given Are you really paying $500 a month to live in your mother-in-law's house?
That lease is between my wife, or was between my wife and mother-in-law, and she takes care of that. I do not know the answer to that question.
You don't have any canceled checks in with you, do you?
You'd have to talk to my wife.
You might be the smartest man in the room.
Then I imagine your wife takes care of all the utility bills, doesn't she?
Actually, in this particular case, the utility bills are still paid for by my mother-in-law's estate.
Say that again, Mr. Oxendine.
The utility bills for 1837 Hezekiah Road, where we live, are still paid through my mother-in-law's estate.
Let me get this straight. You signed a lease, or your wife did, and your name is on it to pay $500 a month. But those $500 a month is actually coming from some other, your mother-in-law's account or a state account.
No, that's not what I said.
All right, pardon me.
You asked me about the payment of the lease.
Uh-huh.
Okay, the lease included rent. It included electricity.
I'm sorry, you're right. We moved on to utility bills. My fault.
Right, okay.
So the utility bills are being paid out of your deceased mother-in-law's account, estate account. You're not paying them. You don't have a canceled check on you.
I'm sorry, I couldn't hear that last thing.
You don't have a canceled check to show that you've paid any electric, water, whatever else, cable bills at that residence, Hezekiah Road, do you?
No.
Okay.
All covered by the lease.
Are you suggesting that the lease, you were paying, somebody was paying $500 on the lease each month, but the utility bills and all that is covered within the 500?
Yes, Mr. Locklear, if you've ever leased a residence before, which I've done many times in my military and traveling career, normally your electricity, sewer, trash, all of those kinds of things can be covered in the lease.
Can be, not necessarily.
Correct.
I'd ask the court to take the lease as part of the record. I'd ask the court to look at the record as we go forward, look at the leases, and see if your interpretation is the same as Mr. Oxendine's.
Mr. Tippett, Counselor Locklear has asked that the lease appears to have a handwritten date of 26 September 2020. It looks like it's about an 9-page long document, double-sided with my printout. And that was a document, just so you're clear, that your client submitted to the court on his own volition without solicitation. You've seen that document, is that correct, sir?
Yes, Your Honor.
You don't have any concerns about that being admitted into the record, sir?
No, sir, I do not.
And so that's going to be marked as exhibit what, Mr. Oler?
Chief Justice, that'll be Exhibit J.
J.
Yes, sir.
That's been admitted, Counselor Locklear.
Thank you very much. Again, I'd call that to the court's attention as we do go forward. Mr. Oxendine, you moved to Robson County on October 26th. September, pardon me, my mistake. Did you have your mailing address changed to Hezekiah Road or Pembroke P.O. Box or any of that?
Yes.
When?
I started changing immediately once we got there, but it took months to get all of the addresses updated. I don't have any specific dates other than, we started basically as the mail would start coming in.
Is it possible you created your mailbox in the town of Pembroke in the month of March?
I don't think so.
Before or after then?
I'm sorry, state again?
Was it before March or after then if you don't think it was in March?
No, all that process started in the fall of 2020.
But you don't have any record on you today to show us when,
Not on each address.
okay? On any of them then, if you don't have it on each, do you have it on any of them?
Well, I mean, I could bring in documents where it's medical, whether it's bank statements, residences on cars, vehicles, property, personal property. And as the addresses came in, or the information, or I registered for my permanent address, then those documents would be updated.
Did you, do you have a bank account now in Virginia?
I have Navy Federal Credit Union. The headquarters is located in Vienna, Virginia, but Navy Federal Credit Union is worldwide.
Do you have a bank account in Robson County?
I have a bank account with First Bank, and I do use the Pembroke office when I need to go to First Bank.
So, did you open the account in Pembroke, or did you open the account in Moore County?
Yeah, I opened it in, well, again, First Bank is also in the southeastern United States, so it really doesn't matter where you open it. It still applies throughout all counties.
I understand. Just asking you where you opened it at, though.
I think in Pembroke, but I'm not sure.
Do you have a safe deposit box in either of those banks, Pembroke or Virginia?
No.
You own an interest in LTE, and thus you receive some compensation based on your interest. If it's in the form of a check, I would assume, where does it go?
It's in the form of a direct deposit to the Navy Federal Credit Union account.
Okay. That account was certainly opened in Virginia, wasn't it?
I opened that account 40 plus years ago at Quantico, Virginia.
Okay, gotcha. Thank you. Got a passport?
Yes.
What address is on it?
1837 Hezekiah Road.
You got it on you?
No, don't have it on me, but I used it to go to Costa Rica in July.
Okay. Did you notify the Social Security office when you moved?
I don't think so.
How old are you?
67.
Okay. Did you notify the Medicare office when you moved?
Say again, please.
Did you notify the Medicare office
Yes.
when you moved? What office did you notify?
Again, I think the Medicare office, along with, well, my VA office, which I also did for disability, is located in Roanoke, Virginia. I'm not sure exactly where the Medicare office is. However, I did get a letter from them 2 days ago.
You are either a business partner or a manager, or you're otherwise connected with some businesses in Virginia, correct?
Yes.
More than one?
Just one.
Is that RB something Holdings? I've forgotten the name.
R&B Holdings, Inc. is my personal company that was created 1 October of 2012 for the purpose of selling my company, R&B Technologies, Inc.
Okay. Did you make that sale yet?
I sold that company 1 October 2012.
Okay. But
it's like 9 years ago.
Okay. The corporate name, however, is still in existence.
Yes.
And you're still listed as the officer, whatever it is,
Yes.
whatever office you hold. So do you have any other active businesses in Virginia?
Not businesses that's registered in Virginia, but Lumbee Tribe Enterprises has an office in Virginia.
Do you work there currently or have an interest in their work?
I do not work there, but the interest is really out of the headquarters here at 812 Candy Park Road, which is the headquarters of LTE.
Got it. Were you a member of a church in Virginia by chance?
I'm not a member of a church, but we attended Holy Methodist Church in Arlington, Virginia.
And do you have a church here in Robson County?
We attend church at Prospect United Methodist Church.
Okay, thank you.
And others.
When you filed your taxes, that is federal taxes for the last year, what address did you use?
1837 Hezekiah Road,
Okay.
Maxton, North Carolina.
If I could have a moment, Your Honors, please. Questions here, except for this lease, I guess. Help me think of anything. See, he's saying that's paid by somebody else. That's a ruse. Yeah. If Your Honors, please, I'm missing the cover page on the lease. Could I hold a copy of one of yours?
I'm sorry?
Could I have a copy of the lease that you have?
Oh, the lease.
Missing the cover page on mine?
This is Exhibit J. It's been marked for the record. You have any concerns, Mr. Tippett?
No, only that he doesn't have a copy of the lease.
I'm sorry, sir?
Sorry, that was snarky. My only concern is that he doesn't have a copy of the lease.
Mr. Oxendine, that's the lease that your name's on there, isn't it?
Yes, my name is on page 7.
Okay. And can you tell the court where it is in that lease that says all the utility bills are going to be paid out of your mother-in-law's estate? I mean, it may be there. I just must have missed it.
Yeah, let's take a look. Utilities, the landlord shall not pay for any of the utilities and services and will be the responsibility of the tenants. That's page 3.
Well, that's you, isn't it? That's your responsibility then.
Again, if you go to page 8 of this agreement, it says agreement to guarantee this lease. Guarantor's signature is Tina Oxendine.
So you are of the opinion that only Tina Oxendine is responsible for payments?
That's correct.
Not you?
That's correct. If you flip to page 7, it says tenant's signature. That's where my name appears, which means the 3 members of my family, me, my wife, and my daughter, would be the tenants under this lease.
And again, I don't have the first page. Whose names are on the first page?
3 individuals, Ronnie Oxendine, Tina Rose Oxendine, and Jersey J. Locklear.
Well, don't you think that makes you a party to the lease? Not just a tenant, but a party?
Well, yes, but it all comes out of the finances of our family.
Who is Jersey Locklear?
She's my daughter.
What age is she?
15. She's my stepdaughter.
Okay.
But she's my daughter.
I understand. I bet she didn't sign any of those business contracts you entered into, did she?
Mr. Locklear, Counselor Locklear.
Okay, did she sign any other contracts other
Counselor
than this
Locklear.
lease?
With all due respect, we will allow you to continue questioning Mr. Oxendine. As I instructed Mr. Tippett earlier, we are not going to allow this. I'm not going to allow it. I'm not going to allow it, sir. You can query Mr. Oxendine related to his residency based on the claim by your client that he does not meet the constitutional requirements. Please.
Okay. You think of anything? All right, we're good, Your Honor, thank you.
Mr. Tippett.
Thank you, Your Honor. In acknowledgement of the time and the flexibility the court has given regarding process, I would propose to offer my exhibit on this exam, and that would probably be the end of the hearing. You might prefer a different, more formalized process, but that would probably save us all some time.
That's fine, sir.
Thank you. Then if I may approach. I brought copies of everything for everybody.
He has an office, I have a home.
We're going to pause for a second. I'd like to talk to Walt Tippett and Gary Locklear right around here. It's 5:50. Mr. Tippett, I think where we were, sir, that you had handed up some documents, and to the best of my recollection, those documents were also provided to Counselor Locklear, is that correct?
Yes.
Yes, Your Honor. Each of the 4 justices, and I'd like to provide a duplicate copy to the witness.
Yes, sir. So this,
I have a copy as well.
yes, sir.
Your Honor, in that this is my only intended opportunity to offer testimony from my client, I'd ask just a little bit of patience. I promise you, this should be efficient. Mr. Oxendine, are you a Lumbee Indian?
Yes.
Move that a little closer to you, the microphone, Mr. Tippett.
Yes, sir. Where did you grow up?
Maxton, North Carolina, in the Oxendine community.
Where did you attend elementary and secondary schools?
Oxendine Elementary School and Prospect High School.
Did you graduate from Prospect High School?
Yes.
What'd you do after graduation?
Enrolled in the Pembroke State University, or UNCP now, in June of '71.
Had your family lived in the community here for a long time?
All my life.
And was your dad a school teacher here?
Yes, in Prospect High School.
What'd you do after Pembroke State University?
After graduating or finishing my work, college work in December of '73, I joined the Marine Corps and went off to Officers Candidate School at Quantico, Virginia on the 4th of March, 1974.
Okay, did you serve in multiple bases in your career?
Yes, I ended up spending 20 years in the Marine Corps and went to a number of bases and a number of countries.
Okay, and did you retire from the Marine Corps?
Yes.
Did you retire in good standing?
Yes, honorable discharge.
And then what was your final rank?
Major.
Okay. What'd you do after the Marine Corps?
Moved back to Northern Virginia, to Alexandria, Virginia specifically, and became a federal/defense contractor.
And why Alexandria, Virginia, in regard to federal contracting?
Well, number one, I'd spent 8 years of my military career in the Washington, D.C. area, so I was very familiar with that area, knew what the dynamics were like. And again, when you start thinking about federal contracting, Washington, D.C. is the hub of federal contracting for our whole government, including the Department of Defense at the Pentagon.
So if a person is in government contracting, you typically live in that area, is that right?
You can.
Okay. And did you ultimately work for some businesses and then sell your own business?
Yes, I started work for a company called Techmatics. I worked for them for 6 years. As I like to say, I hit a glass ceiling and wanted more responsibility. There were no opportunities in the company. And in 2000, I started my own company, R&B Technologies.
And is that the company that you mentioned earlier that you sold?
Correct.
Okay. And at or about the time that you sold that company, did you help found the company that we've been referring to as LTE?
Yes, in 2010, I came to Homecoming and had the opportunity to have a meeting with Chairman Purnell Sweat and offered him the opportunity to set up a federal contracting firm and create an 8A program for our tribe and go forward. It took almost a year before that went through the Economic Development Committee, the Tribal Council, and eventually the Tribal Council approved going forward on 13 May 2011.
And I ask this only for context so that folks listening to this hearing will understand what briefly is an 8A company and how might it benefit the tribe.
Again, I'll use my own terms. An 8A company is a program, it's a business development program that's ran by the Small Business Administration, and it affords companies that qualify and or individuals that qualify or get certified as an 8A. And that offers the ability to get sole source contracts with the federal government.
A sole source contract, that's a competitive advantage, I presume.
It's not a competitive is when you do compete with other companies for a contract, but sole source allows you to, or allows the government to provide a contract to you directly.
Okay. And so I gather that the effort to work with the tribe to set up LTE was successful.
Yes.
Okay. How long did you work with LTE? Not talking about why you left, just talking about how long were you there?
I started work, if I remember correctly, shortly after 1 October 2012, but I think the date was like the 16th or 18th or something like that of 2012.
And you actually worked for the company, is that correct?
Correct. In a manner of speaking. As an owner, there's ways to look at, I wasn't a W-2 salaried employee, but I was the owner working in the company.
Okay. And when you were working for Lumbee Tribe Enterprises, did you work from here?
My office was actually located in Stafford, Virginia. The headquarters for LTE, again, is here off of Candy Park Road in Pembroke. And I went back and forth, when required, every 2 to 3 weeks, sometimes even on a day's notice, to attend meetings depending on when I needed to be in Pembroke.
Okay. And again, did you work from Stafford because that's where government contracting happens?
Well, I worked in Stafford because that's where I lived. I started out living in Alexandria in '94. After 2 years, I built a home and moved to Stafford in 1997. And then in 2000, I started my own company, R&B Technologies. And then in 2003, I moved back to the condominium complex at 1300 Crystal Drive because we were doing business work with the Missile Defense Agency in the Pentagon and other agencies in Northern Virginia / Washington, D.C.
Okay. There came a time when your employment with LTE ended, is that correct?
Yes.
Okay. Again, I don't want to get into that, but was that somewhat coincidental with when you moved from Arlington to here?
Yes. My last work day was 22 September of 2020 with LTE, although in the paperwork it actually went to 30 September, but my last physical work day was 22 September. So at the end of the board meeting, I went home, called my wife, let her know that I was no longer working with LTE, and we began discussions immediately about moving to North Carolina to take care of our mother-in-law.
And I respect the justice's remarks that motive isn't particularly important, but I just want to give context. Why was your family so eager or willing to pick up stakes and move?
Well, number one, I'm out of a job in Virginia. Number two, my wife's a teacher, and because of COVID, she was doing virtual teaching. My daughter is attending Wakefield High School virtually. So all of us were basically free. My wife could teach from anywhere. My daughter could go to school from anywhere. And I was free, and my mother-in-law was sick. So those are the 4 contributing factors as to why we could pick up and move on a moment's notice or within 3 days. But I will tell you this, my wife had already been talking since February of 2020 about the possibility of moving back herself or with herself and my daughter to take care of my mother-in-law as we saw her health deteriorating. So we had been discussing that for months.
And when you moved, did you intend to return to Virginia?
No.
Did you intend to stay in Maxton?
Yes.
Is that still your current intention?
Yes.
What about employment? You said that one of the reasons you were able to move is that you were no longer employed in a job in Stafford, Virginia. Have you looked for new employment here?
Yes. Once I got here, I started looking at opportunities locally. There's a lot of federal contractors at Fort Bragg, and there's obviously still employment opportunities that, would lead you back to DC. However, I started specifically looking for work in the immediate area.
Okay. Did you find work in the immediate area?
Yes.
And tell us about your job.
On the 8th of December, I went to work for Locklear LLC in Red Springs. I was actually provided an office at 106 Main Street here in Pembroke, where I worked 5 hours a day, basically, so part-time, and I've been there ever since.
And for clarity of the record, that was December of 2020. Is that right?
8 December 2020 was when I started work.
And you've had continued employment there ever since?
Yes, I actually missed a 2 o'clock teleconference that was scheduled today.
I understand, sir. I've handed you a packet of paper. If you could please take a moment to look at tab 6. If you just flip through, then the upper right-hand corner is a lease.
Yes.
Okay. And we've talked about how you're identified as a tenant. Your wife is identified as the financial guarantor. You signed this lease with your mother-in-law, is that correct?
Yes.
Okay. And did she pass?
Yeah, she passed on May 10, 2021.
Okay, and so this lease, to the extent that is anything at all, is now with her estate. Is that correct?
Yeah, what was that term?
Her estate, like it,
yes.
Okay, and in fact, who owns the house now?
Well, unfortunately, my mother-in-law passed without a will, so the 4 siblings, her 4 children, in my opinion, each own 25% of her estate.
It's your understanding that each of you inherited, not each of you, each of your wife's siblings and she inherited a quarter of the residence. Is that right?
Yes.
Okay. Do you all continue to live there today?
Yes.
And it's, you think that you're still paying rent to somebody, or your wife is paying rent to somebody. Is that correct?
Okay, say again, please.
I'm just trying to understand. This lease is with a deceased person.
Correct.
But if somebody's paying rent, it's your wife is doing consistent with this lease.
Yes.
Okay. But she's sort of paying 25% of it to herself. Is that right?
Well, again, I'd have to ask my wife if she's actually making the payments, because that's her responsibility. She has her own checkbook, she has her own income, she has her own resources. It's not something that I worry about.
Sure. Let's talk about where you used to live in Northern Virginia. You still own that place?
Yes.
Okay. Why haven't you sold it?
A couple of years ago, a little organization called Amazon made a decision to put their headquarters #2 in Crystal City, Virginia, which is part of Arlington County. I think the headquarters address is like 1700 Crystal Drive. My condo is located at 1300 Crystal Drive. Amazon is investing over $1 billion in improvements in Crystal City, and real estate is skyrocketing, so I'm not going to sell it because the value of that piece of property is continuing to escalate at phenomenal rates.
Have you returned there?
I've been back since arriving. I've been back 4 times. One of those times was for business, and I obviously stay in the condo when I had to do briefings at Quantico as well as the Pentagon. And then the other 3 trips really are just to go back and check on the property, make sure it's still there. And as a condominium, it is protected or equivalent of gated, so nobody can walk into it. So you just go back and make sure everything is okay.
And if the court were to go visit that property, would it look like you were living there?
Oh yeah, you'd look like you're living there. It would also look like I'm packing up to move because of all the boxes and things that are packed up and ready to
In fact,
ship out.
The lease that we referenced earlier provides that you were provided a home in Maxton that was fully furnished. Isn't that correct?
Correct.
So you didn't really need that stuff in Stafford?
No.
Okay. Why haven't you rented it out?
I don't want the headache of a renter. The property is very big with the State Department renting to foreigners and just other, we even have congressmen, senators, and other successful people that live in the building. And I have previously rented my personal home out in years past. And when you come back in after a renter moves out with all the upgrades, all the improvements, the repainting, the recarpeting, that's not something I want to deal with. So I'm holding that property until such time as I decide to sell it.
Okay.
It is fully paid for.
So there's no mortgage to cover?
No.
But to be clear, since you left on September 25th, 2020, you've been back 4 times.
Yeah, 4 or 5. I go back about every 2 to 3 months.
Okay.
Again, just to check. Again, the last time we were there was in mid-August to clear my wife's classroom. And we were there for 2 days, 3 days.
And the purpose of that visit was really because I think she told me her principal was anxious for her to get her stuff out of the school.
Well, they're getting ready for school, and they had to clear her classroom because they needed it when school started.
Okay. There's been prior mention of property that you own in Moore County. Is it true that you own property in Moore County?
Yes.
Is that a place where you could live?
No.
And why not?
There's no livable building or facility there.
Okay, so it literally does not have a certificate of occupancy.
No.
Okay. And did you move here with intentions of moving to Moore County?
No.
Do you currently have an intention to move to Moore County?
No.
So why'd you buy that thing, Mr. Oxendine?
Investment property, but eventually, when I retire, I'll probably move to that home.
Okay. But sitting here today, you don't have any intention to move there as your principal residence. Is that right?
No. Daughter's in school. She'll be in school, wants to stay at Purnell Sweat, so that's a contributing factor of us not needing to move.
I want to, at risk of irritating the panel, you have a 15-year-old daughter who's in high school at Purnell Sweat, correct? And y'all don't desire to take her out of that school?
Not today.
Well, in all seriousness, you don't have any intention to take her out?
No.
And she doesn't want to leave?
No.
Previously, counsel for the petitioner raised an issue about your driver's license and your voter registration. And I'd like to please direct your attention to tab 7 in my packet of information. Could you please take a look at that and tell how the panel may find this helpful?
Well, in the upper right-hand corner, there's a date, 11 December 2020, and this is an appointment from the DMV to go get license and voter registration. Because of COVID, if you had to deal with DMV, you had to make an appointment. You could not just walk in. And if you check the dates from December 11 to 21 January, that's how long it took for me to get the reservation to actually go to DMV in Lumberton to get license and do the voter registration.
Okay. And so you attempted to register to vote and attempted to get your driver's license in December of 2020. Is that right?
Correct.
And through no fault of your own, you couldn't do it. Is that
Correct.
right? Does that mean that you voted somewhere other than here in 2020?
No.
Did you vote in 2020?
No.
Why not?
I was living here in North Carolina, and my registration to vote was still in Virginia, so I didn't feel like it was appropriate, one, to drive back to Virginia to do a vote for an area that I don't live in and had no intentions of moving back there.
Have you, I believe you testified, just to be clear, have you changed other bills to reflect your Maxton address?
To my knowledge, all bills, anything that magazines, anything that has my previous address has been changed to 1837 Hezekiah Road, Maxton, North Carolina.
Okay. Could you please flip to Exhibit 8 in the package?
Exhibit what?
8, sir.
8?
Yep, it's a Verizon billing reference. Sir, is there a date on this document?
No.
Okay. Does it provide any helpful guidance to the panel?
The only thing it says on here is that the Verizon home address is 1837 Hezekiah Road, Maxton, North Carolina, USA 28364.
Have you reported your address in either Moore County or Virginia as a home address since September 26, 2020?
Okay, ask me that again, please.
Yes, sir. Have you reported any real property address other than Hezekiah Road in Maxton as your home address?
No.
Since September 26, 2020?
No.
I may have stopped one question short. Your mother-in-law passed in May 21, is that correct?
Correct.
Did y'all consider moving away from her home at that time?
No.
Mr. Oxendine, at my request, did you seek to provide other statements as to where your residency is?
What do you mean by statements?
Did you try and obtain affidavits from other people about where they think you live?
Yes.
Okay. And in that 48 hours or so, were you successful in doing so?
Yes, I was able to ask about 10 or 11 people to complete an affidavit, which they did, verifying that they had knowledge that I either lived at 1837 Hezekiah Road, or for those that were out of territory, knew that I was living in North Carolina.
Okay. And are at least 8 of those attached in this packet?
Yes.
Okay. And I'm sure that the panel could take as much time as it cared to review those notarized affidavits, but do they all generally affirm your belief that this has been your primary residence since approximately September 26, 2020?
Yes.
Is it also true that you provided me at least one additional affidavit this morning that I was unable to include in this package due to time?
Yes.
You think you could have gotten more if you had more time?
I could probably get plenty more, yes.
Okay. But generally speaking, do you think that the panel can reasonably rely on these statements as affirmation that your testimony that this has been your primary residence since September of 2020 is true?
Yes.
Mr. Oxendine, I'm coming to the end of my questions. I just want to make sure we hit certain elements, boring lawyer word, that the panel may find necessary in rendering its decision. There is federal common law that talks about factors that may be weighed in considering where a person's domicile is. The factors include the places where you exercise civil and political rights. Where do you exercise civil and political rights?
1837 Hezekiah Road, Maxton, North Carolina.
Where do you pay taxes?
Hezekiah Road, Maxton, North Carolina, number 1837.
Where do you lease real property?
1837 Hezekiah Road, Maxton, North Carolina.
Where are your vehicles, and to the extent they're ever registered, any other personal property that you own? Where are they registered?
1837 Hezekiah Road, Maxton, North Carolina.
I think you own a motorcycle, don't you? Is Tina not supposed to know that?
I'd have to figure out. They're both paid for, so I know I have one, but I can't remember if Tina's is in her name or if it's in our joint name or if it's in my name. But both are registered at 1837 Hezekiah Road,
Sure.
Maxton, North Carolina.
And your drivers and other licenses, are they also that address?
Yes,
And I understand that you weren't successful because of COVID until getting your driver's license until January 21st of 2021, but had it been your intention to have that there in December? Your driver's-
yes. Pre-COVID, you could always walk in the DMV, get in a line, and just say, I'm here to get a license, or, provided you get all the documentation. That's the way it was when I was 16, 17, getting my license. It's the way we got licensed when I was stationed at Cherry Point, North Carolina, during my military career. But under COVID, obviously, because of the pandemic, that was not allowed. So you had to make a reservation.
You maintain bank accounts here, is that correct?
Yes,
Okay. You talked about your Navy Federal Credit Union, which sounds like you joined when you joined the Marines. Is that right?
yes, but I primarily use the branch in Fayetteville, North Carolina. That's the closest Navy Federal Credit Union branch.
Okay. You said you have not joined a church. You attend churches here. Is that right?
Yes,
Clubs. Are you a member of any clubs?
no,
Okay.
no.
And to the extent that you have a place of employment, it's at 106 Main Street in Pembroke, isn't it?
Yes,
So this RNB business, it sounds like it's a shell. Does it exist?
yes, again, I had to create, again, you have to follow me here. My business was RNB Technologies, Inc. In order to sell, I had to convert all the stock and put it in RNB Technologies, LLC. I also had to create RNB Holdings, Inc., because that's what would own the assets of the LLC, and the assets were sold 1 October. The assets being RNB Technologies, LLC, were sold 1 October 2012. RNB Holdings is a viable company. It is still active, and again, I'm using that for consulting purposes.
And the final factor mentioned in this case, which the court cited in its pretrial order, is that where do you maintain a home for your family?
1837 Hezekiah Road, Maxton, North Carolina.
And that includes your wife,
Wife and daughter.
your minor daughter. Okay. Thank you. Just a few more questions. The unusual definition in the Lumbee Election Board rules is that your residency is, quote, that place shall be considered the residence of a person in which that person's habitation is fixed, and to which, whenever that person is absent, that person has the intention of returning, end quote. To the extent that that definition makes sense to you, where is your habitation fixed?
1837 Hezekiah Road, Maxton, North Carolina.
And when you leave that address, or are absent from that address, where do you intend to return?
I left that address this morning to come to Pembroke, to come to the tribe to get ready for our proceedings today. And when I leave, I will return to 1837 Hezekiah Road, Maxton, North Carolina.
I believe your testimony can be fairly characterized that you own 2 investment properties, one in Crystal City, Virginia, and one in Moore County. Whenever you visit those places, do you intend to stay or do you intend to return to some other place?
No, I intend to return back to 1837. There's no place to stay in Moore County. And again, I've already covered the amount of time I go to Virginia and check on the property.
Okay. Changing gears, the requirement in the Lumbee tribe constitution for residency is the candidate must, quote, at the commencement of the term, have maintained his or her principal place of residence in the territory of the tribe for the preceding 1 year. If your candidacy or your campaign were successful, when would your term commence?
If I'm correct, it would be the first Tuesday in 2022, which I think is the 4th of January, 2022.
Okay, and so what I'm trying to determine then is if the critical date is January 3rd, 2020, have you maintained any residence, principal place of residence, anywhere other than Hezekiah Road since January 3rd, 2020?
No,
Is there a period earlier than January 3rd, 2020, when you believe you first established Hezekiah Road as your principal place of residence?
26 September 2020.
When you left Virginia, did you intend to make your permanent home here?
Yes.
Has that intention ever changed?
No.
And just so the record's clear, is it your understanding that Hezekiah Road in Maxton is within the territory?
Yes.
Mr. Oxendine, did the petitioner ever ask you where you lived or when you first lived there?
I'm sorry, I missed the first part. Say again.
Yes, sir. The petitioner, David Locklear, did he ever ask you where you lived?
No.
Did he ever ask you when you first moved down here?
No.
If he had, would you have responded?
Yes.
Is there anything secretive to you personally about any of this?
No.
I respect the elections board must comply with rules. That's not, this is not a quarrel with the election board, but is there anything about this that you think you've attempted to hide?
No, and like I say during my campaigning, everything is going to be done under openness. That's one of my 4 key areas, and I tell people I will answer any question asked, obviously within reason, but I answer any questions.
Sure. And so I think my final question, pending other inquiry by other persons, is, Mr. Oxendine, if you were to win in this campaign, would you have maintained your principal place of residence in the territory of the tribe for the preceding 1 year?
Yes.
No further questions, sir.
Couple follow-ups, maybe?
Yeah, before you do that, this is the last warning.
I'm sorry.
This is the last warning. No one else in this gymnasium speaks derogatory. No more snarky comments. No more derogatory comments to the way their policy is written. Let me finish, Mr. Tippett, or I will, hear me and hear me clearly, I will have you walked out that door. Let me finish. You are within your right to ask any and all the questions you want to, but you're going to do that in a manner that's not disrespectful to the tribal members that serve to the best of their ability in positions of authority and trust. So earlier, your comments about the way their policy was written is not appropriate, and I'm giving you the last warning. I don't want to hear anything in response. You don't have to like it. You can reject it, Mr. Tippett, but that's it. That's Mr. Tippett. That's it. I'll hear now from Counselor Locklear related to his questions to Ron Oxendine.
Mr. Oxendine, you said there's not a building on your Moore County property? There's no structure?
Not something you can stay in.
So, but apparently a house is being built, is that
Yes.
true? So that's why you got the big mortgage or substantial mortgage, because you are building a house.
There is a house being built, yes.
Is there an expected completion date?
I'd love to think so, but it's already been in construction for over a year, and I can't predict when it will be complete.
Okay. Your attorney asked you if you'd paid any taxes at Hezekiah, at the Hezekiah Road address, and your answer was no. I mean, you don't own any property for which to pay, any real estate on Hezekiah Road, do you?
No, my wife does.
So,
Or, you know, I went through that. That's my wife's inherited property at the moment.
right, so, I mean, you don't have any tax receipts because you haven't paid any taxes.
No property taxes on Hezekiah Road, no.
Right, okay,
Only on vehicles that are registered there.
gotcha. That's it, Your Honors. I thought I saw something in here.
There's a series of questions the court is going to ask. We'll start with Mr. Moore, Ms. Locklear, Justice Brooks, and then I'll ask my questions if I have any. Mr. Moore.
Mr. Ron, how are you?
Good.
Currently, is Prospect United Methodist Church, are they in service in or outside?
They're in.
They are inside. What's the pastor's name there?
Sam Wynn, or Reverend Sam Wynn.
How long has your daughter been at Purnell Sweat High School?
I'm sorry.
How long has she been attending Purnell Sweat High School?
She started this year in the fall. Again, as I indicated earlier, she was virtual, attended Wakefield High School in Arlington virtually last year, just like my wife was teaching, same, but she started Purnell this fall.
Is your wife currently teaching?
No.
She's not. The home that you are building in Moore County, you have zero intentions of living, let me rephrase that. If you are a candidate for chairman in the next election, or this election, you have zero intention of living at that home that you're currently constructing, correct?
Correct.
While you would be the chairman if elected.
Yes, and I've reported that many times to many answers to questions at meet and greets, because that is a major concern that has been brought up to me, and I have promised all members of the Lumbee tribe that if I am successful in this election, I will live at 1837 Hezekiah Road, Maxton, North Carolina.
No more questions.
Hi, Mr. Oxendine.
Hi.
When you left Virginia in September of 2020, there were still resumes and LinkedIn accounts that reflected the Virginia title, Arlington, Virginia. Why did those resumes and LinkedIn accounts still reflect Arlington when you were living in North Carolina?
Well, if you want to get attention of contractors, there's thousands in the Washington, D.C. area. And it's always a custom, having been a contractor for 47 years, when you see a resume address that is in another state, it goes to the bottom of the pile. So what a resume does is to get attention for an interview. But there's also other resumes sent out by me that have 1837, because I'm looking at Fort Bragg and looking locally here in the area, and ultimately ended up working with Lock 4.
were telling us about your timeline of your life growing up and your adult life as well, at what point did you decide that you wanted to run for Lumbee Tribal Chairperson?
Over the years, working with the tribe and building the 8A program with the tribe, many people have commented to me that you need to move home so you can run for chairman. So when we did move home in September 2020, a lot of those same people and others indicated that I should run for chairman. However, I did not make any kind of decision. One, because had I not lost my job, I would have never considered it because I would have probably still been in Virginia, potentially. But in December of 2020, again, people started asking me, and I told them that I would think about it over the holidays. We did that. I talked to my wife about the possibility of running for chairman. We continued those discussions until mid-January. And then I called the election board to ask specifically what are the requirements so I could determine whether I was qualified to run as chairman. I received the answers to those questions. They laid out the requirements, and I checked off that I met those requirements. And if I remember correctly, on or about 1 February 21, I made the decision and announced that I was going to run for chairman. That answer your question?
Thank you. No more at this time.
Mr. Justice Brooks.
Mr. Oxendine. Thank you for answering questions. Your home in Virginia, you indicated that no one resides there currently.
Correct.
And you indicated that there are a bunch of boxes laying around. When you moved to North Carolina, what items did you bring with you?
Every piece of clothing that we could fit in the car, and that's primarily it. Obviously, we brought some other personal items, very few, because we're moving into my mother-in-law's home. She didn't have a place to put any furniture or anything, so again, as part of the lease, you have a bed, you got a place to stay, you got closet space, you got bathrooms, you have all the things of a standard fixed house. So we really didn't need to bring any property of significance. So we brought all important things, golf clubs,
It was your testimony.
clothing,
Had you lived there
those kind of
since
things.
2003?
I'm sorry?
Was it your testimony that you had lived there since 2003?
That's correct.
And prior to 2003, where did you live?
The previous address there was actually in Stafford, Virginia, where I lived from 1997 until December 2002. I sold my home and then moved to the condo in Crystal City. And then prior to that, I lived in Alexandria, Virginia for 2 years in an apartment which immediately after retiring, because I didn't know where I wanted to live. I ended up building a home in Stafford. So my last residence in Virginia was in Alexandria, Virginia. And that takes you back to 1994.
So is it your testimony that from 1994 until 2020, you lived in the state of Virginia?
Correct.
And at any point during those years from 94 to 2020, did you ever reside in North Carolina during that time?
Not permanently, no.
What do you mean by not permanently?
Well, as I indicated earlier, starting at 2010, when I started working with the tribe, I would come on weekend or during the week to work, setting up LTE, working with the tribe, working with the tribal council, working with the lawyers to establish LTH and LTE. So I would either stay at the hotel here in town, or I'd stay at my mother's home in the Oxendine community. Sometimes I'd stay in my sister's home. And then once I got married in 2013, I would stay at my mother-in-law's house.
So would you describe those as work-related visits?
Yes.
At any time prior to 2020, did you ever change your driver's license or any of these other addresses on personal or government documents to the state of North Carolina?
Not prior to 26 September 2020, no. Again, my job at LTE was in Virginia. I worked there from 2012 till September 2020, which is 8 years. So I would not have a reason to change addresses for anything other than where I lived in Virginia.
Your wife, you indicated that she's a school teacher?
Yes,
And if I heard you correctly, you indicated that you had traveled to Virginia recently to clean out her classroom?
correct.
And what was the name of that school?
Oak Ridge Elementary. Oak Ridge Elementary.
How long did your wife teach there?
My wife started teaching in the fall of 2003. She taught 2 years at a school in Fairfax County, and then started in 2013, and then she taught school at, can't think of the name of the elementary right now, for 2 years, and then in 2015 got a job at Oak Ridge Elementary School in Arlington, Virginia. And she taught there virtually until she took family medical leave in March of 2020. I'm sorry, March of 2021.
And is she currently employed?
No. Again, she took family medical leave to take care of her mother, and she did not go back to teaching school this fall.
And your contention is that the rent that is paid to your mother-in-law's estate, that rent is in fact paid by your wife?
Yes.
Did you request from her any canceled checks to bring with you today that indicate that?
No. I don't even know if she does. I mean, that's her responsibility. I don't check.
So your testimony is you're not even sure if she makes those rent payments?
No. She's responsible for the rent, and that's her responsibility.
And your daughter, Jersey, has, this school year, she began as a student at Pernod Sweat?
Yes.
Have you been out to meet her teachers?
Yes. Meet the teachers, take her to school in the morning, pick her up in the afternoon. She's currently in driver's education class. I don't think she went today, but normally I go by and pick her up at 6:20 when she gets out of her driver's education class.
Does she play any sports?
No. She is, well, let me back up. She is part of the golf team. She just started again this fall, and she was able to have one match with the team. And good on her, she beat the other two players that she was playing against. But that's the only activity. And then driver's education started, and I think school golf is coming to an end prior to driver's education class being complete.
When did you open your account with First Bank?
That's a good question because I can't think of it off the top of my head.
So
probably, I'm gonna guess, probably in May of 2020. The reason is I had to buy the lot first, then worry about construction on a home.
So you bought that in anticipation of the home being built in Moore County?
Yes. And we bought that before we ever moved to North Carolina.
Now, you indicated that you purchased that home and that it is your intention to use that home as investment property.
Or you could also use it as a vacation weekend. But it is really something that we're building long-term, was the intent for retirement, whenever I retired.
When when you made monetary arrangements to purchase that home, did your lender ask you if you were purchasing that home with the intent of it being your primary place of residence?
I don't think so. Don't remember that.
Generally speaking, are you aware that lending companies treat loans differently for investment property in comparison to residential property or personal residential property?
I don't know about that. They're more interested in the amount where the money's coming from as my portion, but I'm sure it is different. It's like that with any other organization. There's different rules, regulations for different kinds of loans. So I would say yes.
Do you still receive mail at that Virginia address, 1300?
No. I've submitted a forwarding address for all mail, anything that comes.
Okay.
It gets forwarded to 1837 Hezekiah Road, and when it comes in, then I upgrade the mailing address.
So if a prospective employer or a prospective business partner who reviewed your resume online and they attempted to contact you at that address, or is it your testimony that that mail would come to Pembroke?
It would work its way to 1837 Hezekiah Road, yes.
Mr. Oxendine, would you agree that a person's principal place of residence is not simply where they live?
I look at my principal place of residence is where I sleep at night. That's where I live. And I've lived there at 1837 since 26 September 2020.
But you have testified that you have made numerous trips back to Virginia.
I would not call 4 trips numerous.
But when you...
Anyone who has rental property, if I'm not mistaken, under IRS code, you're allowed to go back a number of times in a year to check on that property, if you have rental property, for example.
But in fairness to my question, and in fairness to your response to my question, you responded that you believe your residence is where you sleep at night. If that is your definition of primary or principal place of residence, during these visits, do you not sleep or spend overnights in these return trips to Virginia? And
let me see if I can address that. So you're asking me if I spend, say, 8 nights in Virginia and 360 or 356 or 357 nights at 1837 Hezekiah Road. There's a difference.
With respect to you, Mr. Oxendine, I'm not suggesting that that makes it your residence. The only point of my question is asking you your position on the meaning of a principal place of residence, which would suggest to this court that a person can have multiple residences, but only one principal place of residence. Would you agree with that?
Yes.
And it's your position that what makes a person's principal place of residence, as you just stated, was whether or not you sleep there at night.
It deals with having a lease. It deals with address. It deals where your cars, where your property is, where you sleep at night, as I indicated. Everything that we have is at 1837, except for investment properties in Crystal City and investment properties that are in Moore County. That is what I would call a principal place of residence.
Was it your testimony that you are a Medicare recipient?
Yes.
And was it your testimony that that address in your Medicare account reflects that Hezekiah Road address?
Correct.
And I believe it was your testimony that that was changed several weeks ago?
I don't think I indicated changing Medicare. I'm not exactly sure when we changed Medicare, the address. I can't remember.
I apologize. My recollection was that my recollection was that you testified that you had received a letter from Medicare several weeks ago confirming that the address had been changed. Was that not your testimony?
Well, what I said was I received the letter 2 days ago.
2 days ago?
I think 2 days ago.
And that letter was from Medicare?
Yeah, it was about Medicare, yes.
And what was the purpose of that letter? Was it related to your address change?
Not to my knowledge, no. It was about benefits of Medicare.
You testified that just to show that you are in fact receiving mail at that address from Medicare. Was that the purpose of you saying why you got that letter 2 days ago?
Yes. I received mail at 1837 Hezekiah Road.
Understood. That's all I have at this time, Chief Judge.
Earlier, you were asked by Walt Tippett whether this is not his exact phrase, but he asked you whether you participated in political and civil activity. I think he said something akin to at 1837, and you responded yes.
Okay, say it again, please.
Earlier, to the best of my recollection, you were asked a question by your counsel whether you participated in political and civil activity at 1837 Hezekiah Road. Do you recall that question?
Yes.
Do you recall your answer?
Yes.
What was your answer?
Yes.
What is the political and civil activity you participate in at 1837 Hezekiah Road?
Civil activity is any of the activities that I'm working. It's all about anything that's dealing with personals, what I determine as civic. Any notices of legal issues come to 1837. Court cases, court activities, any of those I classify as civil, and they are addressed at 1837 Hezekiah Road.
Okay, thank you. That's not the address that you being a member of the Prospect Men's Club, the notice goes to, correct?
I don't know that I am a member of the Prospect Men's Club.
Are you a member of any civic club here in Robeson County?
No, not to my knowledge. Only, I'll say this, I am a member of the Lumbee Warriors. I don't know if that classifies as a civic club, but I do attend meetings monthly, every fourth Thursday of every month. But I joined that, I don't know, 5-6 years ago or longer. But when I came to town, I immediately started going to the meetings.
In earlier testimony, you offered to the court, to the best of my recollection, that your wife has a number of siblings. I thought you said 4.
She has 3 siblings. There's a total of 4 kids Miss Emma had.
Sure. And who else lives at 1837 Hezekiah Road other than you, your spouse, and your daughter?
My brother-in-law, Purcell Locklear Jr., lives at 1837 Hezekiah Road.
Is that all, sir?
Yes.
Earlier, you testified that your daughter was enrolled at the local public school in the western part of the county. To the best of my recollection, you indicated at Purnell Sweat. Is that correct?
Correct.
Prior to that, to the best of my recollection, you indicated she was enrolled at a school called Wakefield.
Wakefield High School as a 9th grader.
And where is that school at?
Arlington, Virginia.
And is it your testimony that on January 1st, 2021, your daughter was enrolled at Wakefield High School in Arlington, Virginia?
As a virtual student, yes.
Is Wakefield High School a public school?
Yes.
Can you explain to the court what steps you took as a resident, purported resident of North Carolina, as a resident taxpayer in the state of North Carolina, to request, and to receive permission from the state of Virginia to enroll your child at a public high school in Virginia?
Okay, say that one again. It's a little complicated there. I want to make sure
You
I
testified
understand.
that your daughter was enrolled in public school. I said January 1st, but we can use January 15th or February 1st. You indicated your daughter was enrolled in public school this past spring, because that's presumptuous, Mr. Oxendine, I apologize. You told us she was enrolled here this fall, and I'm presuming that means she was at Wakefield in the spring of 2021. Is that a correct presumption?
Yes, as a virtual student. She actually attended school there virtually. So she attended the 9th grade virtually and never actually went to the school for any activities because of, obviously, the COVID pandemic.
And Wakefield High School is a public school?
Yes.
Paid for and supported by the citizens of the state of Virginia?
Yes.
You've testified that you and your wife have become residents of the state of North Carolina on or about ballpark in September 2020.
Yes.
Is that correct?
Yes.
My question is, what steps did you take to request and receive permission from the state of North Carolina to enroll your child, to continue to allow your child to be enrolled in a public high school in the state of Virginia when you were no longer purportedly, you and your wife were no longer purportedly residents of the state of Virginia?
I don't know that I took any specific steps other than to inform the administration of that school that we were virtual and we were in North Carolina. They were informed of that. Reason being was because we had a computer that she was, well, all students get during the school year, and we had to basically let them know that we were taking that computer out of the state.
Sure.
And they had no problem with that because everybody is virtual.
And Mr. Tippett, at any time, if you think there's a need for you to consult with your client before he answers these questions on the record that may be viewed by others, obviously you can speak up if you think that's to your benefit. Do you know whether it's lawful to enroll your child in public school in the state of Virginia when you and your wife are not residents of the state of Virginia?
No.
No, you don't know, or?
No, I don't know. Because when we moved, we informed the school that we were moving. She informed her principal that she was virtual, and nobody had any questions, nor did they ask us to my knowledge, again, you have to ask her, she's the teacher, fill out any forms or anything like that, where there was a problem or an issue.
Did you notify this notification to the public schools at Wakefield, which I don't know what public school system that's part of? Do you recall whether you notified them that you were no longer remaining a citizen of the state of Virginia, you and your spouse?
No, I'd have to ask my wife if she did or not, but I did not.
Is it true, because I've not asked you, that your daughter was enrolled into public schools at Wakefield High School through on or about the late part of May or the first part of June? Would that be approximately when their school year ended?
Mid-June.
I think you've been asked this, but I need to make sure. Thank Mr. Moore. Are you a member of a church within the tribal territory?
I am not a member as in on the books. I attend church at Prospect United Methodist Church. I go there.
Did you bring with you today, either on your own volition or at the request of your counsel, a copy of any insurance documents showing that you maintain renter's insurance at 1837 Hezekiah Road?
No.
Do you, in fact, have insurance at 1837 Hezekiah Road?
I don't know if I do or not. I don't remember.
So is that yes or no? It's your testimony.
Well, I really don't know. I know there's property insurance, renter's insurance. I'll say no, but I really don't know.
Okay, thank you. Earlier, Justice Brooks solicited from you that, in fact, as clearing up earlier testimony, that in fact, the property that you own that was referenced in the deed from the evidence that was submitted by petitioner is, if I'm correct, you've now told or informed the court, in fact, there's a home being built there, correct?
Yes.
But your testimony, to be clear, is that's not a home where you or your family is going to live at.
No.
It's investment property.
Yes. It'll be a weekend property.
So is it going to be investment property or a second home?
Well, we're not going to rent it out, so I call it investment using my term.
Okay.
But it's like any other residence. As an example, folks in Robinson County go to the beach. I'll go, because I'm a golfer, I'll go to visit that home on the weekend.
Yes, sir. Okay, that makes sense. Thank you. When you went to obtain what we received earlier in our evidence from petitioner, we receipted and allowed to be entered into the record a copy of a deed of trust. Do you recall that?
Yes.
You do acknowledge that that, in fact, is a construction deed of trust related to the construction of a residence on that property.
Correct.
When you went to get the construction loan, can you tell me what address you went to in Moore County, what bank you went to, and who was your banker in Moore County to talk about getting the construction loan?
The first bank in Aberdeen, North Carolina, was the office that I recall going to, and Miss Jenny Webb is the, I don't know, loan officer, I guess, that I actually talked to and exchanged emails with regarding anything related to that loan or anything related to First Bank.
Earlier, to the best of my recollection, you informed when speaking about the Navy Federal Credit Union and First Bank. I thought that your testimony was you utilize the bank here in Pembroke related to First Bank. Can you explain to the court that if 1837 Hezekiah Road is what the Constitution refers to as a principal primary place of residence, which we've informed all parties of, is the equivalent of domicile, why would you not go to a banker near your principal place of residence?
The closest bank to 1837 Hezekiah Road is First Bank in Pembroke. It's only about 5 miles.
Sure, but you told me you went to see Jenny Webb in Aberdeen.
Yes, for the construction loan, yes.
So can you explain to the court that if this is the place where you conduct political and civil activity, why would you not go to a bank closer to your home at 1837 Hezekiah Road?
Well, I have a daughter that lives in Aberdeen, and there are First Banks on the corner at Aberdeen, Southern Pines, and in Pembroke. I can't tell you why I went to one or the other. I could have went to any of them. And Ms. Webb, again, is tied to, if I remember correctly, the Aberdeen office. And she was also referred to me because the home is being built in Southern Pines, as you know, and they referred me to her specifically, and then turns out she works in the Aberdeen office. That's why I didn't come to Pembroke.
When you said, as you know, referring to me, what did you mean by that? I don't know what you mean.
Well, I talked to her via email. She's still actually working under COVID issues, and I haven't met her in her office. So she always talks about going to the Aberdeen office, and that's the only tie I have.
Okay, all right. Earlier you testified, I think in response to Justice Brooks' question about utilizing 1837 as your address on notices to parties and notices to other folks. But in earlier evidence that was submitted to this court, to the best of my recollection, without putting my finger on it, you signed a document with the Virginia Secretary of State related to R&B Holdings, Inc., notifying them that your address was 1300 Crystal Drive, apartment 305, and you signed that document literally 7 days ago.
Yes. Annual registration for a company registered in Virginia at 1300 Crystal Drive.
Sure, but can you square that with your testimony that you were putting 1837 down for all your addresses for important issues like you testified earlier when I asked you about political and civil actions? You said, that's where I get court documents and other things related to that. And to the best of my understanding, because I'm a lawyer, part of the reason you register and fill out documents and put an address on a registration document is so you can be served in case of a civil action. So if you're telling the state of Virginia where you're to be served and where you're to receive official legal correspondence, why would that not be your purported principal place of residence at 1837 Hezekiah Road?
I'd have to go look and pull up the document, but I registered the R&B Holdings as 1300 Crystal Drive because that's where it always is. And if I'm not mistaken, there was a letter of what is your actual residence, and I put 1837 Hezekiah Road on there so that I would get mailed directly because it would, the documents associated with R&B Holdings comes through you might know the answer, a registrar, a company that handles the registration of the company.
Yeah, like a representative.
Correct. They're the representative, and they send those documents to me. And if I'm not mistaken, they're actually located in Delaware or someplace.
Yeah, I don't. It's called like a corporation service.
Correct. CSC.
Yeah. I think you testified earlier that at some point, I assume, but I want to ask, I assume prior to filing for tribal chairman, you testified that you contacted the tribal board of elections. Is that correct?
Yes,
And what I wrote down is you said you spoke with someone at the board of elections related to the process. Is that correct?
what the qualifications were to run for chairman.
And can you recall what specifically you were inquiring about related to qualifications?
Well, I asked for all of them because I didn't have a document that told me what they were at the time. So I just tell me what are the rules so I can check off that I have actually met those requirements.
And in response, that was a phone call?
Yes,
Who did you speak with at the tribal board of elections?
Miss Ruby.
Miss Ruth?
Ruby.
Miss Ruby.
Rubelina?
Did you speak with anyone else at the board of elections related to eligibility to run for tribal chairman?
No,
Not at any point?
not after I had the answers on that phone call, no.
What about before that point?
Nope.
Ruby's it?
Yep.
I'm sorry.
Yes.
Okay. I don't think I have any more questions. I do want to ask you, though, one thing. I'm sorry, I apologize. I got more than one question. You saw the order that this court sent out last night that was signed by Justice Locklear.
Yes.
To the best of your recollection, you saw in paragraph 8, page 2, where this court said, quote, "The court has taken judicial notice that, quote, the determination of domicile is a matter of federal common law," and then we quote a case. I called it the Good Samaritan case. And then it goes on to say, quote, "While we may look to state law for guidance, the question of a person's domicile is a matter of federal common law." Do you recall either reading that or speaking to the extent that you can share? Do you recall being informed of that, either through counsel or through yourself? You recall receiving this information?
And Your Honor, I would object to the question to the extent it may require revealing any communications with counsel.
That's what I was trying to.
Thank you.
That's what I was trying to say. Do you recall learning it somehow?
Yes.
About the court's reference to domicile? Is that
Yes.
correct? Okay. With that being said, you do understand that this court and similar courts are required to consider, as your counsel referenced during a question earlier, what I'll loosely refer to as factors. You recall your counsel referring to factors?
Ask that question again.
To the best of my recollection, Mr. Tippett asked you about factors.
Oh, okay, got it.
And so you recall that?
Yes.
So is it your understanding that this court, during its decision process, will have to consider factors related to your testimony and other evidence that it has received today?
Yes.
Do you understand that in the process of looking at those factors, the court will consider what I'll loosely refer to as the totality of the circumstances, not just a single factor or a single five?
Yes.
Do you have any objections to, do you think this court is misplaced or wrong by considering factors as it relates to making a determination as to your, what is in this order referred to as domicile?
Well, I would hope you would consider all factors.
Yeah, yes, sir.
That's what I assume your job is.
That is. Well, I'm saying, but you acknowledge that we have to look at the totality of the circumstances related to all of the factors that have come through the evidence that we've received.
Yes.
Mr. Moore?
Mr. Oxendine, I'm looking at the construction/permanent loan rider to security instrument. And it says including security agreement. I don't know what page it is, but it's in here. It's number 6. It says occupancy. Do you agree that you signed this as the borrower?
I'm sorry, I agreed to.
Do you agree that you signed this loan as the borrower or one of the borrowers?
No, I'm sure I did.
Okay. So number 6, occupancy, it says, Section 6 of this security instrument is amended and restated to read as follows. Borrower shall occupy, establish, and use this property as borrower's principal residence within 60 days after the permanent mortgage date, and shall continue to occupy the property as borrower's principal residence for at least 1 year after the date of occupancy, unless lender otherwise agrees in writing, which consent shall not be unreasonably withheld, or unless extenuating circumstances exist which are beyond borrower's control.
Yeah, but I will also tell you that when you sit down and you go through with your loan officer and you cover all of the information, they give you the document and it's signed here. And okay, again, as I indicated earlier, their key thing to me is they're worried about the money. That's what they talk about.
Ms. Locklear, you have any more questions?
Questions?
Justice Brooks.
Mr. Oxendine, what value would you say that your home in Virginia is?
Am I required to answer that question?
I mean,
I would.
Question the relevance of it, sir.
No, he doesn't have, if he don't want, I mean, I think he can say, I'm going to decline to answer that question if you want. I mean, Mr. Tippett, I mean, you're his counsel.
Well, I can't instruct him not to answer, but I will.
Well, you can make it, well, do you have an inquiry for the court?
I object to the question. You may overrule the objection if that's what you want to do.
Of course, I'm not going to make you answer that question, Mr. Oxendine, but I will let you know why I'm asking that question. It appears by this loan document that you are building a significantly valuable home.
Yes.
According to the loan document, it's $816,000 and some change. The reason why that's important to me is I would like to know what type of standard of living you are accustomed to as it compares to your current standard that you are living in your mother-in-law's home.
I would say that it's very different. It's a different house. That house that I'm living in now was built in 1999 by my mother-in-law, who, for all practical purposes, in my opinion, has done extremely well for herself and her family. The house at Southern Pines is a totally different home. Just like my mother-in-law did for her family, I do for my family. And I provide a home that is, as you kind of indicate, accustomed to what your living conditions are. And you're reading the number of the value of the house. I mean, if anyone knows what a house looks like with that value, that's what it is. I mean, I don't know how to describe the difference between where I live now compared to that house.
Well, I appreciate you responding that, because that's important for me. As, in fairness to you, we have a responsibility to judge all the factors.
Sure.
You know, we don't expect that every one of these factors will lean your way. We expect that some, if not many of these factors, possibly all of them, will lean your way. But one of the considerations that's important for me is if this is your intent to make this your permanent residence, it's important to me to know if you are in fact maintaining an accustomed lifestyle. That's why I asked that question.
Let me answer your question about 1300 Crystal Drive.
Okay.
Its value is greater than the value you're looking at on that document.
Which document?
You had a deed of trust, or you just quoted a number?
So the value is greater than the value for the new residents in
Yes.
Southern Pines. Would you attribute that to the Amazon reason that you gave earlier about the skyrocketing value?
It has a significant contribution to that increase in value.
You may have answered this previously, but have you filed federal income and state income taxes for
Yes.
the year of 2020?
Yes.
And on those documents, which address did you use?
1837 Hezekiah Road.
That's all I have, Chief Justice.
If there's no additional questions from the court, this time we're going to let Mr. Locklear, based on the questions, and then Mr. Tippett clean it up. Council Locklear, you have any questions?
I did momentarily. If I didn't ask you, I apologize, Mr. Oxendine. The area code on your cell phone is still a Virginia area code, isn't it?
No.
No?
My phone number is area code 910-734-1041. And I've had that phone since 23 September 2020.
Do you have Exhibit 8 in front of you?
Exhibit 8?
Yes.
Let me dig here. Yes.
Well, there's a home phone there with a 703 area code. Can you explain that?
Yes, that number is the number I had with LTE, and that's a Lumbee Tribe Enterprises phone number, and it was registered as my home and cell phone because it's the only number I ever had that I used for personal and LTE business. So it was still on the record. So it should not be there now. It needs to be updated. Again, the area code since 23 September 2020 is 910-734-1041.
Thank you, Mr. Oxendine. That's it from Mr. Tippett. I don't know if you have any follow-ups.
No, sir. I don't think I have any follow-up questions.
We're going to, at this time, during our process, is there any more, Locklear, Brooks? We're required, through our process that we followed earlier, after we received the evidence that you submitted related to your witness, we went out and we decided which of those matters. We're going to do the same thing now. This court's going to stand in recess until I won't give you a time, because last time we went out, it was longer than 15 minutes. We're going to stand in recess.
All rise.
Your Honor, may I ask one question, please? Did we ever mark this as a specific exhibit, or is it good enough standalone?
We did not, because, Mr. Tippett, you didn't introduce anything into the testimony other than at number 6, 7, and 8.
Your Honor, I think there has been a miscommunication with the court. May we?
We can sit back down.
In the interest of fairness, we don't object, Your Honor.
Say again?
In the interest of fairness, we don't object to their documents.
Yeah, I understand. Go ahead, Mr. Tippett.
Thank you, Your Honor. And this may be an example of where.
May I sit down now?
Oh, yeah, absolutely.
Or am I still up?
No, you can sit down as far as I know. I'm not sure what Mr. Tippett.
Thank you, Your Honor. I appreciate your allowing me to clarify this. And this may be an example where the process is unfamiliar to me. This document was provided to the clerk earlier today, and when my client referred to several of the exhibits specifically and then to others non-specifically, more the affidavits, I had thought by providing them all to the court that had satisfied the requirement of tender, If that was insufficient, sir, I'd like to, as is typical in Superior Court, move the entry of the document filed as notice of filing of affidavits and other materials in opposition to the petition into evidence.
That's exactly what you needed to do, in my opinion. What's it going to be marked as, Mr. Matt?
Excuse me. This should be Respondent Exhibit A.
Exhibit what?
Respondent Exhibit A.
A is in alpha?
Alpha, yes, sir.
Mr. Tippett, does that address your concern, sir?
It does. Thank you very much for allowing me to do so, sir.
Yes, sir.
All rise.
Please be seated. It's 7:43 on Thursday, October 14th. This is the reconvening of the Lumbee Tribe Supreme Court in the matter of David Locklear versus Mr. Ron Oxendine, with the interveners, respondents, the Tribal Elections Board. Do you have something, Justice Moore? I think what we're going to do is right before we went out, we talked about we are admitting into the evidence all the entire packet of information submitted by Oxendine. In addition, Mr. Roller, I need to admit into the evidence, because I do not think we've done so previously. And if you would just shout out how we're going to do that. We need to admit into the evidence the transcript and the recording that we heard earlier before our break from the Constitution and Ordinance Committee of the Tribal Council that took place on October 5th. We've not admitted that, have we?
No, sir.
Okay. So all the documents tendered by petitioner have been admitted. All the documents, to the best of my understanding, and by respondent have been admitted. We need to ask, I think I know the answer, but Ms. Graham, do you have anything at this point?
Your Honor, we would have no evidence as it relates to residency.
Yes, ma'am, I understand. So in keeping, and Locklear and Tippett, make sure you agree with this. Counsel Locklear had called David Locklear. Then Counsel Locklear had called Ron Oxendine. To the best of my recollection, Mr. Tippett requested, and this court granted, based on his request, and this is paraphrasing Mr. Tippett, he said, do you want to let's go ahead and let me discuss the things that I have to request to be admitted, which was the packet that we just received in totality. Is that correct, Mr. Tippett?
Yes, Your Honor, and my goal was for his testimony on cross to serve as respondent's evidence.
Yes, sir. Okay, that's how we took it.
Thank you, Your Honor.
So but to close it out, I think sequentially, Counsel Locklear, do you have any more evidence?
No, Your Honor.
Does the respondent, other than Mr. Locklear's, Mr. Oxendine's interaction just a few minutes ago, do you have anything that you want to admit or offer at this time?
No, Your Honor, and just for a point of clarity, did the court in fact admit the lease that was offered by Mr. Locklear? It was just separate from some of his prior exhibits, and if you did, great. I'm just making sure.
We got it. I think we got it two ways.
Super.
I think we got it through your process and the petitioner's process, unless I'm mistaken. Justice Brooks, are we mistaken on that?
I think it was exhibited as Exhibit J, if I recall.
Great. Thank you, Your Honor.
That's from the two primary parties. Justice Brooks, I'm going to turn it over to you to address the other residual things, especially related to the interveners and respondent interveners.
In light of where we're at this juncture in the proceeding, as it relates this dynamic between the petitioner and the respondent, in presenting a case of whether or not Mr. Oxendine meets the residency requirement, does the Elections Board intend to offer any evidence?
No, Your Honor.
At this time, I believe it will be appropriate, Mr. Locklear.
Is there any chance of brief argument? Or?
Yes.
Yes, we're going to get there.
Okay.
At this time, we would invite the parties to offer closings.
Petitioner would request to close if that'd be allowed, rather than open and close.
Mr. Tippett, would you like to make closing argument?
Yes, Your Honor. Would you like me to do that now?
Yes.
Would you like me to do it seated or just stand? Thank you. First, I want to thank the court. This has been a long day for me. I hope it's a long day for you, because this is a lot. but I appreciate your earnestness today and the opportunity to present a case on behalf of my client. I respect the lateness in the day. I want to be as brief as I reasonably can. We worked very, very hard to make your job as easy as we possibly could. We believe that we have covered every factor that we could discern in everything that is even arguably something this court might consider, and I think we smothered it up. Therefore, I'm going to focus on the exact two pieces of evidence that I think you might think are countervailing to the position which we believe we've overwhelmingly covered. The first is whether my client should have also enrolled his stepdaughter into a school here while this 14-year-old freshman in high school was doing remote school in Virginia. Candidly, I don't know that it ever occurred to him because his daughter certainly wasn't not going to school. She was going to school as much as anybody was, but not here. Therefore, I hope to the extent it is a factor at all, his stepdaughter's remaining enrolled where she was to complete that year, I think is not particularly convincing in light of everything else, and especially because she continued to go to school at all. The second piece seems to be a bank document, and this is a place where I genuinely wish I had possession of the exhibit, because my strong suspicion is it's the type of loan that converts from a temporary construction loan to a permanent loan. I can't say that because I didn't have a chance to read it during the break, but within the boilerplate, I trust that, of course, Justice Brooks read it accurately. There was a boilerplate representation about an intention to occupy, with a couple of exceptions. Certainly, my client testified he was not cognizant of that term. Should he have been? Same time, I'm a pretty good lawyer, and I've never read any of the mortgages I've ever had, so here we are, we humans. And then second, I think he's been explicit in many venues on many days that he has every intention to remain living here if he wins his campaign and otherwise. I said the if there just to cover both those eventualities. I think he's been very clear. Apparently he will need to go talk to his mortgage broker or First Bank person if he wins, because I know he's the kind of guy that's going to get that straight, and we're now aware. So Justice Brooks, thank you for bringing that to our attention, but at the same time, as a factor, it is both unpersuasive because it's curable and because he simply didn't have the intent. I'm going to back up just a little bit to the law. The law is clear. It is, as Justice Malcolm suggested, I believe it was Justice Malcolm, maybe it was both Justice Malcolm and Justice Brooks, intention is something that must be weighed. If a person takes a year off to sail around the world, that boat does not become their primary residence. They intend to go home. The evidence is clear. My client intended when he moved here to stay. He intends to stay here. He has covered up the intention aspect of that, and that loan document, which perhaps contains a representation, can't inform the court of his intent because he literally testified he was unaware of it. He may be a bad borrower from First Bank, and we'll have to deal with that, but I don't think that is particularly important to this court's analysis today. Therefore, with all due respect, I believe this case should be relatively clear. I believe we have worked very hard, and he has testified convincingly for almost 2 hours that he meets the Constitution's definition. All other issues aside, we have met the standard referenced by the petitioner and the standard referenced by you in your pretrial order. We have also met all the other standards because, candidly, I didn't know how it was going to come today, and so we have done what we are required to do. We don't have the burden, but I think we met the burden. I think we did what we were required to do, and those two factors that I speculate may be part of your discussion. I just don't think they change the fact that, as my esteemed counsel has referenced, it should be what the people, the Lumbee people, want to do. And as I respect at the beginning of this proceeding, you emphasize the seriousness of this event and how it's ensuring the Lumbee people have a fair right or aren't disenfranchised to vote for whom they want. And I strongly believe that what has happened today in no way would justify denying the Lumbee people the opportunity to choose Mr. Oxendine as their chairman. I think that's where I want to stop. Thank you for your efforts today, and please serve the Lumbee people by allowing them to make an unlimited choice as to who they may select as their next chairman. Thank you very much.
Thank you, Counselor.
Your Honor, it's my understanding that the petitioner did want to close and the intervener does wish to be heard as to remedy. So I want to make sure that's clear.
Okay, you may proceed, Ms. Graham.
The petitioner and the respondent are here essentially because of residency. In the petitioner's petition, essentially in section number 5, if the court would like to look along, the petitioner asked for a judicial ruling on whether the respondent meets the residency requirements set out in Article 8, Section 2B, and set forth that. However, in his remedy, that is not what he asked for. He asked for the court to enter an order that the respondent, Ron Oxendine, is not eligible to be a candidate for tribal chairperson in this election cycle. Now, every time, perhaps before today, the Board of Elections has come to this court as a respondent, as a petitioner, with some type of allegation, either as an appeal before as to some burden, as to what it didn't do or what it should have done. And in every court proceeding, the court found that the court is determined is vested with inherent authority pursuant to Article 9 of the Constitution of the Lumbee Tribe to schedule any hearing or any issue as necessary to ensure constitutional operation of the election board and the associated processes. And until this case, when we're quasi-interveners, there's not been a case that came before the court that in fact asked for a remedy that has been delegated by the Constitution, by tribal ordinance, to the Board of Elections. So at this point in time, we're going to ask the court to find that today's remedy being sought, that the court's hearing it either for the limited purposes to address the residency issue, because it has not been addressed by the Constitution, it's not been addressed by ordinance, because if it doesn't, then it is violating the separation of powers. Because
Say that again, go through that again, start about 30 seconds ago.
Okay. Because if it doesn't limit this process to be this one-time
If what doesn't limit, I'm sorry.
The court, this process that's happening and playing out today, that somehow it was a one-time event because we needed to define residency, because it wasn't defined in the Constitution, or it wasn't defined by tribal ordinance, then this process of coming before the Supreme Court, when the Board of Elections has already certified a candidate, it wasn't an appeal that sent it back to the Board of Elections that said you got it wrong. It was a new certification of the candidate. Brand new evidence, not a review of the evidence, not a review of what took place at the Board of Elections, but a brand new case. Our argument is, if that's the facts that can take place, then the administrative process and the inherent authority and the original jurisdiction process are going to run side by side every single time. And that power for the remedy being sought in the petition to determine, again, if a candidate has satisfied the requirement to be a candidate for tribal chairperson or councilman has been delegated to the Board of Elections. So our concern here is procedure. Our concern here is the policy being established. If we have an administrative policy that certifies candidates, and we're now having a court policy or court case or case law where the remedy is for the court to determine if this candidate is in fact to be certified or not, or meets the qualifications. Not what was asked in Section 5 of the actual petition that I read, but that he is not eligible to be a candidate for tribal chairperson. That's a delegation of authority already been delegated to the Board of Elections. And I would start with the preamble to the Constitution. The tribe adopts this Constitution for the purposes of establishing a tribal government structure. Under Article 3, powers expressed herein are those powers necessary and proper to exercise of those powers expressed herein are delegated to the specific branch of government by the general membership of the Lumbee Tribe of North Carolina. Section 3. The powers delegated to the legislative, executive, and judicial branches, except as expressly provided in this Constitution, shall be separate and distinct, and no branch shall exercise the power delegated herein to another branch, except for the office of vice chairman. And why it's important that it says, except as expressly provided in this Constitution, is Article 10. In Article 10 is where that power is commingled. In Article 10, there shall be an independent tribal elections board of the Lumbee Tribe of North Carolina, which shall have the following authority: to promulgate necessary and appropriate regulations under authority of the Constitution and tribal ordinances governing voter registration, the conduct of all regular and special tribal elections. We then go to the tribal ordinance. Tribal ordinance under Section 3 sets out the promulgation of rules and regulations. Under Section 2, certification of candidates. The remedy that the petitioner seeks in his petition has to deal with the certification of Mr. Ron Oxendine. That didn't come here as an appeal that says Board of Elections got it wrong, fix it, send it back, or undo it, set it aside. It's coming here on original jurisdiction after the administrative process. So now, if Ms. Sheila Begg follows the administrative process and she gets one answer, and Mr. David Locklear follows the constitutional process and comes to the Supreme Court and gets a different answer, then
What do you
who
mean?
has the authority?
What do you mean? So when you reference Sheila Beck,
Well, we handed up the case law for Sheila Beck versus Dewey McNeil.
sure.
So,
That's a matter you agree that did not come to the court.
yes, that's
Nobody
correct.
appealed it to the court.
That's true. It's administrative, so it followed the administrative process.
Sure. But nobody appealed it to us, so this
That's
court
right.
hadn't had the ability to have
As of
that.
yet.
This board hadn't weighed in on whether we think whether what happened there was constitutional.
That's correct. But the argument we're making is there's now two pathways as opposed to the pathway that was designated to the Board of Elections. And that was delegated. And now there appears to be two pathways. This is not an appeal where it says, do it over and you got it wrong. This is a pathway where he says, I'm not going through the Board of Elections in the administrative process. I'm going to choose to go through Supreme Court. Now, that means you have two processes to certify a candidate based on the remedy he's seeking. We're saying that was delegated by the Constitution, by the tribal ordinance, to the Board of Elections. We're asking the court to find this case to be necessary for either the purposes of defining residence or to be heard in a case of first impression, to not create a procedure by which people can avoid the administrative process to certify candidates that has been delegated to the Board of Elections. Because if you do, you are violating the separations of powers, and you are not protecting Article 10, the independent nature of the Tribal Board of Elections, because you've just removed their power to certify the candidates.
If I may, Ms. Graham. Would your client agree that the primary reason that this court has been impaneled today is because the tribal council has failed to act and to write an ordinance that is clear, related to a number of matters involving election oversight and standards, as you heard the video in the recording that we heard earlier?
The Board of Elections is, at this point, not going to throw the tribal council under the bus, because one of our motions to dismiss was because David Locklear didn't use his administrative remedies. Even still, to this day, we allege that he could have appealed the certification of the candidacy of Mr. Ron Oxendine from the Board of Elections and appealed it to the Supreme Court and had reviewed that he had a remedy. So again, does it need to be done by the tribal council? Certainly. We would not argue with the court. It needs to be done.
Sure.
But we're asking the court to consider this case as a case of first impression and not a case of creating policy and procedure to circumvent the administrative remedy that has been delegated to the Board of Elections.
So I appreciate your words. As you know from my tone, this has nothing to do with throwing anybody under the bus. I'm very factual. Different organs of this government have different responsibilities.
Yes.
So my question is, if the tribal council, much like they did 2 years ago when this court ruled, the last 3 hearings we've had, including this one, have dealt with election ordinance-related matters. Correct, Ms. Louise? 2 years ago, this court held a hearing because the tribal council did not sequence the timing of when they notified the people as to where remote, I'll call them remote, where the locations of voting enclosures are going to take place over in Hope County and things like that. And it was during that hearing that the court said, and the reason the election ordinance was updated in looking at it in 2019 is because the court ruled on the matter. The court ruled on a matter that had been disenfranchising the tribal members. It did not position the tribal members to best be positioned to know how they could ensure they were taking part in the most sacred right, in my opinion, that our Constitution gives them, which is the ability to cast a ballot. Same thing happened the most recent hearing, where the tribal council put an artificial barrier to a tribal member's ability to run for tribal council. And this court found that it was arbitrary and capricious to tell tribal members that they could not, if they served on the Board of Elections, that they had to wait for 2 years. This court found there was no substantial governmental interest in forbidding people from serving if they had served honorably on the Board of Elections. And now here we are, as you heard in the tribal council members' own words, which resonated with me. They knew there's problems with the ordinance. And the reason I ask this question in this very public forum is because our tribal members need to know, and everyone needs to hear it, that we're mostly here because our statute, what I'll refer to as our statutory process, which is really codified in ordinance, is severely lacking to inform people like Ron Oxendine, as he testified to, that he called. I mean, think if he had called 9 months ago and someone would have said, hey, here's the hyperlink to the election ordinance. Blam. Right here it tells you it's either residence and has the 3-prong test. You can only have one domicile at a time. You can move to a domicile, but you got to show an intent to remain. If that had all been there, I'm not saying it would have changed things for Mr. Oxendine, but it would inform David Locklear, it would inform Ron Oxendine. And with that being said, at least for me, it is no infringement by this court to strike down, to order, to direct, to modify ordinances of our government and to set forth precedent, as you rightfully couched it, that helps, in my opinion, it actually helps Ms. Louise and Dr. Clark and the other folks. So you and your client's not sitting around in September and August going, the ordinances, you heard it on the recording. Dr. Clark, they quoted him and said, because the Constitution's silent and because the ordinance is silent, these public servants to our tribe are doing their best to make the decisions that they think are right. But we're all human and we make mistakes. Sometimes people get in front, people's rights get trampled upon after somebody comes like us, let's be candid, with 2020, and we come in and say, Dr. Clark, Miss Mitchell, why didn't you do X, Y, Z? And that's not fair to them. So, like I said, I appreciate your words. I appreciate your suggestion to this court is the way I took it, that our response should be measured. But rest assured, if there's a way I can pin it to ensure that future tribal members and candidates like Ron Oxendine and petitioners like David Locklear are clear as to what the rules are, if the tribal council is not going to act, then the U.S. Supreme Court acts in matters of federal matters. The folks up in Raleigh act on matters of state court, and I would suggest this court will act too. And so I appreciate, I don't mean to, I'm not trying to lecture you, and I assume you know that, Ms. Graham, but it's, I've told Ms. Mitchell in the past, the Board of Elections is the frequent flyer. In all the cases I've looked back on, those folks are pulled into more court cases than any other entity, and that's unfair to your organization. And we really, as you know, Ms. Louise, we've talked about this before, from here, we appreciate the work that all you folks do. Thank you, Ms. Green.
Thank you, Judge.
Court pleases. Regarding Ms. Graham's arguments on behalf of the Board of Elections, pardon me, one of the reasons that we are here, that is David Locklear is here, is because of the murkiness, and that's no reflection on the board. I mean, this is tough stuff, as your court has recognized. It's just tough to get it right, and there are lawsuits in every jurisdiction, much less in tribal court, over these same or similar issues. Some of those places have had a little more experience than we have because we're a young government, and for that reason, we're still growing, and we have these things to have to deal with. Let me just move on without dwelling on what Ms. Graham has said. I don't think that should, what she has said shouldn't control in this case. I mean, the obvious issue is between David Locklear and Ron Oxendine. And then that issue boils down to residency, whether he meets the requirements. It's been said before, but it's worth saying again, that one can have many residences, and apparently Mr. Oxendine does. He's a successful person and he's able to do that. But she still can only have one state of domicile. Many residences, but one domicile. And then the issue would become when did that domicile occur? It's undisputed, Mr. Oxendine. By the way, we don't have, David Locklear doesn't have a smoking gun to bring in and say, this is the thing you hang your hat on to make a decision. It never happens that way, never. As has been suggested before, there are many factors, and it is the totality of those factors. And as my mama told me 1,000 times, it's actions that speak louder than words. You know, intentions are sometimes spoken in words. I intend to do this. I intend to do that. But what speaks louder is, what does a person do? And in this instance, we'd argue that Mr. Oxendine, he hasn't abandoned his residence in Virginia. I mean, he hasn't. He told you that. He's given you a reason why he still owns it. Furthermore, during the course of his stay here, and he has every absolute right to build a house in Moore County. But it's another factor, though, that I ask the court to at least consider. What speaks louder, his words that he intends to stay here, or his actions that he still owns a house in Virginia with all the furnishings? Which brings me to the lease that was signed. Signed on September 26th to take effect on October 17th. That's a bit unusual. That's highly unusual. It does say that all the parties agree, including, to their minor daughter, and I won't go there anymore about that. But Mr. Locklear, Mr. Oxendine is, I've already given him credit for being a smart fellow, shrewd businessman. Did you see, hear his answers about that lease? Well, I don't know who pays the bills here. And finally, he says, well, my wife pays them, but, we don't know about checks. It comes out of my mother-in-law's estate. Let's be real for a moment, okay? They moved from Virginia to take care of his mother-in-law, his wife's mother. She enters into a contract with them to charge them rent. They're coming to help her in her sickness and eventually her later death, of course. But yeah, that's not the Indian way. That's not how people operate. It'd be the other way around, probably. She might be paying him to help her. She might have had to pay outside help, but they were willing to come in. But it just goes against the grain of everything. And then to suggest that the lease says the tenants pay all these utilities, there's just something out of sync somewhere here when it makes you wonder whether or not, this is a pretty detailed document. It's not that thick, it's just one of these up here. It's exhibit number 6 in respondents' packet of information. But it's a pretty detailed document, and if they were not going to abide by it, doesn't it make you wonder why they even entered into it? And for what it is worth, it is not notarized. It didn't need to be notarized, but wouldn't that have added some value in terms of the precise date that it was entered into, I argue that it would have. We acknowledge that the burden of proof, because it was not shifted, is on us, and that burden is a preponderance of the evidence. It's a little, you know, but if we can tilt the scales, someone said greater weight of the evidence, same thing in my mind. We think we have offered enough of these individual circumstances, and I haven't finished offering them yet, but this is just where this happened to land in terms of on my list of things to mention in terms of burden of proof. It's on us, and that standard is by a preponderance of the evidence. We think we've met that. I think we'd be willing to say this to the court. It doesn't matter how long Ron Oxendine's been in that house. What matters was that his domicile? Was that his principal place when he moved in? Or during the course of events, like when he went down to get his driver's license in January? I understand you heard what he said about how that happened. Nevertheless, there's a series of events that should make you feel, someone used the word on the tape today, to give you pause. And I argue that many of these things do. He wants to be the tribal chair, but he's building, at least an $800,000 house. My argument is he probably had to put down a bunch of money to be able to borrow the $800,000. Nobody's going to loan you 100% of the value. It makes you wonder why was he hesitant to answer a question about the value of the house he still owns in Virginia? Just again, the totality of the circumstances. The school issue has already been debated, if you will. But I call that to your attention, the fact that his daughter remained in school in Virginia virtually, but while living in North Carolina. That's a factor that would tend to show that he was not domiciled. He was living. He had a residence in North Carolina. Again, his actions speak louder than his words. What he says is more important than what he does. We've done the best we could to bring you a case, and we trust your judgment. We think that we have raised significant issues as to whether or not Ron Oxendine meets the residency requirements. We thought, and still do, that this issue was so important, and we thank you for hearing it. But because the Lumbee people needed to know that you decided this matter, not, in this case, not the Board of Elections, with all due respect to the Board of Elections. So that's why we're here. Again, I'll close. We think we have persuaded you by the greater weight of the evidence. When you add all these things up, I think I forgot something. When you add all these things up, that you will come to the conclusion that, yeah, he lives here now, that's undisputed, but that doesn't count. The fact that he's here now, well, it does count, but I mean, that doesn't give him residency. His residency, the way it reads is, would have had to have started on January 1. He may have been here January 1, but I'd argue to you, he still had a house in Virginia. He was making plans, apparently, to build in Moore County. I don't know the sequence. I think the lot was purchased first and then later a loan to build a house. I've said enough. I appreciate your time, and God bless you all for giving your time to the Lumbee people. Thank you.
Thank you, Counselor.
Chief Justice Malcolm, if I may, you asked for me to mark that transcript for evidence. I have it marked for you. If I may approach, I can bring that to y'all.
You can, we'll get it from you in a moment.
Yes, sir.
Anything else, petitioner?
No.
Anything else, respondent?
No, sir.
Anything else, interveners, respondents?
The court ordered that we produce the login, and we did, so we don't know if it's been made a part of the record or the transcript.
If we can mark that too, thank you very much, Ms. Graham. If you can mark the document that came, I think 5 minutes, we asked that it come in about 8:55 from Ms. Louise. It's my understanding that was delivered, and thank you very much. If we can mark that, what's that going to be marked as?
Yes, sir. We can mark that as Court Exhibit B. I put that in your file this morning. It should already be with the justices, but I'll mark it for you.
So, Mr. Moore, anything? Justice Locklear.
No.
Justice Brooks.
No.
So the way this will proceed, so everybody knows, what we typically do is we go back in the back, and what our practice has been is we lock ourselves in a room and agree not to eat and not to drink a lot of water, but not allow each other to go to the bathroom until we come to a decision. I'm just joking. But typically what we do is we do go in the back and we debate it and discuss it. And I think the last time we went in the back, yeah, we went in the back a long time. I wished I could tell you how long we may be in the back. I mean, there is no requirement that anybody stay here, but our practice is that we go in the back and we discuss it, and then we come back out and make an oral announcement from the bench. And I anticipate, right now, that's what we would do tonight. If there's nothing further, thank you to all the council. Thank you to all the tribal members that have observed this in person today. And thank you for the tribal council members that have joined to listen to this today or 2 weeks from now, because this is a version of your court at work, primarily by a bunch of volunteers. And I think that's very important for the tribal members to know. Certainly everyone sitting up here today, we are not paid for our services, and we knew that going into that, and we went into it eyes wide open. And I know my colleagues here today and my prior colleagues are proud to serve our tribal members to the best of our ability. Thank you very much. We'll stand adjourned.
All rise.
Hi.